Welcome to episode 79 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and you may be wondering why a whole lot of episodes are missing. Today, I'll be reading the Supreme Court's opinion in Trump versus Barbara, which is the Birthright Citizenship case decided June 30th, 2026. So after talking with Will, who, of course, will be joining me for the Opinions of the Hosts section in this episode, we decided the significance of this case and the length of all of the opinions merited getting this episode out as soon as possible, so we're skipping ahead. We won't be making this a common practice, so please don't ask. This case was just kind of exceptional. So after this episode, we'll go back to releasing episodes in the order their respective cases were decided, and we'll re-release this episode after episode 78 so that it shows up in its appropriate place in playlists and whatnot. So with all that said, as usual, we will begin with the syllabus. The question presented is whether the Constitution guarantees citizenship to children born in the United States of parents who are unlawfully or temporarily present in the country. Under the Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. On January 20th, 2025, President Trump issued Executive Order number 14,160 titled Protecting the Meaning and Value of American Citizenship. The order provides that children born in the United States of parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, INA, which uses the same language. Several parents filed suit, some in the name of their children, arguing that the executive order violates the 14th Amendment and the INA. The district court agreed, provisionally certified a nationwide class of children who would be denied citizenship by the order, and preliminarily enjoined the order's enforcement. This court granted certiorari before judgment. Held. Children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. Part A. The Citizenship Clause must be understood in light of its historical context, from the English common law to the widespread condemnation of the court's decision in Dred Scott v. Sandford. Section 1. Under the English common law, children born within the sovereign's domains owed a natural allegiance to the sovereign who protected them at birth, regardless of how momentary and uncertain their presence. Such children were therefore natural-born subjects. The same rule applied to children born of parents subject to expulsion. The rule's exceptions were narrow: children born in lands the sovereign did not control, children born in areas temporarily outside the sovereign's control, and children of foreign ministers by a fiction of extraterritoriality. This common law of citizenship, known as jus soli, or the right of the soil, crossed the Atlantic and prevailed in each and all of the states after American independence. The rule was applied even to the novel situation of quasi-sovereign Indian tribes who maintained dominions of their own, such that the Indians born under those dominions were not citizens, but members of alien sovereign tribes. In a nation of immigrants, jus soli's broad scope took on particular importance, assuring that children of foreigners, including those here on a temporary sojourn, would be American citizens by birth alone. Section 2. In Dred Scott v. Sandford, the court departed from the common law and adopted the view that blood, not soil, determined citizenship. It held that those descended from slaves could not be citizens. The decision was met with shock, and abolitionists swore to undo what the court had done. Section 3. In the midst of the Civil War, Attorney General Edward Bates issued a landmark opinion citing key authorities, including Calvin's case and Kent's commentaries, rejecting the premise that citizenship is ever hereditary, and declaring that every person born in the country is, at the moment of birth, prima facie a citizen, without any reference to race or color. The exceptions were few: the small and admitted class of the natural born composed of the children of foreign ministers and the like. Following the war, Congress sought to turn Bates's opinion into law by enacting the Civil Rights Act of 1866, which made citizens of all persons born in the United States and not subject to any foreign power, excluding Indians not taxed. The act was simply assumed to invoke the common law rule. Part B. What the Civil Rights Act began, the 14th Amendment and its repudiation of Dred Scott would finish. Section 1. The 14th Amendment's Citizenship Clause mirrored the common law's criteria for citizenship, starting with territory, a child must be born in the United States, and ending with sovereign power, a child must be subject to the jurisdiction of the United States. A child born on American soil and subject to American law was made an American citizen. Even the language of the clause is that of the common law, echoing cases and treatises that described the common law rule. And its principal author explained that its language was simply declaratory of the law of the land already. Section 2. The Citizenship Clause's key phrase, subject to the jurisdiction, refers to the power of the United States to govern those within its territory. The scope of that power was settled largely by Schooner Exchange versus McFadden, where Chief Justice Marshall explained that jurisdiction referred to the full and complete power of a nation within its own territories, susceptible of no limitation not imposed by the nation itself. The narrow exceptions to jurisdiction arose where exercising jurisdiction would degrade the dignity of foreign sovereigns, most frequently in the case of foreign ministers. But private individuals who traveled to the United States for business or caprice were amenable to the jurisdiction of the country. Children born in the United States to parents unlawfully or temporarily present here are thus subject to the nation's jurisdiction. Part C. The court's precedent in United States v. Wong Kim Ark confirms this rule. Section 1. For nearly 2 decades after the amendment's ratification, the executive branch viewed the Citizenship Clause as simply an affirmance of the common law, with the limited exception of the children of foreign ministers and others with rights of extraterritoriality. But the end of the Reconstruction era brought uncertainty. Around that time, the State Department began to deny citizenship to those with dual or doubtful allegiance, and several scholars proposed a new international law-based theory of the Citizenship Clause, focused on the parent's status, not the child's. Only if a child's parents were domiciled in the United States was the child internationally subject to the jurisdiction of the United States, as the Citizenship Clause, they said, required. Acknowledging that the common law took a different view, these writers insisted that jus soli had not been made part of the Constitution. Section 2. In Wong Kim Ark, the court held that the 14th Amendment was declaratory of the fundamental rule of citizenship by birth that prevailed at common law, excluding only those recognized as exempt from the jurisdiction of this country, the children of ambassadors and those born in the nations of Indian tribes. All others were citizens at birth, whether born to permanent residents or temporary visitors. The court wrote that the words subject to the jurisdiction thereof must be presumed to have been understood in the same sense as Chief Justice Marshall used them in Schooner Exchange. Under that understanding, aliens who traveled to the United States for business or pleasure received no exemption from the jurisdiction of the country. To the contrary, they were subject to that jurisdiction for as long as they remained here, and any children born to them were American citizens under the 14th Amendment. Part D. Arguments for limiting birthright citizenship to those domiciled in the United States fail. These arguments err in their definition of allegiance, contending that natural allegiance was no longer sufficient for citizenship and that some greater quantum of allegiance based on domicile was required. There is scant evidence for this dramatically revisionist view. Sources from 1776 to 1868 defined allegiance by birth just as the British did, as the tie or duty owed by one who is born within the dominions and under the protection of a particular sovereign. Domicile and national citizenship are distinct concepts. One who establishes a domicile in a new country does not automatically become a citizen thereof, nor does he automatically lose his prior citizenship. The congressional debates over the Civil Rights Act of 1866 and the 14th Amendment confirm the common law rule. Statements embracing the common law were far more frequent and explicit than ambiguous references to temporary sojourners. For a Congress intent on putting the question of citizenship once and forever to rest, A domicile-based qualification would have introduced significant uncertainty. Yet the word domicile appears just twice in the discussion of the relevant provision of the Civil Rights Act, and in only one speech from the Citizenship Clause debates. Sources from after the ratification of the 14th Amendment do not put in doubt the understanding of the Citizenship Clause at the time of and after its ratification. In any case, reenactment history cannot override the text. If Congress intended to limit American citizenship to children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. Attempts to narrow Wong Kim Ark by noting that the court's opinion repeatedly referred to the domicile of Wong's parents fail because the holding's underlying reasoning cannot be squared with a domicile requirement. The court exhaustively canvassed the text and history of the Citizenship Clause and at no point identified any evidence that the ratifiers thought themselves to be imposing a domicile limitation. Chief Justice Roberts delivered the opinion of the court, in which Justices Sotomayor, Kagan, Barrett, and Jackson joined. At issue in this case is whether the Constitution guarantees citizenship to children born of parents unlawfully or temporarily present in the United States. Part 1. The 14th Amendment provides, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, end quote. On January 20th, 2025, President Trump issued Executive Order Number 14,160, entitled Protecting the Meaning and Value of American Citizenship. The order provides that children born of persons unlawfully or temporarily present in the United States are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, INA, which uses the same language. Footnote 1. In full, the executive order declares that the privilege of United States citizenship does not automatically extend to persons born in the United States, 1. when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth, or 2. when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Carrying on. Several parents filed suit, some on their own behalf, others on behalf of and in the name of their children. They argued that the executive order violates the 14th Amendment and the INA. The district court agreed. It provisionally certified a nationwide class of children who would be denied citizenship by the order and preliminarily enjoined the order's enforcement. We granted certiorari before judgment. Part 2. To understand the Citizenship Clause of the 14th Amendment, it is first necessary to understand the context in which it arose, and the opinion of this court, Dred Scott v. Sanford, that it rejected. Section A. The story of citizenship in the United States begins with the English common law. Before the Revolution, the American colonists, like in the British Empire, were considered subjects of the sovereign. That arose not from royal fiat, but from what the common law conceived as the relationship between the sovereign and the people. The king, Blackstone explained, owes those born within the dominions a duty of protection. And in return for that protection, those born within the dominions owe the king a duty of allegiance. Children born with that allegiance were natural-born subjects. As Lord Coke put it in the celebrated Calvin's case, a dual and reciprocal tie thus connects the sovereign and his subjects. Because the sovereign's power, and thus his duty, was limited in various respects, so too was the scope of this rule. He could not demand allegiance from, for he could not protect, those born in lands he did not control. The same held true even in discrete areas within his kingdom that were temporarily outside his control. And the same held true for ambassadors and their families, who were considered by a fiction of extraterritoriality to remain on foreign soil and thus under the allegiance of their home country. In all other respects, however, the sovereign's power and his claim to the people's allegiance was complete. A foreign mother could enter the British Isles, give birth, and leave with her child the very next day, and that child would remain a British subject. Why? Because the child owed an implied allegiance to the sovereign who protected him at his birth, no matter how momentary and uncertain his presence in the king's realms. Footnote 2. The mother, too, owed the British king allegiance for so long a time as she continued in his territory. But her allegiance was just local and temporary, the product of her presence in the British realm. Unlike the lasting allegiance of her natural-born son, the mother's allegiance was extinguished as soon as she left the British domains. Carrying on. The same rule applied to children born in the realm of parents subject to expulsion. For example, children of gypsies, today called Romani or Roma people, born in the realm were natural-born subjects, notwithstanding that British law at the time directed the Roma people to avoid the realm under pain of imprisonment or even death. For those children and all others born in Britain, the rule was the same. With protection came allegiance, and with allegiance came the status of a natural-born subject. This view crossed the Atlantic with the colonists and was adopted with little fanfare after the Revolution, as subjects of the sovereign became citizens of the states. This common law of citizenship, known as jus soli or right of the soil, prevailed in each and all of the states after American independence and continued to emphasize reciprocal allegiance and protection. By the doctrine of natural allegiance, all who were born within the jurisdiction of their state were citizens. When the newly independent Americans confronted a novel situation unknown to England, that of the quasi-sovereign Indian tribes, they turned to the principles of the common law. Did the tribes truly govern their people, or were their people wholly subsumed within the United States? Echoing Coke and Blackstone, Chancellor Kent answered with the common law. We have purchased the greater part of their lands, destroyed their hunting grounds, and gradually abridged their native independence, Kent acknowledged. Even so, he reasoned, the United States has never dealt with those people within our national limits as if they were extinguished sovereignties. They were instead dependent nations and maintained dominions of their own. Indians born under those dominions, he concluded, were not citizens or subjects of the United States, but members of alien and sovereign tribes. Others followed Kent's lead, all while emphasizing that the very few exceptions to the sovereign's power were narrow indeed. In A Nation of Immigrants, An Asylum for Mankind, in Thomas Paine's words, jus soli's broad scope took on particular importance. The young republic attracted tens of thousands of emigres from the Old World, Scotch-Irish, French, German, Welsh, and many more, some of whom hoped to stay only a short time, others of whom hoped never to leave. No matter their intentions, however, they could be assured that their children would be American citizens by birth alone. As Justice Story said, nothing is better settled. The very first American legal treatise agreed, as did the antebellum era's foremost case on the topic, Lynch versus Clark. Lynch reiterated that the common law rule was the law of the land for the children of citizens and foreigners alike, including those foreigners here merely on a temporary sojourn. The promise of American citizenship, Lynch declared, extends to all persons born within the jurisdiction of the United States. Section B. The common law made no distinction on account of race or color, but the slave states did. As the Civil War approached, more and more Southern states sought to deny citizenship to Black Americans and openly rejected the common law to reach that result. It was not the place of a man's birth that made him a citizen, these states said, but the rights and privileges he may be entitled to enjoy. On that view, the prejudice of caste was unconquerable. Not even emancipation could confer citizenship, these states held, because free African Americans still suffered from social and civil degradation based on the taint of blood. With the common law abandoned, almost 500,000 free Black Americans in the South were left little more than strangers. In the odious decision of Dred Scott v. Sanford, this court imposed the Southern states' beliefs onto the nation. Chief Justice Taney, writing for the court, concluded that the words people of the United States and citizens had an unexpressed and atextual racial component, one that excluded all those descended from slaves. Even if Massachusetts or Connecticut chose to grant citizenship to the freedmen, they still could not participate in the national affairs. They were born in the country, Chief Justice Taney acknowledged, and thus did owe allegiance to the government, the precise criteria for citizenship at the common law. But they were not included and were not intended to be included under the word citizens in the Constitution. For them, blood, not soil, was made the rule. Dred Scott was met with shock. Ever since the Declaration of Independence, Justice Curtis wrote, the received general doctrine has been, in conformity with the common law, that all free persons born within a state are citizens of the United States. Justice McLean said much the same. Being born under our Constitution and laws, he explained, makes him a citizen. Northern newspapers condemned Dred Scott as a wicked and false judgment, an atrocious doctrine, a deliberate iniquity, and a willful perversion. The decision was, in Lincoln's famous words, an astonisher in legal history. Abolitionists swore to undo what the court had done. By birth, Frederick Douglass insisted, we are American citizens. The Constitution knows all the human inhabitants of this country as the people, he explained, no matter their color, class, or clime. All I ask of the American people is that they live up to the Constitution, adopt its principles, imbibe its spirit, and enforce its provisions. When this is done, Douglass predicted, the glorious birthright of our common humanity will once again become the inheritance of all the inhabitants of this highly favored country. Section C. The court had overruled the common law, but the people eventually would overrule the court. It took more than a decade and the addition of names such as Antietam, Gettysburg, and Chancellorsville to our national canon, but Douglass's vision of our common humanity would be fulfilled. The Reconstruction Congress did not start from scratch. In the midst of the Civil War, President Lincoln's Attorney General, Edward Bates, had issued a landmark opinion that sought to displace Dred Scott in favor of the common law. Citing the key authorities, among them Calvin's case and Kent's commentaries, Bates rejected the premise that citizenship is ever hereditary. Every person born in the country, he wrote, is at the moment of birth prima facie a citizen without any reference to race or color or any other accidental circumstances. He acknowledged that there were some limits, hence prima facie, not conclusive. But those exceptions were few, simply the small and admitted class of the natural born composed of the children of foreign ministers and the like. To Bates, it was soil, not blood, that furnishes the rule both of duty and of right. A year after General Lee's surrender at Appomattox, Congress sought to turn Bates' opinion into law. The result was the Civil Rights Act of 1866. The act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby citizens of the United States. To the Reconstruction Congress, the act was simply assumed to invoke the common law rule, as Bates had in his ablest and most exhaustive opinion, and as the New York Court of Chancery had in the great case of Lynch v. Clark. Indeed, the bill's sponsor, Senator Lyman Trumbull, enthusiastically agreed with the bill's critics that it would make citizens of the children of Chinese and Gypsies born in this country. Even the infant child of a foreigner born in this land is a citizen under this bill, Trumbull declared. The specter of Dred Scott, however, loomed over Congress's efforts. Opponents of the act contended that Congress could not grant such expansive citizenship and set aside this court's precedent by statute alone. To quiet those concerns and to permanently enshrine the common law in the Constitution, Congress turned to the 14th Amendment. Part 3, Section A. What the Civil Rights Act began, the 14th Amendment would finish. Like the Act, the 14th Amendment was intended to repudiate Dred Scott. This time, however, the goal was even grander, to put the great question of citizenship beyond the legislative power altogether, to settle the issue once and for all. The 14th Amendment achieved its aim. The Citizenship Clause mirrored the common law's criteria for citizenship. The clause starts, like the common law, with territory. A child must be born in the United States, not elsewhere, even to American parents. And the clause ends, again, like the common law, with sovereign power. A child must be subject to the jurisdiction of the United States, unlike, say, the families of foreign ministers. A child born on American soil and subject to American law was made an American citizen. Even the language of the clause is that of the common law. Lynch held that American citizenship extended to all persons born within the jurisdiction of the United States. So did Chancellor Kent. So did the first legal treatise on the rights of free black Americans. And so did the famed antebellum lawyer Horace Binney. Little wonder, then, that the Citizenship Clause's principal author would explain that its language was simply declaratory of the law of the land already. That law was clear. Any child who was born under the protection of the United States, that is, any child for whom no extraterritorial fiction applied, was made a citizen, for he owed a natural allegiance and thus obedience to the nation. Section B. Even putting the common law to one side, the Citizenship Clause's key phrase, subject to the jurisdiction, requires the same result. The word jurisdiction was hardly unknown to the drafters and ratifiers of the 14th Amendment. Congress chose to use an established legal term, and the clause must be interpreted in that light. In 1868, as today, jurisdiction in the context of a sovereign refers to the power of governing or legislating. To be subject to the jurisdiction of the United States, then, is to live under its domain, a meaning reinforced by the clause's territorial focus on those born in the United States. The Citizenship Clause uses jurisdiction in its ordinary sense, referring to the power of the United States to govern those within its territory. The scope of that power was well settled in 1868, largely by the celebrated case of Schooner Exchange versus McFadden. Expounding on general principles, Chief Justice Marshall explained that jurisdiction referred to the full and complete power of a nation within its own territories. That absolute power was susceptible of no limitation not imposed by the nation itself. All sovereigns, however, were understood to have impliedly waived their jurisdiction in certain peculiar circumstances, in essence, where exercising jurisdiction would degrade the dignity of foreign sovereigns. In the context of jus soli, those particular circumstances arose most frequently in the case of foreign ministers. Every sovereign would hazard its own dignity, after all, if its officials abroad were made to owe temporary and local allegiance to a foreign prince. The limits of that exception were carefully defined. Still within the United States' power were the private individuals of a foreign nation who had spread themselves through our territory as business or caprice may direct. It would be obviously inconvenient and dangerous to society, and would subject the laws to continual infraction, Chief Justice Marshall explained, if such individuals or merchants were not amenable to the jurisdiction of the country. Nor can the foreign sovereign have any motive for wishing such exemption, he continued, with respect to its sojourning subjects who were not employed by the sovereign or engaged in national pursuits. Just like jus soli, a sovereign's jurisdiction made no exception for those only temporarily present within the sovereign's territory. Instead, nearly everyone within the territorial boundaries of the United States was amenable to the nation's jurisdiction. The ordinary legal meaning of the text of the clause thus neatly captures the common law rule with its broad reach and narrow exceptions. The same groups included and excluded by jus soli were included and excluded by the conventional understanding of jurisdiction. Excluded by both were the children of foreign ministers and members of 19th century Indian tribes over whom the United States had ceded a part of its territorial jurisdiction to preserve its relationship with a foreign sovereign or quasi-sovereign. No such inter-sovereign concerns apply to children born of parents unlawfully or temporarily present in the United States. No foreign sovereign would have any motive for wishing them outside this nation's authority. Those children are thus subject to the jurisdiction of the United States. They satisfy both elements of the Citizenship Clause. They are born in the United States and subject to the jurisdiction thereof. Under the Constitution, they are citizens at birth. Part 4. Our precedent, the seminal case of United States versus Wong Kim Ark, confirms this rule. Section A. For nearly 2 decades after the 14th Amendment's ratification, the executive branch viewed the Citizenship Clause as simply an affirmance of the common law of England and of this country. Under that view, the status of citizenship was fixed by the place of nativity, irrespective of parentage, with the limited exception of the children of foreign ministers and of other persons who may be within our territory with rights of extraterritoriality. In 1872, for instance, Attorney General George Williams was called upon to determine the citizenship of a child born to Austrian parents only temporarily residing in New York City. Citing the Citizenship Clause and Bates's 1862 opinion, Williams explained that a person born in this country, though of alien parents who have never been naturalized, is, under our law, deemed a citizen of the United States by reason of the place of his birth. Thus the child is a native of this country, Williams concluded, and as such was originally clothed with American nationality. Secretary of State Hamilton Fish agreed. So did federal courts. Like the executive branch, they saw the clause as merely declaratory of the rule of the common law. As the era of Reconstruction faded, however, so too did the promise of birthright citizenship. Uncertainty came with the first Chinese Exclusion Act of 1882, and the election of President Cleveland, the first Democrat to hold the office since the Civil War. It was around this time that the State Department began to deny citizenship to those with dual or doubtful allegiance, and it was around this time that several scholars proposed a new theory of the clause, one based on international law. This new theory focused on the parent's status, not the child's. It was only if a child's parents were domiciled in the United States, they argued, that the child was internationally subject to the jurisdiction of the United States, as the Citizenship Clause, they said, required. These writers acknowledged that the common law took a different view, and acknowledged that the language of the 14th Amendment was very broad. But they insisted that jus soli had been universally rejected by other nations and had not been made part of the Constitution. Section B. In Wong Kim Ark, this court rejected that view, concluding that no rule of international law had qualified the ancient rule of citizenship by birth within the Dominion. At issue was the citizenship of Wong Kim Ark, born in San Francisco to Chinese parents. In Wong's telling, the case was not close. There can be no just doubt, he argued, that the amendment was intended to be based upon the doctrine derived from the common law, that the character of a natural-born citizen is incidental to birth only. The government disagreed. It admitted that the opinions of the attorneys general, the decisions of the federal and state courts, and, up to 1885, the rulings of the State Department all concurred in the view that birth in the United States conferred citizenship based on the common law doctrine of allegiance and the authority of the decision of Chancellor Sanford in Lynch v. Clark. But the executive no longer endorsed that view. The common law doctrine of England, it argued, had in fact never been the doctrine of the United States and was not made law by virtue of the Citizenship Clause. In an opinion by Justice Gray, the court rejected the government's position. Justice Gray explained that the 14th Amendment was merely declaratory of the fundamental rule of citizenship by birth that prevailed at common law. That same rule, he wrote, was in force in all the English colonies and continued to prevail under the Constitution. And its contours were clear. It excluded those recognized as exempt from the jurisdiction of this country, the children of ambassadors and other representatives of foreign sovereigns, as well as those born in the alien nations of Indian tribes. All others were citizens at birth, whether born to permanent residents or temporary visitors. Indeed, Justice Gray noted, no one had even contested this conclusion for more than 50 years after the adoption of the Constitution, until the matter was elaborately argued before the New York Court of Chancery in Lynch v. Clark. And there the question was decided upon full consideration by Vice Chancellor Sanford in favor of their citizenship. The same doctrine was repeatedly affirmed in the executive departments, Justice Gray wrote, not to mention by Kent and Binney, each of whom affirmed that the child of an alien, if born in the country, is as much a citizen as the natural-born child of a citizen. In adopting the common law, Justice Gray explained, the Citizenship Clause adopted the same rule. Justice Gray then turned to Schooner Exchange to confirm what the common law made clear. The words, subject to the jurisdiction thereof, he wrote, must be presumed to have been understood and intended by the Congress in the same sense in which the like words had been used by Chief Justice Marshall in the well-known case of the Exchange. On that understanding, aliens who traveled to the United States for business or pleasure received no exemption from the jurisdiction of the country. To the contrary, they were subject to that jurisdiction for as long as they remained here, and any children born to them were American citizens under the 14th Amendment. What the court held in Wong Kim Ark was simple. The Citizenship Clause incorporated the common law and granted citizenship to nearly all children born in the United States. Not surprisingly, then, in the 128 years since, we have repeatedly understood the rule of Wong Kim Ark to guarantee citizenship to all children born in the United States and subject to its power. We see no reason to depart from that view today. Part 5. The government and the principal dissent share many of our premises. They agree that the Citizenship Clause was intended to incorporate the background principles of the common law. They agree that, under the common law, citizenship turns on allegiance. And they agree that Dred Scott departed from that traditional allegiance-based view of citizenship, a departure that Congress repudiated in the clause. Where the government and the principal dissent err is with their definition of allegiance. They concede that Calvin's case and Blackstone state the rule that prevailed before the Declaration of Independence, that a natural allegiance arises for all children who are born here under the protection of the sovereign. Yet according to the government and the principal dissent, the United States' conception of allegiance at some unspecified point in time broke from Great Britain's. Natural allegiance, they contend, was no longer sufficient for citizenship. Some greater quantum of allegiance was required. How much? The government offers a smorgasbord of formulations: primary allegiance, sufficient allegiance, full allegiance, requisite allegiance. What all these formulations supposedly share is that they turn on domicile, the place of one's permanent home. At some point before the ratification of the 14th Amendment, the argument goes, it became deeply rooted in this country that domicile is the key concept that creates allegiance. The trouble is that there is scant evidence for this dramatically revisionist view. Certainly no one said that such a change had occurred. Indeed, even as the antebellum Americans hotly debated whether the Declaration of Independence had abrogated one aspect of the British common law, that natural allegiance was indefeasible no matter a person's desire to expatriate, all agreed that such allegiance was owed in the first place. The only evidence the government and the principal dissent can muster to show that some alternative primary conception of allegiance displaced the common law is a funeral oration for President Lincoln. Ahistorical modifiers aside, the government and the dissent identify no source that defined allegiance at birth as being based on domicile in the period from 1776 to 1868. Footnote 3. The principal dissent comes closest with the decision of New York's Intermediate Appellate Court in Ludlam v. Ludlam. When New York's highest court heard that case, however, it did not follow the lower court's reasoning. It relied instead on Lynch v. Clark. Carrying on. Sources from that period instead defined allegiance by birth just as the British did, as the tie or duty owed by one who is born within the dominions and under the protection of a particular sovereign. Of course, some wished to change the rule. But even those who wished to limit just solely did not deny that children born of temporary visitors owed natural allegiance to the United States. They instead thought that domicile might serve as a reasonable qualification to the common law rule, namely that citizenship derives solely from the natural allegiance owed to the government of the territory of a man's birth. The principal dissent, but not the government, at times seems to directly equate domicile and national citizenship. This is wrong. It is, in fact, a general axiom of international law that there may be domicile where there is no nationality and nationality where there is no domicile. After all, one who establishes a domicile in a new country does not automatically become a citizen thereof. He has to be naturalized, nor does he automatically lose his prior citizenship. He has to expatriate. Thus, the principal dissent ultimately acknowledges that domicile alone was insufficient to make someone formally a citizen. Of course, domicile was relevant to naturalization and expatriation, but that by no means suggests it was a prerequisite to national citizenship at birth. The principal dissent's reliance on cases concerning changes to a person's state citizenship is thus misplaced, and the government's remaining support for the idea that a domicile qualification to birthright citizenship was widely accepted in the United States before the Civil War consists of a single state court case about citizenship in the Republic of Texas, a proposed but never adopted model code for the state of New York, and another treatise that discussed the subject only in terms of the principles of natural reason, which it expressly distinguished from the common law. The congressional debates over the Civil Rights Act of 1866 and the 14th Amendment confirm our view. The principal dissent and the government lean heavily on a handful of ambiguous floor statements referencing temporary sojourners and foreigners. Far more frequent and explicit, however, were statements embracing the common law. And the debates make clear that no member of Congress seriously grappled with a domicile-based carve-out to the fixed, certain, and intelligible rule of the common law. For a Congress intent on putting the question of citizenship once and forever to rest, a domicile-based qualification would have introduced significant uncertainty. Unlike the easy-to-apply common law, it would be difficult, if not impossible, to lay down any general rule of domicile-based citizenship, as domicile often depends on the circumstances of each case, the combinations of which are infinite. If Congress intended to hinge citizenship on each individual's domicile, a question that is sometimes a matter of great difficulty to decide, it is reasonable to expect that there would have been at least some discussion of the topic. Yet the word domicile appears just twice in the discussion of the relevant provision of the Civil Rights Act, and it appears in only one speech from the Citizenship Clause debates as part of an explanation why state citizenship is distinct from national citizenship under the Constitution. Perhaps recognizing the absence of ratification-era support for a domicile-based rule of national citizenship, the government and principal dissent both emphasize sources from after the ratification of the 14th Amendment. They turn to the same international law treatises that underpinned the government's attempt to limit birthright citizenship in the 1880s. Footnote 4. The principal dissent suggests that any scholar who wanted to prevent the children of Chinese immigrants from being citizens would not have proposed a domicile requirement because many Chinese immigrants were already domiciled here. But several of the scholars upon which the dissent relies, most prominently Francis Wharton, did not agree. In their view, Chinese children born in America were not citizens because the Chinese as a population could not be domiciled in the United States. Indeed, the government made the same argument in United States versus Wong Kim Ark. Carrying on. This fundamentally revisionist scholarship and the post-1884 executive branch actions that relied upon it do not put in doubt the understanding of the Citizenship Clause at the time of and after its ratification. As Senator Trumbull explained in 1871, the Citizenship Clause recognized that every person born within the jurisdiction of the nation was a citizen of the United States, as had been true under the common law of this country as well as of England. In any case, post-enactment history cannot override the text. If Congress intended to limit American citizenship to the children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. For a simple reason, they did not matter. And while the clause does ensure state citizenship attaches for U.S. citizens in the state wherein they reside, the explicit invocation of residence for state citizenship only highlights its absence from the criteria for U.S. citizenship. When the principal dissent does grapple with the operative legal text subject to the jurisdiction of the United States, it has little to say. It argues only that a person is subject to the jurisdiction of the government of his domicile. But that is not the question. The question is whether a person is subject to the jurisdiction of the government of the country in which he is physically present, even if he is only there temporarily. He is, unless he falls under one of the familiar exceptions, such as for ambassadors. For the reasons given by Chief Justice Marshall in Schooner Exchange, the United States exercises full and complete power, its absolute and complete jurisdiction, over temporary visitors. Footnote 5. The government briefly contends that Elk v. Wilkins adopted its unconventional understanding of jurisdiction. That is mistaken. Elk addressed the citizenship of a child born a member of one of the Indian tribes, and Elk hewed to the very same common law rule announced by Chancellor Kent in 1823. Indeed, it even cited him. The court reasoned that tribal members were no more born in the United States and subject to the jurisdiction thereof than children born within the United States of ambassadors or other public ministers of foreign nations. In both contexts, after all, the United States had voluntarily ceded part of its territorial jurisdiction to another sovereign or quasi-sovereign. As the court later confirmed, ELK concerned only members of Indian tribes within the United States. Beyond that unique inter-sovereign relationship, the court's decision had no tendency to deny citizenship to children born in the United States of foreign parents, not in the diplomatic service of a foreign country. Carrying on. To avoid these problems, the principal dissent spends much of its time on the text of the Civil Rights Act. The Civil Rights Act made citizens of all persons born in the United States and not subject to any foreign power. The principal dissent contends that a person is not subject to any foreign power if and only if he is domiciled in the United States, for it is then and only then that his home nation is forbidden from regulating his conduct. Justice Alito contends that a person is not subject to any foreign power if and only if no other country would automatically make him a national whether he is domiciled here or not. Neither theory works. As to the principal dissent, it is simply not true that domicile in a new nation severs one's ties to the old one. If the test truly is whether a person is amenable to the laws of two governments at once, then it is a test that every child born to a foreign parent fails, a result that even the principal dissent cannot stomach. Justice Alito seems to recognize this bind, so he would create an ad hoc exception for those whose parents have done everything within their power to become Americans. He does not explain how that exception can be squared with his view of the text, which, to repeat, is that anyone automatically made a national of his parents' native country was not entitled to citizenship under the Civil Rights Act. Footnote 6. Justice Kavanaugh proposes a similar ad hoc exception to his own interpretation of the Citizenship Clause. Under his rule, the clause generally does not promise citizenship to children whose parents are not U.S. citizens. Yet it must grant citizenship under the facts and circumstances presented in Wong Kim Ark, even though Wong's parents were not U.S. citizens. Like the exception proposed by Justice Alito, Justice Kavanaugh's exception is at war with his supposedly unifying principle of the clause. Carrying on. In our estimation, the Act raises more questions than answers, and was replaced by the 14th Amendment, which better expresses the views of the Reconstruction Congress anyway. This court said as much in Wong Kim Ark. For the dissents and the government, Wong Kim Ark is essentially irrelevant. They attempt to narrow that precedent by noting that the court's opinion repeatedly referred to the domicile of Wong's parents. That is true, but the reasoning underlying the holding of Wong Kim Ark cannot be squared with a domicile requirement of the sort the government envisions. As we have already explained, the court exhaustively canvassed the text and history of the Citizenship Clause. It traced an unbroken line from the English common law into the founding and antebellum eras and through the debates to the clause's ratification. Yet at no point did the court identify any evidence in the historical record that the ratifiers of the 14th Amendment thought themselves to be imposing a domicile limitation. In the end, it is the dissent in Wong Kim Ark that makes the strongest case for a domicile-based theory of American citizenship. There, Chief Justice Fuller resisted the application of the English common law rule because it recognized no exception in the instance of birth during the mere temporary or accidental sojourn of the parents. He admitted that, in England, the question of domicile is entirely distinct from that of allegiance because the one relates to the civil and the other to the political status. But he believed that a different view as to the effect of permanent abode on nationality had been expressed in this country. Under this different view, the 14th Amendment prevented the acquisition of citizenship by the children of aliens whose parents owed local and temporary allegiance merely remaining subject to a foreign power. The government and today's dissenters agree, but this view commanded only a dissent in 1898, and neither time nor circumstance has changed the fact that it is not the law. Again and again, the dissents cast the common law as feudal, medieval, a remnant of the darkness of the Middle Ages. This was not the view of the Reconstruction Congress. Where the dissents see feudalism, the framers of the 14th Amendment saw emancipation. By the time of the Glorious Revolution of 1688, in fact, the tie created by birth was less a duty than a right, the foundation of the ancient liberties of freeborn subjects. That is why Blackstone described the privileges owed to the national born. That is why the colonists demanded the rights of Englishmen more than 250 years ago. And that is why abolitionists lauded the ancient and universal rule of citizenship by birth alone as an ordinance of heaven. Citizenship, then and now, was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to every freeborn person in this land. We keep that promise today. The judgment of the District Court for the District of New Hampshire is affirmed. It is so ordered. Hi, it's me, Bailey, interjecting for a moment. Before we continue on to Justice Jackson's opinion, I just wanted to note that Jackson decided to do all of her citations in footnotes as opposed to the more common in-text citations. So I'm going to be changing how I handle footnotes for this opinion. I'll be skipping over the footnotes that are just citations that I would normally skip over, and I will read out the rest as normal. So you may notice gaps between footnotes where some of them were skipped. That is why. Anyway, carrying on. Justice Jackson, with whom Justice Sotomayor joins as to the introduction and Part 1, concurring. I join the court's opinion in full. I write separately to respond to some of the themes in the principal dissent. Despite his long-standing endorsement of a colorblind constitution, Justice Thomas now surprisingly suggests that the Citizenship Clause was a race-conscious remedial measure relating only to freed slaves such as Dred Scott, and those who shared with them certain characteristics. It is for this reason, he says, that children who were born in the United States but to parents not domiciled here are not entitled to claim birthright citizenship. But that narrow vision of the 14th Amendment bears little relationship to the history of its ratification. Even worse, Justice Thomas is telling elides the entire point of the Second Founding. The Reconstruction Amendments were an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery. Part 1. It is common ground that the 14th Amendment was enacted with the one prevailing purpose of securing equal citizenship to the freed slaves. Also true is the fact that this court has time and again denied Americans that promise. Footnote 1. I suspect, though, that Justice Thomas and I disagree about when and how that promise has been denied by this court. My list is long and sadly only getting longer. For a sampling, consider civil rights cases, Plessy v. Ferguson, DeLima v. Bidwell, Downs v. Bidwell, Korematsu v. United States, Milliken v. Bradley, McCleskey v. Kemp, Parents Involved in Community Schools v. Seattle School District, Shelby County v. Holder, Students for Fair Admissions v. President and Fellows of Harvard College, and Louisiana v. Calais. Carrying on. But consensus about the 14th Amendment's central motivation does not justify Justice Thomas's myopic treatment of it. The amendment caused a paradigm shift in the trajectory of our nation. The teacher who scolds a student for bullying a classmate hopes the student learns the broader lesson of treating everyone with kindness, not just that one kid. In the aftermath of the Civil War, those who championed the 14th Amendment, both within and beyond Congress, understood the assignment. Their work product used language that transcended race and region, and thereby changed and broadened the meaning of freedom for all Americans. Instead of the limited salve the principal dissent makes it out to be, the Citizenship Clause reflects this universalist approach. Section A. Consider first the voices of those outside the chambers of the Senate and the House of Representatives whose advocacy and organizing culminated in the 14th Amendment. Footnote 3. Compare Woolford v. Lopez, Jackson dissenting, explaining the importance of ensuring that Black experiences and perspectives are not here again excluded from our analysis of the relevant history. Carrying on. First in the North as states abolished slavery, and then in the South after emancipation and the Union's victory in the Civil War, Black people who were generally not permitted at the polls or in the halls of power mobilized nevertheless to advance the universalist vision of belonging and citizenship that eventually won the day. The odds were long and the stakes were high. Indeed, around the time they gained their freedom, former slaves faced a crisis similar in relevant respects to the American immigrant experience. With little in terms of possessions and even less in terms of opportunities to make a living for themselves and their families, free blacks were not ushered warmly into the broader community with apologies or compensation, set up for success, or even given the rights and privileges others enjoyed. Though they'd tilled the soil for centuries and had labored to build every building, once freed, they were basically treated as strangers in a not-so-strange land. This was not for lack of trying to survive and belong on the freedmen's part. They constructed churches, schools, and mutual aid societies, safe zones amidst America's racialized social and economic order. Outside those enclaves, however, freed blacks were characterized as unassimilable and incapable of full civic participation. Their humanity was disregarded. Serious doubts about their claims to citizenship were also being sown. The reason was clear. An integrated, race-blind society under the rubric of all men are created equal required a social commitment to anti-subordination principles and practices, i.e., a well-resourced effort to undo the damage done to black people by slavery. But even the most ardent opponents of slavery recoiled from that prospect. One solution that gained traction in the early 1800s was to physically separate the freedmen and other black people from the general polity. Anti-slavery Northerners and pro-slavery Southerners found common cause in the idea that freed blacks would surely be happiest in a black-led republic beyond the contempt of and competition with white Americans. Footnote 11. By the middle of the century, colonization was so popular that it found favor with leading abolitionists, including President Abraham Lincoln. During an August 1862 meeting at the White House between Lincoln and a committee of free Negroes, Lincoln described a fund Congress had created for the purpose of colonizing people of African descent, a cause he had long favored. The problem, as Lincoln described it to his visitors, was that your race suffers very greatly, many of them, by living among us, while ours suffers from your presence. He continued, "Your race are suffering, in my judgment, the greatest wrong inflicted on any people. But even when you cease to be slaves, you are yet far removed from being placed on an equality with the white race. Colonization would allow free blacks to thrive without forcing whites to accommodate their demands for equal treatment and legal protection." Interestingly, Lincoln had a universalist view of citizenship despite his support for the colonization movement. Carrying on. This vision of paternal caste prompted the creation of the American Colonization Society, which established the colony of Liberia and pushed for freed blacks to relocate there voluntarily. Once freed blacks were out of sight, they would thankfully be out of mind, eliminating any need for a racial reckoning in America. Meanwhile, many states pushed the envelope, passing black laws in the pre-war North and black codes in the post-war South, intending to make it difficult for freed blacks to live and work there. Violence, too, played a significant role in the isolation effort. Those who opposed abolition banded together with those who resented the extra competition in the job market to form marauding mobs, ransacking black neighborhoods, homes, and stores. Footnote 14. Frederick Douglass's first-hand account from the Baltimore of 1834 provides insight into white resentment over freed blacks' entry into the labor market. Quote, "The circumstance which led to my being fired was the committing of an outrage upon me by the white apprentices of the shipyard. The fight was a desperate one, and I came out of it shockingly mangled. I was cut and bruised in sundry places, and my left eye was nearly knocked out of its socket. The facts which led to this brutal outrage upon me illustrate a phase of slavery which was destined to become an important element in the overthrow of the slave system, and I may therefore state them with some minuteness. That phase was this: the conflict of slavery with the interests of white mechanics and laborers. In the country, this conflict was not so apparent, but in cities such as Baltimore, Richmond, New Orleans, Mobile, etc., it was seen pretty clearly. The slaveholders, with a craftiness peculiar to themselves, by encouraging the enmity of the poor, laboring white man against the blacks, succeeded in making the sad white man almost as much a slave as the black slave himself. Carrying on. And local law enforcement? They did little to help. Before emancipation, per the Federal Fugitive Slave Act, state officers pursued and arrested blacks suspecting of having escaped slavery. Afterwards, the cavalry looked the other way when black neighborhoods were terrorized by vigilante violence. Footnote 15. The violence, of course, continued after the war and during Reconstruction. The Colfax, Louisiana massacre of 1873, for example, was the bloodiest single instance of racial carnage in the Reconstruction era. 280 black people were ruthlessly slaughtered on Easter Sunday. The Colfax massacre taught many lessons, including the lengths to which some opponents of Reconstruction would go to regain their accustomed authority. Carrying on. The Ku Klux Klan would form and then flourish starting in 1866. Still, most freed blacks resisted the pressure to self-deport. Instead, many started organizing toward the creation of the kind of nation the colonialists opposed, one that guaranteed liberty and justice for all. In the decades leading up to the ratification of the 14th Amendment, black Americans organized and gathered at more than 600 local and national conventions across the country. There, delegates erected the political and intellectual scaffolding for the 14th Amendment, and later for the black civil rights movement more generally. Critically for present purposes, these visionaries already understood themselves to be American citizens. The refrains, "We are Americans" and "We are citizens" echoed in conferences throughout the North. Moreover, birthright figured importantly as delegates frequently characterized their status as that of native-born citizens. The delegates argued that, as such, they had the requisite allegiance, so at minimum, the federal government owed them the duty of protection. Footnote 22. This was, of course, an invocation of the principle of jus soli, which was well known and widely accepted during this historical period. Delegates at the colored conventions drew upon its twin duties: allegiance owed and protection given, to demand not only that their rights as humans be honored, but also that due attention should be given to our needs. The delegates pointedly observed that the laws which have made white men great have degraded us because we were colored and because we were reduced to chattel slavery. So, they argued, in slavery's wake, the law needed to make things right. It had to provide equality expressed in such language as equal liberty, equal justice, equal rights, and equal citizenship. Carrying on. The famed orator Frederick Douglass was one of these delegates. Capturing the spirit of the moment, Douglass proclaimed that Chief Justice Taney, the author of the majority opinion in Dred Scott v. Sanford, could do many things, but he could not change the essential nature of things. In the absence of the artificial evils of slavery and racial subordination, Douglass explained, the glorious birthright of our common humanity will become the inheritance of all the inhabitants of this rightly favored country. Do note this. The citizenship thesis of the colored conventions was thus not that some new status should be created and conferred on free blacks. It was instead that freed blacks already had a rightful claim to citizenship because they had been born on American soil. After all, the nation from its founding had boldly proclaimed that all men are born free and equal, and that consequently life, liberty, and the pursuit of happiness are inherent in every individual, vested inalienably by natural birthright. No ideal was more inherently American. Now, resting their cause on the Republican standard of the Revolutionary Fathers, freed blacks were knocking at the doors of the Constitution and demanding an entrance. And if asked what evidence they bring to sustain their qualifications for citizenship, they would offer them certificates of birth and nativity. Would the nation live up to its promise? Such universalist appeals were a conscious choice. Yes, black Americans had suffered a singular wrong, and yes, they had fought and bled for the Union, paying a steep price for their freedom. But the delegates did not rest on these laurels. Rather, they drew upon the moral and political force of the universal principles that were already core to the nation's identity. That bears repeating. Freed blacks did not advocate for a unique set of rules that catered only to their situation, nor did they seek to advance their own position relative to or at the expense or exclusion of other marginalized groups. Instead, those whose gatherings helped galvanize the push for full equality understood that a diverse origin does not disprove a common nature, nor does it disprove a united destiny. The firmest foundation for freedom would require an anti-caste reset, both for his sake and for ours, and would benefit all. During his U.S. Senate candidacy, Abraham Lincoln developed a similar vision. In the lead-up to the now famous Lincoln-Douglas debates, Lincoln explained that the promise of liberty and equality in the Declaration of Independence was held sacred by all and thought to include all. Lincoln expressly and intentionally linked the fate of Black Americans and immigrant groups, among us perhaps half are people who are not descendants at all of the founders, and noted that the nation's future hinged on a universal definition of citizenship that excluded neither. He explained that the Declaration's promise that all men are created equal was the electric cord that links the hearts of patriotic and liberty-loving men together, regardless of race or descent. The case was made. First, there was war, and then the delegates and Lincoln's universalist view of citizenship made its mark on the Constitution. Section B. The Civil Rights Act of 1866, the predecessor to the Citizenship Clause, was initially drafted as a spot treatment. Senator Lyman Trumbull's first proposal honed in on the freedmen and provided merely that all persons of African descent born in the United States are hereby declared to be citizens of the United States. If that language had prevailed, the view Justice Thomas asserts today might be well-founded. But Senator Trumbull changed his mind. The day after he submitted that first proposal, he requested to withdraw the original and offer another in lieu of it to the same purport, changing the phraseology. Consistent with the views espoused by activists, Trumbull's new proposal adopted a distinctly universalist register. All persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the United States without distinction of color. This is the language Congress would eventually enact as part of the Civil Rights Act of 1866, and the Civil Rights Act of 1866 would go on to become the basis for the 14th Amendment's Citizenship Clause. Senator Trumbull's progression from specific to universal was more than mere word choice. In the face of the virulent anti-immigrant, and in particular the anti-Chinese and anti-Romani sentiment of that era, language targeting just freed former slaves would have been the path of least or less resistance. But Senator Trumbull, along with those colleagues who took up the same mantle during the ratification debates, expressly rejected that narrow framing. Do not miss this context. Throughout the mid-19th century, Chinese immigrants to America were often portrayed as coolies, a racist slur implying indentured servitude and allegiance to a Chinese master. Footnote 37. When anti-Chinese sentiment reached a fever pitch decades later, Congress enacted the Chinese Exclusion Act and prohibited all Chinese immigration. Justice Harlan's dissent in Plessy v. Ferguson, the most celebrated 14th Amendment opinion according to the principled dissent, did not rise above such prejudice. Justice Harlan described Chinese immigrants as a race so different from our own that we do not permit those belonging to it to become citizens of the United States and instead deem them absolutely excluded from our country. Justice Harlan thus drove a wedge between Black Americans and other non-Black minorities. Carrying on. Some members of Congress brought that sentiment to the Civil Rights Act's citizenship-related debates. Notably focusing his attention beyond freed former slaves, Senator Edgar Cowan, for example, argued that German immigrants' children born in Pennsylvania should be citizens, but Chinese immigrants' children should not, because Germans and Chinese were different. In response, Senator Trumbull emphasized that the law he had drafted drew no such distinctions. Undeterred, Senator Cowan would warn again, this time during debates on the 14th Amendment, that the Citizenship Clause would let Chinese immigrants overrun California and double or treble the population of that state. Senator John Conness of California, where anti-Chinese sentiment was arguably most pronounced, responded that the children begotten of Chinese parents in California shall be citizens. In fact, he said, the Civil Rights Act had already declared that the children of all parentage whatever should be regarded and treated as citizens of the United States. No senator rose to agree with Senator Cowen or dispute what Senator Conness had said. And no senator said what the principal dissent says today, that the text at issue conferred citizenship only on freed blacks and those in analogous situations. Footnote 44. In response to this history, the principal dissent notes that Francis Wharton, a late 1800s legal scholar and State Department official, posited that because foreigners born in the United States of parents not being here domiciled are not subject to the jurisdiction of the United States, Chinese children born in this country are not citizens. But Justice Thomas leaves out the motivation behind Wharton's contention, not the Constitution, but that the Chinese were insufficiently civilized, and that to admit such rights to an emigrating nation would be not merely to establish a foreign sovereign, but a foreign barbarism within our national domain. Carrying on. The debates went similarly with respect to Roma people, who were referred to at the time as gypsies. Footnote 45. William Blackstone called the Roma people Egyptians and branded them outlandish. The proper term for this group today is Romani, or the Roma people. Carrying on. When asked whether native-born Romani children would be birthright citizens of the United States under the proposed Civil Rights Act, Senator Trumbull replied, "Undoubtedly." President Andrew Johnson apparently agreed. In his message vetoing the act, Johnson noted with disapproval that under the law, the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as blacks, would be birthright citizens. Without making any changes to the bill or responding that Johnson was mistaken in his understanding of it, or otherwise capitulating to Johnson's views in any respect, Congress overrode that presidential veto. During the ratification debates, Senator Cowen took aim at the Roma people too, characterizing them as undeserving of birthright citizenship because they wandered in gangs, infested society, and imposed upon the simple and weak everywhere. And again, Senator Conness dismissed Senator Cowen's prejudices. The only invasion of Pennsylvania within my recollection was an invasion very much worse and more disastrous to the state, and more to be feared, and more feared than that of gypsies. It was an invasion of rebels at Gettysburg. When ratified, the Citizenship Clause thus vindicated the universalist vision of the delegates at the colored conventions and their allies in Congress. Far from the principal dissent's representations, freed blacks did not receive citizenship as a reward for their military service or for having, through no choice of their own, no other homeland and no allegiance to any foreign power. Instead, the amendment recognized their rightful claim to birthright citizenship simply and solely by virtue of their having been born on American soil. John Bingham, one of the amendment's principal architects, said this clearly. The rights of citizenship are universal because they are the sacred rights of personhood. Footnote 51. Bingham believed the liberation of slaves had forced the United States to federalize the Bill of Rights and apply it to all Americans. Carrying on. With this recognition, the U.S. Constitution finally got an anti-caste engine, and with it, the nation gained a new font of legitimacy and vitality. Part 2. Fast forward 150 years to 2026. Section 1 of the 14th Amendment still contains that same universalist language consistent with its origins and the ratifier's intent. So, respondents say our Constitution confers citizenship upon almost anyone and everyone who is born on American soil, to include the children of immigrants and temporary sojourners not domiciled in the United States, just as it did at the time of the 14th Amendment's ratification. Footnote 52. At this point, the almost caveat pertains mainly to the children of ambassadors and other representatives of foreign sovereigns. Congress addressed the founding era exclusion of those born in the alien nations of Indian tribes, with its enactment of the Indian Citizenship Act. Carrying on. But the government's view, which the principal dissent adopts, rejects this. Its argument focuses on the fact that the Citizenship Clause had a particular purpose, to reverse Dred Scott's holding that Black Americans were not entitled to citizenship. The reading is, in essence, that the 14th Amendment recognized freed blacks as citizens because they had fought and bled in the Civil War, had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. Thus, the argument goes, the amendment's guarantees are for only black Americans and those who fit their fought and died for country, no other homeland, domiciled mold. That contention is ahistorical for the reasons laid out in Part 1 Supra, and those explained in the court's opinion. In my view, it is also difficult to square with the notion of a colorblind constitution, which has loomed large in the court's 14th Amendment jurisprudence. Footnote 53. This footnote starts with a number of citations to 14th Amendment cases decided by the Supreme Court. I'm not going to read them all out. There are myriad ways in which the court's adherence to colorblindness is mistaken, some of which I have addressed in other opinions. My concern now is that a fleeting nature is among its many flaws. One wonders how the outcomes in the above cases might have differed had the court, like the government and the principal dissent today, relied upon the fact that the 14th Amendment was enacted to ensure that black Americans are not treated as second-class citizens, or had it at least acknowledged the connection between the amendment's historical context and its remedial purpose. Carrying on. The court's conception of a colorblind constitution and the government's and principal dissent's cramped, group-specific reading of the Citizenship Clause are two sides of the same coin, stemming from a basic misunderstanding of the relevant history. As I have shown in this opinion, the 14th Amendment is not colorblind. Rather, its core principle is that our nation does not tolerate racial caste, i.e., the systemic subordination that many, even some who oppose slavery, had wished to perpetuate after the Civil War. Footnote 54. Quote, a caste system is an artificial construction, a fixed and embedded ranking of human value that sets the presumed supremacy of one group against the presumed inferiority of other groups on the basis of ancestry and often immutable traits that would be neutral in the abstract but are ascribed life and death meaning in a hierarchy favoring the dominant caste whose forebears designed it. Throughout human history, across time and space, at least 3 caste systems have stood out to this day. The tragically accelerated, chilling, and officially vanquished caste system of Nazi Germany, the lingering, millennia-long caste system of India, and the shape-shifting, unspoken, race-based caste pyramid in the United States. End quote. Carrying on. So, the architects of the Second Founding did not think or pretend that race didn't matter. Quite to the contrary, they understood that race made an enormous difference to the lived experiences of all concerned, and to the fate of our Union. Indeed, it was for that very reason that a radical restructuring was required. The Citizenship Clause applies universally precisely because such universal application was necessary to achieve the amendment's own race-conscious remedial purposes. Putting a finer point on this, when colonizationists objected to changing their norms to accommodate the equal citizenship and rights of freedmen, freed blacks and their allies organized to push for a constitution that would bring their own anti-subordination vision to fruition. That kind of ambitious transformation, nothing less than the remaking of the soul of a nation beset by a rank, entrenched, race-based prejudice and inequity, did not come for free or purely by the say-so of those who claimed to be colorblind. It required heavy lifting, a fundamental shift, the very thing for which the 14th Amendment stands, a repudiation of the notion that there is a superior, dominant ruling class of citizens, and a willingness to see and strive to eliminate all remaining vestiges of historical subjugation. So the principal dissent is wrong to complain that the court has repurposed the 14th Amendment to protect rights that the Reconstruction Congress never contemplated. Delegates to the colored conventions drew upon their own experiences to successfully argue for a new constitution, one that protected fundamental human rights, including an individual's right to own his body and mind, and the right of personal security and protection against injuries to our bodies or good name. Thus, even in cases where the protagonist was not a black American, this court's 14th Amendment cases have focused at bottom on the same universal liberty and equality interests that motivated the 14th Amendment itself. The question is, and always has been, does the affected individual or group enjoy equal dignity? And the correct answer is, and has always been, to heed the 14th Amendment's universalist anti-subordination command. Our nation did not undergo something as profound and world-shifting as Reconstruction for naught. After the Civil War, Frederick Douglass frequently reflected on the events of the time through the lens of biblical stories. In one speech, Douglass described how God leveled Sodom and Gomorrah on account of sin, and how, in the aftermath, Abraham stood atop a nearby mountain to survey what remained. The orator used the image of Abraham looking down upon the destroyed landscape to demand that Americans look down upon their own recent self-destruction and all but unjustified survival and remember. Douglass declared that his own aim was to show that nations should have memories. In the time since Douglass's prescient observation, Americans have come to learn that fading memories are not the only danger. The distortion of historical facts, retellings that reimagine and repurpose past events to lend credence to misbegotten aims, may be an even greater threat. Yet here we are. The government, the principal dissent, and a handful of revisionist commentators now vigorously promote an interpretation of the Citizenship Clause that diverges sharply not only from what the text says, but also from the historical record as interpreted by the keepers of the call of remembrance, trained historians. Footnote 59. A substantial amount of scholarly work has been done to unearth historical truths about the facts and circumstances that gave rise to the Reconstruction Amendments. In addition to the sources I have cited throughout this opinion, see, for example, D. Faust, This Republic of Suffering, Death and the American Civil War, E. Matheson, The Loyal Republic, Traitors, Slaves, and the Remaking of Citizenship in Civil War America, and K. Stamp, America in 1857, A Nation on the Brink. Carrying on. What is more, this alternative account pitches Black Americans against immigrants when the advocates who promoted the 14th Amendment did no such thing. Freed blacks fought for the shared humanity of all people, and the great emancipator eventually foresaw that the only path forward that could prevent a return, in any form, to slavery and race-based subordination was to link the fates of all. Ultimately, then, it is the government and Justice Thomas who have repurposed the 14th Amendment. By ignoring that our Constitution stands firmly against caste and subjugation, on all axes and in all manners, they deny the clear universalist vision shared and proclaimed by the 14th Amendment's framers to rebuild a shattered empire, to plant deep and solid the cornerstone of eternal justice, and to erect thereupon a superstructure of perfect equality of every human being before the law. Of course, the ultimate irony is that for all the talk about the detestable Dred Scott decision, the government and the principal dissent propose a return to its core tenet. Their bottom line is that, for certain people, being born on American soil will not suffice to confer citizenship. It is that odious conclusion that the Citizenship Clause plainly rejects, as the court explains. I add only that the 14th Amendment's universalist aims should forever be the death knell for this kind of claim, one that seeks to make bloodline the marker of birthright. The America that was reborn from the rubble of the Civil War simply does not countenance that inequitable result. Thankfully, a majority of the court remembered this today and has dutifully preserved the most basic animating principle of our nation's founding, that all human beings are created equal once more. Justice Kavanaugh concurring in the judgment and dissenting in part. Executive Order Number 14160 establishes new exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country. The court today holds that the order violates the 14th Amendment to the Constitution. I respectfully disagree with the court's constitutional holding. In my view, the executive order does not violate the 14th Amendment, but the order does contravene a federal statute, 8 U.S.C. Section 1401A. Congress could, consistent with the 14th Amendment, amend Section 1401A or otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country, but Congress has not yet done so. Part 1. I first consider plaintiff's statutory argument. The statutory analysis is straightforward, and the court could have, and in my respectful view should have, decided the case on that narrow ground. Initially enacted in 1940, Section 1401A of Title VIII provides that persons born in the United States and subject to the jurisdiction thereof shall be nationals and citizens of the United States at birth. That statutory language mirrors the text of Section 1 of the 14th Amendment, which was ratified in 1868 and similarly provides, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. This court's 1898 Wong Kim Ark decision interpreted the subject to the jurisdiction language of the 14th Amendment. That decision adopted a general rule of birthright citizenship for those born in the United States, with 4 disparate exceptions for children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory, and children of members of the Indian tribes. Importantly, the Wong Kim Ark decision treated those 4 exceptions as a closed set for constitutional purposes, meaning that Congress could not create other exceptions to birthright citizenship, although Congress could eliminate one or more of those 4 exceptions. In 1940 and 1952, Congress employed the exact language from the 14th Amendment, subject to the jurisdiction thereof, in comprehensive new immigration and naturalization laws that provided for birthright citizenship. The relevant provisions are now codified at 8 U.S.C. Section 1401A. Because Section 1401A uses the same language as the 14th Amendment, the statute has long been interpreted to adopt Wong Kim Ark's general rule of birthright citizenship, subject to the exceptions identified in that case. If Congress in 1940 or 1952 wanted to create new exceptions and thereby test Wong Kim Ark's statement treating the 4 exceptions as a closed set, Congress presumably would not have repeated the precise language that this court had interpreted in Wong Kim Ark to contain only those 4 exceptions. Stated more doctrinally, Congress must be considered to have adopted also the construction given by this court to such language and made it a part of the enactment. Footnote 1. By the time of the 1940 and 1952 acts, Congress had granted statutory birthright citizenship for American Indians born in the United States, thereby eliminating the American Indian exception as a matter of statutory law. Carrying on. Importantly, moreover, from the time of those statutory enactments in 1940 and 1952 all the way through 2025, the executive branch consistently interpreted Section 1401A to encompass only those Wong Kim Ark exceptions to birthright citizenship. The government here does not contest that historical point. That long and consistent executive branch interpretation further indicates that Section 1401A incorporates only those exceptions. In 2025, however, Executive Order No. 14,160 sought to add 2 new exceptions to birthright citizenship for children born to foreign citizens who are either illegally or temporarily in the United States. In doing so, the executive order goes beyond what Section 1401A authorizes. For the executive order to be lawful, therefore, Congress would need to amend Section 1401A or otherwise enact new legislation to encompass those 2 new exceptions. As of now, Congress has not done so. Over the last 30 years, Congress has considered numerous proposed bills to alter birthright citizenship, but Congress has never actually passed such legislation. Unless and until Congress enacts such legislation, the executive order contravenes the federal statute, Section 1401A. Part 2. I next address the 14th Amendment issue. As revealed by the court's opinion with its detailed account of history and precedent, and by the weighty and thoughtful dissents, the constitutional issue is far more complicated than the statutory issue. After reading those scholarly opinions, one thing seems evident. The constitutional issue is not straightforward, much as we might want it to be. That is another reason why, in my respectful view, the court should have decided the case on the narrow and straightforward statutory ground. In any event, because the court addresses the Constitution, and because I respectfully disagree with its analysis of that highly consequential issue, I too will briefly address it. Ratified in 1868, the Citizenship Clause of Section 1 of the 14th Amendment provides, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. In 1898, as noted above, Wong Kim Ark interpreted the 14th Amendment's subject to the jurisdiction language to provide a general right of birthright citizenship with 4 disparate exceptions for children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our country, and children of members of the Indian tribes. Importantly, Wong Kim Ark indicated that the four exceptions were a closed set, meaning that there can be no additional exceptions recognized based on subsequent circumstances or developments, and the decision has consistently been read that way, including by plaintiffs and the court today. Footnote 2. At oral argument, plaintiffs repeatedly argued that the exceptions recognized in Wong Kim Ark are a closed set. Carrying on. But Wong Kim Ark's treatment of the exceptions as a closed set is incorrect in my view. Considering the four exceptions as a permanently frozen or closed set as of the 14th Amendment's ratification in 1868, such that there can be no subsequent exceptions recognized based on new developments after 1868, is inconsistent with the court's long-standing approach to constitutional interpretation in a variety of areas. Footnote 3. In my view, to be clear, the result in Wong Kim Ark was correct given the facts and circumstances in that case. Carrying on. To spell that out, the Constitution is an enduring document, and its principles were designed to and do apply to modern conditions and developments. The original constitutional principles do not change absent a constitutional amendment, but the relevant principles, both the rules and exceptions alike, must be faithfully applied not only to circumstances as they existed in 1787, 1791, and 1868, for example, but also to modern situations that were unknown or unanticipated by the Constitution's framers. Stated otherwise, the meaning of rules is constant, only their application to new situations presents a novelty. In Fourth Amendment cases, for example, courts apply the reasonableness requirement to searches of cars even though cars did not exist in 1791 or 1868. In First Amendment cases, courts apply free speech protections to the Internet, notwithstanding that the Internet did not exist in 1791 or 1868. In Second Amendment cases, this court applies the amendment to semi-automatic handguns even though those did not exist in 1791 or 1868. From the other direction, moreover, this court recognizes constitutional exceptions based on new circumstances when the new exception is relevantly similar to those exceptions that existed in 1791 or 1868. This court's constitutional precedents do not treat the 1791 or 1868 exceptions as a closed set trapped in amber. So ordinarily, both the relevant constitutional rule and the constitutional exceptions, as of 1787, 1791, or 1868 as the case may be, apply to new circumstances. As the court has said before, discerning and developing the law in this way is a commonplace task for any lawyer or judge. Indeed, at oral argument in this case, many members of the court explored that critical interpretive point at some length with counsel. Footnote 4. Amid their famous First Amendment debate in Ullman v. Emmons, both Judge Bork and Judge Scalia agreed on that bedrock interpretive point. Judge Bork, quote, "In a case like this, it is the task of the judge in this generation to discern how the framers' values, defined in the context of the world they knew, apply to the world we know. The world changes in which unchanging values find their application. The Fourth Amendment was framed by men who did not foresee electronic surveillance, but that does not make it wrong for judges to apply the central value of that amendment to electronic invasions of personal privacy. The commerce power was established by men who did not foresee the scope and intricate interdependence of today's economic activities. But that does not make it wrong for judges to forbid states the power to impose burdensome regulations on the interstate movement of trailer trucks. We must never hesitate to apply old values to new circumstances." End quote. Judge Scalia, quote, "I am not in need of a reminder that the Fourth Amendment must be applied to modern electronic surveillance, the Commerce Clause to trucks, and the First Amendment to broadcasting. The application of existing principles to new phenomena, either new because they have not existed before or new because they have never been presented to a court before, is what I would call not evolution, but merely routine elaboration of the law." End quote. Carrying on. The Citizenship Clause of Section 1 of the 14th Amendment should be no different. The court's 1898 decision in Wong Kim Ark recognized four exceptions that existed as of the 14th Amendment's ratification in 1868. Therefore, under basic tenets of constitutional interpretation, other exceptions can be recognized when the new exceptions 1. are based on subsequent developments or circumstances that are new, i.e., largely unknown or unanticipated by the framers of the 14th Amendment, and 2, are relevantly similar to the 4 previously recognized Wong-Kim Ark exceptions. Here, that interpretive principle would support additional exceptions for children born to foreign citizens unlawfully or temporarily in the country. Footnote 5. When I refer to foreign citizens in this opinion, I am not referring to those who are dual citizens of the United States and a foreign nation. Persons born in the United States to parents who are dual citizens of the United States and another nation are constitutionally entitled to birthright citizenship. Carrying on. First, significant illegal immigration into the United States is a new circumstance that was largely unknown as of 1868 and that the framers of the 14th Amendment could not have fully anticipated. And the framers likely would not have anticipated, and presumably would not have intended, the odd result of granting a substantial birthright citizenship benefit to 1. Those foreign citizens who violate U.S. immigration law and illegally enter or overstay and then have children in the United States over 2. Those foreign citizens who follow U.S. immigration law and have children in their home countries while seeking to lawfully immigrate to the United States. Nor, presumably, would they have wanted to grant constitutional birthright citizenship to children of foreign citizens unlawfully in the country, while simultaneously denying constitutional birthright citizenship to children of tribal American Indians. So, too, the issue of temporary visitors who give birth in the United States presents a new and different circumstance than in 1868, given the significant changes in immigration laws and travel. And second, those two categories of foreign citizens, namely those unlawfully or temporarily in the country, are relevantly similar to the 4 categories of persons recognized as exceptions in Wong-Kim Ark. The only apparent principle unifying the 4 disparate exceptions listed by the court in Wong-Kim Ark, especially in light of the exceptions for tribal American Indians, is that the parents in all of those varied circumstances were not U.S. citizens and were citizens of other nations, whether tribal or foreign. An exception for those born in the United States to foreign parents unlawfully or temporarily in the country is consistent with that principle and therefore with the 14th Amendment. Footnote 6. Plaintiffs' only proposed unifying principle for the 4 exceptions is what they call the fiction of extraterritoriality. The court today seemingly embraces that same principle. It is not clear what the fiction of extraterritoriality means here, and it certainly does not support treating the 4 exceptions as a permanently closed set. If plaintiffs' point is to indulge the fiction, to use their word, that certain foreign citizens, such as diplomats, should be considered as being back in their home countries for the purposes of birthright citizenship, why does that not also apply to those in the United States unlawfully or temporarily? And most starkly, plaintiffs cannot convincingly explain their view that the children of tribal American Indians are not constitutionally entitled to birthright citizenship, while the children of foreign citizens unlawfully or temporarily in the country are constitutionally entitled to birthright citizenship. Carrying on. All of that said, as noted above, Congress in 1940 and 1952 enacted a statute, Section 1401A, that at the time and since has always been understood to authorize only the 4 Wong-Kim Ark exceptions. If Congress amends Section 1401A or otherwise enacts a statute creating new exceptions along the lines of the executive order for children born to foreign citizens unlawfully or temporarily in the country, such a statute, as I see it, would pass constitutional muster. Footnote 7. Nothing in this opinion is intended to suggest how birthright citizenship should be addressed as a policy matter. Carrying on. For those reasons, to reiterate, the executive order does not violate the 14th Amendment, but the order does contravene 8 U.S.C. Section 1401A. Consistent with the 14th Amendment, Congress could amend Section 1401A or otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country, but Congress has not yet done so. Justice Thomas, with whom Justice Gorsuch joins, dissenting. This court's decision in Dred Scott v. Sanford would have permanently denied citizenship to blacks as a subordinate and inferior class. After the Civil War, the Reconstruction Congress overruled Dred Scott, first with the Civil Rights Act of 1866, then with the Citizenship Clause of the 14th Amendment. Both the Civil Rights Act and the Citizenship Clause guaranteed citizenship to persons born and domiciled in the United States regardless of their race. Neither guaranteed citizenship to persons who were not domiciled in the United States. Blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. They fought and bled in the same battles, gained and gloried in the same victories, and were liable to be called upon to defend America in time of war alongside every other citizen. The Citizenship Clause thus guaranteed them the dignity and glory of American citizenship, so as to ensure that they would never be treated as second class under the law. The same could not be said for the children of foreign temporary visitors. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in time of war. Americans, consistent with their settler ethos, believed that citizens were the people who called a place home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. A person was a citizen of the state where he had his domicile. When foreigners temporarily visited, their national character was unchanged. Such visitors were strangers, not subjects. A person born here but domiciled in a foreign land was therefore considered as much a stranger to the country as his father. That is why, when Dred Scott went to court, he argued that to be a citizen, it is only necessary that he should have acquired a domicile. After this court held that Scott was not a citizen because he was black, Republicans in Congress, such as Representative John Bingham, stated that a person was a citizen if he was born and domiciled in the United States. Scott was a citizen in their view because he was born to Americans, not to temporary sojourners. As Frederick Douglass had put it, the freedmen sought citizenship not as aliens or as exiles, but as Americans. Congress implemented the principle that citizenship follows birth and domicile in the Civil Rights Act of 1866, and then in the Citizenship Clause of the 14th Amendment. The Civil Rights Act guaranteed citizenship to persons who were both born in the United States and, as relevant here, not subject to any foreign power. The phrase "not subject to any foreign power" excluded from citizenship children of foreign temporary visitors who were subject to the power of their home nation. The Citizenship Clause, which the same Congress passed shortly after the Civil Rights Act, was understood to have the same meaning. It guaranteed citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile. Domicile was the foundation of jurisdiction over persons. The government of a person's domicile had broad power over that person, including with respect to his personal affairs, his conduct abroad, his personal taxes, and the mutual duties of protection and allegiance. So, as the senator who introduced the Citizenship Clause explained, the word jurisdiction as here employed ought to be construed so as to imply a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. After all, Congress would have no right to make citizens of persons temporarily resident. The Citizenship Clause was consistently interpreted not to apply to the children of foreign temporary visitors who were by definition not domiciled in the United States. Regardless of administration or party, the federal government for decades after ratification regularly denied claims to citizenship by children who were born in the United States but not domiciled here. When a child was born in the United States to parents domiciled abroad, he was not, therefore, under the statute and the Constitution, a citizen of the United States by birth. Scholars agreed. A child born within the territory of the United States of alien parents was not a citizen unless his parents were permanently domiciled within the United States. This court agreed. The Citizenship Clause excluded from its operation children of citizens or subjects of foreign states born within the United States. And Congress agreed. The Citizenship Clause did not extend to a child born here but subject to any foreign power. As Justice Harlan would write in his dissent in Plessy v. Ferguson, the Citizenship Clause gave citizenship to all born or naturalized in the United States and residing here. The court offers a different account. American citizenship, the court says, was based on a medieval English feudal principle, according to which each person owed personal service to the lord of the soil as his master, a perpetual servitude that was born with the child and only ended in the grave. Americans, the court says, adopted this feudal principle as a rule of American citizenship with little fanfare. Then, according to the court, the Reconstruction Congress codified that feudal principle with the words not subject to any foreign power in the Civil Rights Act and subject to the jurisdiction thereof in the Citizenship Clause. Then, the court says, the clause's meaning was definitively settled by dicta in United States versus Wong Kim Ark. With due respect, the court's account is not historically accurate. The court says that the Citizenship Clause incorporated the English feudal principle that subjects owed lifetime servitude to the king who owned the soil on which they were born, but Americans, unsurprisingly, rejected this feudal principle. The court's theory of American citizenship is based on the opinion of a New York assistant vice chancellor in an inheritance dispute called Lynch versus Clark. But the assistant vice chancellor's reasoning, whatever it was worth, was not even followed in New York by the time of the Citizenship Clause. Finally, the court reasons that dicta in Wong Kim Ark settled the meaning of the clause, but Wong Kim Ark itself emphasized that its holding was limited to persons domiciled in the United States, and scholars and government officials continued to agree after Wong Kim Ark that the Citizenship Clause did not extend to the children of foreign temporary visitors. The rule remained what it always was. A child born on American soil of a stranger or traveler passing through the country or temporarily residing here was not a citizen. The court today takes the extraordinary step of holding facially unconstitutional the president's order excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support. Because many potential applications of the President's order are consistent with the original public meaning of the Citizenship Clause, I respectfully dissent. Part 1, Section A. I begin with early American practices relating to citizenship and nationality, which inform what the Citizenship Clause means. In America, you were generally a citizen if you were born here and this was your home. The legal word for home was domicile. The concepts were so linked as to be taken as effectively synonymous at times, such that Justice Bushrod Washington would say, citizenship means domicile, home, permanent residence. The same correspondence has persisted throughout American history. Citizens were not the people who were temporarily passing through a territory or who happened to be born within it. Citizens were the permanent members of the body politic, the people whose roots were in a place, who called that place home, and who would, if necessary, go to war for that place. The law of both state and national citizenship reflected this principle. Domicile was critical for state citizenship. As Chief Justice Marshall explained, a person was a citizen of that state in which he has a fixed and permanent domicile. Temporary visitors, it followed, were not citizens. When a person who went to a new state on a mere temporary visit for a transient purpose, Justice Story explained, he could not hereby claim to be a citizen of such state. Instead, to become a citizen of the state to which he removes, someone had to show that he had his domicile there. The same rule remains in place today. As a general matter, an individual is deemed a citizen of the state of his domicile. Domicile was also critical for national citizenship. As this court stated the rule, when a person acquires a domicile in a nation, he becomes a member of the new society, at least as a permanent inhabitant. Domicile played a role in determining someone's national character, which would change whenever he removes to a foreign country and settles himself there, with an intention permanently to reside there. He was a subject of the nation where he was domiciled. He followed the character of that country in war as well as in peace. Thus, the view of the executive branch was that when a person acquires an American domicile, the law enjoins upon other nations to respect him in regard to protection as an American citizen. Domicile confers a national character. It does not allow anyone who has a domicile to decline the national character thus conferred. His status remains as long as the domicile is retained, and is changed with it. This approach was consistent with this country's settler ethos. Daniel Webster wrote that no government has carried the general presumption further than the United States that a person attains a new national character when he settles and intends permanently to reside in a nation. Although some nations would lay claim to anyone born in their land or any descendant of their citizens, America viewed its people as the people who built their lives here. A person domiciled here pays the same price for his protection as native-born or naturalized citizens pay for theirs. In war, he shares equally with them in the calamities which may befall the country. His services may be required for its defense, and his life may be periled and sacrificed in maintaining its rights and vindicating its honor. The United States thus did not claim as a citizen every child born on its soil. Instead, pursuant to the principle that children followed their parents' domicile, a child was a citizen of the place where his parents were domiciled. A child born of foreign parents is not, on principles of natural reason, necessarily to be considered as a citizen of the country where he is born. If he was born in the country but both his parents were strangers not designing a permanent change of country, then he was as much a stranger to the country as his father. The rule was that when a subject is traveling or sojourning abroad, he continues under the protection of his home nation, so his children are an exception to the rule which makes the place of birth the test of citizenship. The relationship between citizenship and domicile was a matter of general law from which the political branches could depart by statute, but those statutes also typically tracked the domicile rule. So Congress retained the prerogative to set the terms for becoming a naturalized citizen and could impose requirements beyond domicile. But when Congress enacted naturalization statutes, they too generally tracked the domicile requirement. And even when a person was domiciled here and not formally naturalized, he was already considered a citizen for some purposes. Before being naturalized, domiciliaries were de facto, though not de jure, citizens of the country of their domicile. Likewise, for other purposes, national citizenship was not an independent concept but simply derivative of state citizenship. Every citizen of a state, it was often said, was ipso facto a citizen of the United States. In these contexts, too, national citizenship required domicile because state citizenship required domicile. Of course, birthplace closely correlated with domicile. Most children were born where their parents were domiciled and where, as a result, they were domiciled. The correlation was especially strong in the early 19th century when crossing an ocean for a temporary visit was an unappealing prospect for pregnant women. Because birthplace was often a heuristic for domicile, it could be generally stated that children were citizens of their place of birth. But when the specific question arose, a reasonable qualification to that general statement exempted children of parents who were in itinere in the country or abiding there for temporary purposes. Section B. The law of domicile is essential to understanding the citizenship provisions of the Civil Rights Act and the 14th Amendment, so I briefly explain the relevant parts of the law of domicile here. Subsection 1. Domicile meant legal home. The most common definition of domicile was residence with the intent to permanently remain. A person's residence was the place where he lived. He had the intent to permanently remain in that place if he planned to stay there indefinitely. A person was not domiciled in a place simply because he was temporarily present or born there. A person's presence in a place was merely prima facie evidence that he was domiciled there. Because a person's temporary visit to a place did not change his domicile, persons who were temporarily present in a place were regarded by the law as not subjects but as strangers. Accordingly, a person's place of birth was only prima facie evidence of domicile. A child took on the domicile of his parents. Because any person incapable of establishing his own domicile had the domicile of that person on whom he depends for support, it followed that generally minor children had the settlement of their fathers. So if a child was born to foreigners who did not permanently reside here, the child was not domiciled here. Finally, each person had one and only one domicile. Every person must have a domicile somewhere, and every person can have only one domicile. The supposition that a man can have two domiciles would lead to the absurdest consequences. A person can reside and intend to permanently remain in only one place at a time, and no person, according to the law of nations, is without a domicile. So if someone did not intend to remain where he was at the moment, the law ascribed that person his last such place as his domicile. Subsection 2, subsection A. Because a person could have only one domicile, domicile was a natural criterion for citizenship. In the 19th century, dual citizenship was considered highly undesirable, if not a contradiction in terms. The general view was that no one can have two countries. Dual citizenship led to a number of foreign policy concerns, such as conflicting claims on the dual citizen during a war. Therefore, the United States did not recognize a double allegiance. Instead, under our law, a citizen was bound to be true and faithful alone to our government. Because each person had one and only one domicile, domicile-based citizenship avoided the problems attendant to dual citizenship. The principle that citizenship followed domicile also made it more likely that citizens would be attached to their country. As Alexander Hamilton envisioned it, the citizenry were the people who would join together against any threat, a large body of citizens who stand ready to defend their own rights and those of their fellow citizens. As Frederick Douglass saw it, citizenship belonged to those who fought and bled in the same battles and gained and gloried in the same victories. And as this court put it is to the citizen that the country must look for its safety. The dignity and glory of American citizenship belongs to people who have a meaningful tie to this country. A domiciliary had, by definition, the sort of permanent attachment to a place that befitted him to citizenship. A temporary visitor whose homeland was somewhere else, although he had legal rights and was entitled to dignified treatment, lacked the ties to this country that would make him fit for citizenship. He therefore was generally not eligible for naturalization, and his children were likewise not naturally citizens of their birthplace. Footnote 1. Perhaps for this reason, although the United States welcomed settlers with its domicile-based approach, the baseline in most of the Western world was often that only the children of citizens could be citizens. Carrying on. Subsection B. Once a person became domiciled in a place, he was considered no longer subject to any foreign power. A person was subject to the government of where he was domiciled. When a person traveled abroad, he remained subject to the power of his home nation, much like an American who travels abroad today remains subject to the power of his government. As this court explained, if a person goes into a foreign country on a temporary visit, he remains subject to the power of his home country. When a person moved to a country permanently, by contrast, he was no longer subject to the power of the country from which he originated. Those who resided in a new nation from a permanent cause became subject to the new nation. Subsection C. American legal authorities described a person as subject to the jurisdiction of the government of his domicile. Then, as now, governments exercised different types of authority over temporary visitors and permanent residents. A government does not apply the same laws in all manners to persons who are only temporarily resident as it applies to persons who are permanently resident within its territory. So, while a government applied, among other things, its ordinary criminal laws to temporary visitors, it had a wide range of further powers only with respect to persons domiciled within it. For that reason, when someone was present in a territory but had a domicile elsewhere, although he was still amenable to the laws of the host government, that government would describe him as not subject to our jurisdiction. In contrast, when a party made his habitual and usual domicile in a place, he became, in 1860 parlance, subject to the jurisdiction thereof. Footnote 2. This characterization of jurisdiction as a function of domicile was common. Carrying on. A person was subject to the jurisdiction of the government of his domicile because of the legal relationships that followed from domicile. The fact of domicile was one of the highest importance to a person. It was said that domicile determines a person's civil and political rights and privileges, duties and obligations. It fixes his allegiance, it determines his belligerent and neutral character in time of war, it regulates his personal and social relations whilst he lives, and it furnishes the rule for the disposal of his property when he dies. The legal relationships that followed from domicile, which collectively made a person subject to the jurisdiction of the government of his domicile, could be grouped into four categories. First, domicile determined which government had the power to declare the law as to an individual's most important personal affairs. The law governing personal affairs included the laws of marriage and divorce, which followed a couple's domicile. It included laws governing the succession of a person's estate, which was distributed according to the law of distribution of the place of his domicile. And it included laws governing a person's age of majority, his capacity to contract, his right to sue, and his rights with respect to movable property. Jurisdiction over these personal affairs had exclusive operation given to it only with respect to persons domiciled. Mere territorial presence was not enough. Second, domicile determined which government had plenary jurisdiction over a person to regulate his actions anywhere. The law governing domiciliaries, unlike the law governing temporary visitors, had effect given to it beyond the limits of the territory. And as now, a government could exercise personal jurisdiction over domiciliaries while the domiciliaries were abroad and for their conduct abroad. Third, domicile determined which government had the power to impose personal taxes on a person. The power to impose personal and income taxes depended on the party's domicile. A sovereign could tax the property in its territory belonging to anyone, but it could impose personal taxes, such as a capitation tax, only on persons domiciled within it. A person not domiciled is not within the jurisdiction of the assessors. He was not liable to taxation in the city for his poll, income, and personal property because his residence and domicile was not in the city. So, while transient travelers were not liable for ordinary governmental or municipal taxes, such taxes could be collected from domiciled aliens. A non-domiciliary could recover taxes as improperly collected because he was, regardless of his territorial presence, not subject to the jurisdiction of the taxing authority. Fourth, domicile determined which government owed a person protection when he went abroad. As this court explained, the American citizen who goes into a foreign country, although he owes a local and temporary allegiance to that country, is yet, if he performs no other act changing his condition, entitled to the protection of our government. So, before the Civil War, the government intervened to protect Americans abroad based on their domicile. A non-naturalized domiciliary abroad was entitled to protection as an American citizen. The Department of State throughout the 19th century repeatedly confirmed the right of persons domiciled in the United States but not naturalized therein to maintain internationally their status of domicile and to claim protection from this government in the maintenance of such status. This protection abroad corresponded to the primary allegiance that the domiciliary owed his home government. When a person went abroad for a time, his own state still possessed a right to his allegiance. He continued under the obligations of his home allegiance, and his children, though born in a foreign country, were not born under foreign allegiance. Although he owed a partial and temporary allegiance to his host nation, he was excused from military service and other obligations distinctively associated with natural allegiance because he owed a prior and more binding allegiance to his own sovereign. Domicile was for that reason typically a prerequisite to, among other things, compulsory service in the militia. And although America more than other nations supported the right to change that allegiance, it held that doing so required a change of domicile. Footnote 3. The court claims that the government and the dissent identify no source that defined allegiance at birth as being based on domicile in the period from 1776 to 1868. It is the court that focuses on allegiance, but in any event, many sources disprove the court's claim. Carrying on. Section C. When Dred Scott sued for his freedom, he claimed to be a citizen of Missouri, the state of his domicile. Scott, a black man held in slavery, sued in a federal court which could hear the case only if it was between citizens of different states. Scott argued that he was a citizen of Missouri and that the defendant, Sanford, was a citizen of New York. Scott, though, was not born in Missouri. He was born in Virginia but domiciled in Missouri. He alleged that he was a Missouri citizen because he and his family were brought there in 1838, where they have ever since resided. He argued that the term citizen described persons identified with the communities where they reside. In response to the argument that blacks could not vote and therefore were not citizens, Scott explained that a person need not have acquired all these rights it is only necessary that he should have acquired a domicile to enable him to sue as a citizen. Citizenship, Scott argued, in terms that would have been familiar at the time, means nothing but residence. Nobody disagreed with the premise that Scott was domiciled in Missouri. Black slaves and freedmen alike were unambiguously Americans. They were not foreigners. They were not aliens. They owed no foreign allegiance. It was the dissimilarity of American blacks to foreigners that Frederick Douglass emphasized in his call for recognizing the citizenship of blacks. We address you not as aliens nor as exiles, humbly asking to be permitted to dwell among you in peace. Instead, we are Americans. So speaking the same language and being of the same religion, worshiping the same God, owing our redemption to the same Savior, and learning our duties from the same Bible, Douglass reasoned, we shall not be treated as barbarians. American blacks were liable to perform all the duties and support all the obligations of citizens. They were domiciled in the United States, whether in slavery or in freedom. Dred Scott was therefore a citizen of Missouri. This court disagreed. It held that Scott was not a citizen of Missouri and therefore could not sue as a citizen because of his race. According to the court, blacks could not be citizens because they were considered as a subordinate and inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. As a result, this court said, blacks were denied the basic privileges of citizenship, including the right to keep and carry arms wherever they went and to exercise the full liberty of speech in public and in private. They could not sue in federal court as state citizens. Justices McLean and Curtis dissented. Justice McLean would have ruled that Scott was a citizen of Missouri because he had a permanent domicile in the state. As he stated the law of citizenship, being a freedman and having his domicile in a state different from that of the defendant, he is a citizen. Likewise, Justice Curtis took the position, common at the time, that national citizenship was simply based on state citizenship. He said that birthplace alone is not sufficient to be a national citizen, but that a person must be born here and a citizen of a state. Those persons born within the several states who are citizens of the state are thereby citizens of the United States. State citizenship, of course, was based on domicile. Justice Curtis thus agreed that Scott was a citizen of Missouri. Critics of the Dred Scott decision consistently took the position that citizenship should be based on birth and domicile regardless of race. Domicile, after all, was colorblind. In the words of Representative John Bingham of Ohio, soon to become a central figure in the crafting of the 14th Amendment, all free persons born here and domiciled within the jurisdiction of the United States are citizens of the United States from birth. Blacks such as Dred Scott called America home, so they were citizens despite having been subordinated based on their race. As Representative Schellebarger would explain, persons of African descent whose ancestors were slaves were entitled to citizenship because they were domiciled in our own country and continue to here reside. Likewise, Representative Philemon Bliss condemned Dred Scott and explained that all persons born here were citizens regardless of their race, except for children born to temporary sojourners. Chief among the critics of Dred Scott was Abraham Lincoln. Soon after the court released the decision, Lincoln declared that the Dred Scott decision is erroneous and did obvious violence to the plain, unmistakable language of the Declaration of Independence. The case exacerbated national division over the issue of slavery and contributed to Lincoln's election as president. Lincoln vowed not to acquiesce in it as a precedent, but instead to do what we can to have it overruled. During the Civil War, Union officials continued to define citizenship based on birth and domicile. Lincoln's Attorney General, Edward Bates, wrote that the place of birth was prima facie evidence of citizenship, a rule that corresponded with the familiar rule that place of birth was prima facie evidence of domicile. The Lincoln administration deemed persons citizens if they were born and domiciled in the United States. Congress's discussion of who could be subject to a wartime conscription law focused on the distinction between temporary sojourners and those who settled here with the intention of making their home here. Only the latter were fully and completely subject to the law. For the purposes of conscription, children of foreigners born here were American citizens if permanently domiciled in the United States and could avoid conscription if their parents have not established a long-term residence in the United States. Footnote 4. This is just a number of citations to that effect, so I'm not going to read them all out. Carrying on. Even at a memorial service for Lincoln, prominent statesman George Bancroft confirmed that everyone born on American soil, with the few exceptions of the children of travelers and transient residents, owes it a primary allegiance. Section D. After the Civil War, Congress vindicated Lincoln's vow to overrule Dred Scott, first with the Civil Rights Act, then with the Citizenship Clause of the 14th Amendment. Subsection 1. Congress enacted the Civil Rights Act of 1866 to repudiate Dred Scott. The Civil Rights Act of 1866 confirmed that former slaves were citizens, but it did not extend citizenship to foreign temporary visitors or Indians who were still within their tribes. Subsection A. The Civil Rights Act guaranteed citizenship only to persons born here and not subject to any foreign power. In full, the citizenship provision of the Civil Rights Act, which formed the basis for the citizenship clause at issue in this case, stated, quote, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, end quote. Temporary visitors domiciled in a foreign country remained subject to a foreign power. The Civil Rights Act therefore intentionally excluded children of foreign temporary visitors. The congressional debates were clarifying on this score. When Senator Trumbull introduced the Civil Rights Act's citizenship provision, he stated that the language excluded persons temporarily resident in the United States, whom we would have no right to make citizens. He had considered limiting the Civil Rights Act's citizenship provision to persons owing allegiance to the United States, but he abandoned that terminology because temporary visitors owed a partial allegiance to the United States, and he wanted to make clear that the act excluded them. Likewise, when Representative James Wilson spoke in support of the act in the House, he explained that every person born in the United States is a natural-born citizen, except, it may be, children born on our soil to temporary sojourners. Others confirmed that the Civil Rights Act excluded the children of temporary visitors. Representative Bingham described the Civil Rights Act as simply declaratory of pre-existing law, which he had already explained required that a citizen be both born and domiciled in the United States. Bingham understood the act to grant citizenship only to children of parents not owing allegiance to any foreign sovereignty. Representative Martin Thayer agreed that the act required that a person not owe allegiance to a foreign power. Of course, temporary visitors and their children owed allegiance to their home country. Unsurprisingly, then, the public interpreted the act to guarantee citizenship to all persons born in the United States except those subject to foreign governments, a class which included those born to foreign parents temporarily sojourning in this country. Subsection B. The Civil Rights Act also excluded from citizenship Indians not taxed. This provision was intended to exclude Indians in tribes, but to recognize the citizenship of Indians who had left those tribes and joined the body politic. In Senator Trumbull's words, it excluded Indians who belonged to the Indian tribes, but it included Indians who were no longer connected with their tribes and instead lived and earned a livelihood in the white settlements. Tribal Indians were considered virtually as foreigners, but whenever they were separated from those tribes and came within the jurisdiction of the United States so as to be counted, they were citizens of the United States. Like temporary visitors, tribal Indians were not completely subject to the jurisdiction of the United States. The United States did not have the right to impose personal taxes on them, hence Indians not taxed. Their personal affairs remained subject to the jurisdiction of their tribal nation. The right of self-government was secured to each tribe with jurisdiction over all persons and property within its limits, subject to certain exceptions, founded on principles somewhat analogous to the international laws among civilized nations. The United States did not interfere with the disposition or descent or tenure of their property as between themselves, or prove their wills, or subject them to the laws of marriage and divorce, or subject them to the laws of the United States against high treason. tribal Indians did not owe the United States primary allegiance and did not receive from it complete protection. Indians in tribes were not covered by the Civil Rights Act's exclusion of persons subject to any foreign power because Indian tribes were not foreign, they were domestic dependent nations. Thus, to preserve the status quo that tribal Indians were not citizens, Congress used the clause not subject to any foreign power, excluding Indians not taxed. Subsection 2. Although the Civil Rights Act, by its terms, overruled Dred Scott, the Reconstruction Congress could not be sure that it would endure. Some questioned whether Congress had the constitutional power to enact the Civil Rights Act, and thus feared that a hostile court might neuter it. Others worried that as soon as the Democrats came into power, they would repeal the act. Thus, when it passed the Civil Rights Act, the Reconstruction Congress was already drafting the 14th Amendment. 2 months later, Congress would formally propose the Citizenship Clause of the 14th Amendment to the states. The states ratified the amendment in 1868. The Citizenship Clause of the 14th Amendment constitutionalized the Civil Rights Act's citizenship provision. The main object of the clause was to settle the citizenship of freed slaves. In full, the Citizenship Clause provided, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, end quote. This language, all agreed, unambiguously overruled this court's contrary holding in Dred Scott v. Sanford that the Constitution did not recognize Black Americans as citizens of the United States or their own state. The Citizenship Clause forever closed the door on Dred Scott and constitutionalized the Civil Rights Act of 1866 by foreclosing a racial criterion for citizenship. The Citizenship Clause did not change the Civil Rights Act's rule. The clause and the act were passed by the same Congress during the same session. Senator Howard, who proposed the Citizenship Clause, believed that it hardly warranted discussion because Congress had just enacted the same rule in the Civil Rights Act. The Senate had so fully discussed the question of citizenship as not to need any further elucidation. He also stated that the Citizenship Clause is simply declaratory of what I regard as the law of the land already. Senator Trumbull, who had introduced the Civil Rights Act's citizenship provision, confirmed that the object to be arrived at is the same. Senator Johnson had no doubt that all that this amendment provides is that all persons born in the United States and not subject to some foreign power are citizens of the United States. To be a citizen, Senator Howard said, meant to be not a subject of a foreign power. The phrase subject to the jurisdiction was a familiar way to describe the relation of a domiciliary to his home nation. Lawyers in America would have known that a person was subject to the jurisdiction of the place of his domicile. Congressmen confirmed that the clause should not be construed to refer to the bare territorial power that a sovereign exercises over all persons in its territory. I understand the words here, subject to the jurisdiction of the United States, Senator George Williams said, to mean fully and completely subject to the jurisdiction of the United States. The word jurisdiction, as here employed, Senator Howard explained, ought to be construed so as to imply a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. The Citizenship Clause, Senator Trumbull agreed, means subject to the complete jurisdiction thereof. So, although in one sense all persons born within the geographical limits of the United States are subject to the jurisdiction of the United States, Senator Williams explained, some were not covered by the Citizenship Clause because they are not subject to the jurisdiction of the United States in every sense. Each of these descriptions precluded applying the Citizenship Clause to the children of temporary visitors who, unlike children domiciled here, were not subject to the jurisdiction of the United States in every sense. It was on this basis that congressmen believed that the clause fixed in place the rule of the Civil Rights Act. Senator Trumbull stated that the Citizenship Clause, like the Civil Rights Act, would still exclude all persons subject to a foreign power. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else, that is what it means. Senator Howard agreed that the Citizenship Clause would not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. And shortly before the Citizenship Clause was introduced, Senator William Fessenden, a supporter of the amendment, explained that persons may be born in the United States and not be citizens of the United States, then gave the example of a person who was born here of parents from abroad temporarily in this country. The Citizenship Clause, just like the Civil Rights Act, also excluded from citizenship the children of tribal Indians, meaning Indians whose tribes retained sovereign authority over them. Certainly, Senator Howard said, gentlemen cannot contend that an Indian belonging to a tribe, although born within the limits of a state, is subject to this full and complete jurisdiction. As Senator Trumbull saw it, tribal Indians were excluded because they, like temporary visitors, retained a primary allegiance to and therefore were subject to their tribal nation. It cannot be said of any Indian who owes allegiance, partial allegiance if you please, to some other government that he is subject to the jurisdiction of the United States. He concluded it is only those persons who come completely within our jurisdiction who are subject to our laws that we think of making citizens. Congress was satisfied that its language accomplished that result with the phrase subject to the jurisdiction thereof. As Senator Williams explained, I would not agree to this proposed constitutional amendment if I supposed it made Indians not taxed citizens of the United States, but I am satisfied that, giving to the amendment a fair and reasonable construction, it does not. The Citizenship Clause used different wording from the Civil Rights Act only to resolve an uncertainty that had arisen out of the Act's Indians not taxed language. Senator Trumbull explained that the category of Indians not taxed was an attempted proxy for the Indians over whom the United States lacked complete jurisdiction. The Civil Rights Act was supposed to designate a class of persons who were not part of our population, so it was supposed to exclude tribal Indians while including Indians who come within the jurisdiction of the United States. The former could not be taxed in the sense of personal taxes, but the phrase excluding Indians not taxed, Trumbull realized, could be misunderstood to encompass Indians who had left their tribal community and permanently settled outside of it, but were not taxed for other reasons, such as because they were not possessed of wealth. Similarly, making citizenship depend on taxation could allow states to manipulate citizenship eligibility by changing their tax practices. The phrase subject to the jurisdiction solved the problem because it avoided excluding from citizenship the children of non-tribal Indians who, for whatever reason, were not taxed. Tribal Indians were not in any sense subject to the complete jurisdiction of the United States. Like temporary visitors, tribal Indians were not subject to our jurisdiction in the sense of owing allegiance solely to the United States. Their internal affairs, including marriages, family matters, intestacy, and payment of personal taxes, were regulated by their tribes. Thus, members of Congress understood the 14th Amendment's language to be more precisely describing, not substantively altering, the set of individuals excluded from birthright citizenship by the Civil Rights Act. With respect to temporary visitors from foreign nations, the phrase was believed to accomplish the same object as the Civil Rights Act's exclusion of those subject to a foreign power. Children born to temporary visitors owed allegiance to another government, the country of their domicile, so they were not subject to the jurisdiction of the United States. The Citizenship Clause simply states in positive terms, subject to the jurisdiction thereof, what the Act stated in negative terms, not subject to any foreign power. Section E, subsection 1. The evidence from the decades following ratification confirms that the Citizenship Clause was understood to exclude the children of temporary visitors. There was a frequently expressed, enduring, and widespread agreement from the Reconstruction Congress through the end of the 19th century and even into the 20th that the Citizenship Clause did not guarantee citizenship to persons not domiciled here. The executive branch, Congress, courts, states, lawyers, scholars, and commentators generally shared this understanding. Subsection A. The executive branch understood the Citizenship Clause to exclude the children of temporary visitors. In 1873, President Grant's Attorney General George Williams interpreted it to apply only to persons over whom the United States had complete jurisdiction. The word jurisdiction must be understood to mean absolute or complete jurisdiction, such as the United States had over its citizens before the adoption of this amendment. It therefore excluded aliens over whom the United States had only a limited jurisdiction, even if they were born here. Footnote 5. This interpretation was shared by Ebenezer Orr, a prior Attorney General for President Grant. Orr, too, believed that under the Citizenship Clause, a child born within the United States of parents who are not citizens is not himself a citizen unless domiciled in the United States. Carrying on. Across administrations, the executive branch took the same position. A child born on American soil was not an American citizen when he was domiciled in a foreign country. By virtue of his foreign domicile, he was, on his birth, subject to a foreign power and not subject to the jurisdiction of the United States. A child born in this country to a foreign father, when taken by his father abroad, acquires the father's domicile and nationality. These statements were not mere abstract positions, but the executive branch's operating rule of decision for decades. When the children of temporary visitors born on American soil claimed to be citizens based on the Citizenship Clause, the executive branch repeatedly denied their claims to citizenship. Joseph Speck was denied citizenship after being born in the United States to parents domiciled in Switzerland. In 1878, Speck claimed to be a citizen after his father returned with him to Switzerland. President Hayes's acting Secretary of State, Frederick Seward, rejected his claim. Although Speck may have been able to claim citizenship had he been domiciled in the United States, Seward denied his claim because his status, as well as his domicile, according to the well-understood principles of international and municipal law, follows that of the father until the boy attains his majority. Ludwig Hausdig was denied citizenship after being born in the United States to parents domiciled in Saxony. Hausdig's parents were Saxon subjects temporarily in the United States. President Cleveland's Secretary of State, Frederick Frelinghuysen, explained in 1885 that Hausding was not constitutionally entitled to citizenship. Because Hausding's parents were not domiciled here, he remained subject to any foreign power. Therefore, his attempt to assert citizenship on the ground of birth in the United States was untenable. Richard Greiser was denied citizenship after being born in the United States to parents domiciled in Germany. He was born in 1867 in the state of Ohio. His father was domiciled in Germany. According to President Cleveland's Secretary of State, Thomas Bayard, in 1885, Greiser therefore was on his birth subject to a foreign power and not subject to the jurisdiction of the United States. He was not, therefore, under the statute and the Constitution, a citizen of the United States by birth. The State Department thus denied Greiser's claim to citizenship. Friedrich de Bury was denied citizenship after being born in the United States to parents domiciled in Austria. When de Bury sought protection as an American citizen in 1886 after returning to Europe, Secretary Bayard denied his claim to citizenship. Although de Bury was born in the city of New York, Secretary Bayard explained, his parents were temporarily resident and returned to Europe a few years later. He then remained in Europe, showing that an Austrian domicile was chosen. Secretary Bayard concluded that de Bury's passport must therefore be refused. The child of a woman named Mary Devereux was denied citizenship after being born in the United States in 1889. Devereux was an Irish woman who arrived in New York and promptly went to the hospital to give birth the next day. She was not yet, however, lawfully admitted to the country. Although the baby was undoubtedly born on American soil, it was not an American citizen because Devereux had not yet been lawfully admitted. President Harrison's administration denied the baby citizenship. I am, therefore, of the opinion that the child in controversy, born during the temporary removal of the mother from the importing vessel to a laying in a hospital for her own comfort, pending further examination as to whether she belongs to the prohibited class of immigrants, did not become, by reason of its birth, under such circumstances, an American citizen. These children were not born to diplomats. They were not part of invading armies or Indian tribes. They were simply foreigners born on American soil but not domiciled here. And they were all denied citizenship under the Citizenship Clause by those in a better position to know its original meaning than we are today. Footnote 6. Sometimes, children born to lawful foreigners could elect one allegiance and repudiate the other upon reaching full age by becoming domiciled in the United States. But they were not guaranteed citizenship by birth alone, and they were not guaranteed citizenship without domicile. Carrying on. Even the most expansive executive interpretation of the Citizenship Clause ultimately denied citizenship to a child born here but domiciled abroad. When Francois Heinrich, born of parents who ultimately returned to their native Austria, claimed to be an American citizen, President Grant's executive branch did say that he was originally clothed with American nationality, but it then promptly denied Heinrich's claim to American citizenship. Heinrich was instead, despite being born in the United States, a citizen of Austria, where he was domiciled. Francois A. Heinrich should be held by the United States to be an Austrian subject and treated as such. He is not an American citizen. Subsection B. Congress understood the Citizenship Clause to exclude the children of temporary visitors. Just 2 years after the 14th Amendment was ratified, Congress passed the Enforcement Act of 1870. The act implemented the Citizenship Clause with the same language that the Civil Rights Act had used, limiting the right of citizenship to persons born here and not subject to any foreign power. The 1870 Act thus incorporated language that expressly excluded the children of temporary foreign visitors who were subject to the power of the foreign countries in which they were domiciled. If the Citizenship Clause included the children of temporary visitors who clearly fall outside the reach of the Enforcement Act, then the Reconstruction Congress would have violated its own Citizenship Clause in an act designed to enforce it. The parties point to no one who suggested that the 1870 Act was unconstitutional. Subsection C. This court long agreed that the Citizenship Clause did not apply to persons born here to children of temporary visitors. Just 5 years after the Citizenship Clause was ratified, this court explained that the phrase subject to the jurisdiction excluded persons not domiciled here. The phrase subject to its jurisdiction, the court explained, was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the United States. Then in Elk, the court again interpreted the clause to require complete jurisdiction, not just bare territorial authority. The court held that to satisfy the Citizenship Clause, a person must not only be born within the territorial limits of the United States, but must be completely subject to the United States' political jurisdiction at birth. The Citizenship Clause's evident meaning, the court said, is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to its political jurisdiction and owing it direct and immediate allegiance. The Citizenship Clause thus granted citizenship at birth only to persons who owed no allegiance to any foreign power. Of course, the children of temporary visitors were not completely subject to the United States' political jurisdiction, did not owe the United States direct and immediate allegiance, and did owe allegiance to an alien power. Justice Harlan dissented in Elk, but he agreed that the Citizenship Clause referred to the same complete jurisdiction. He dissented only because he thought that someone born in the territorial United States could become a citizen even if he became subject to its complete jurisdiction later in life. On Justice Harlan's view, which was not uncommon at the time, the Citizenship Clause did not require that the person be born while subject to the complete jurisdiction of the United States. Instead, a person could be born in the United States while not subject to its jurisdiction, as John Elk was because he was a member of an Indian tribe at birth, but become subject to its jurisdiction later, as Elk did by abandoning his tribe. On Justice Harlan's view, following the law of domicile, persons became subject to the jurisdiction of the United States by becoming bona fide residents of states and subject to taxation there. Every justice in Elk thus agreed that the Citizenship Clause did not refer to bare territorial authority. The most celebrated 14th Amendment opinion is Justice Harlan's dissent in Plessy v. Ferguson. In that dissent, Justice Harlan disagreed with the Plessy Court's conclusion that the Constitution tolerated state-imposed segregation. Justice Harlan took the position, to be vindicated decades later, that our Constitution is colorblind and neither knows nor tolerates classes among citizens. He also took a view on whom the Citizenship Clause applied and did not apply to. According to Justice Harlan, the Citizenship Clause did not apply to persons born here who resided abroad. Instead, it gave citizenship to all born or naturalized in the United States and residing here. Subsection D. State officials likewise agreed that the Citizenship Clause excluded persons not domiciled here. Although the Citizenship Clause guaranteed both national and state citizenship, states excluded from citizenship children of transient aliens. Nobody seemed to suggest that these state laws violated the 14th Amendment. Likewise, state judicial precedent held that the Citizenship Clause included children born of foreign parents only when the parents are domiciled here. To qualify for citizenship, two facts must concur. The person must be born here, and he must be subject to the jurisdiction of the United States according to the 14th Amendment, which means, according to the Civil Rights Act, that the person born here is not subject to any foreign power. The Citizenship Clause thus accepted those born in this country of foreign parents who are temporarily traveling here. Subsection 2. Scholars agreed as well that the Citizenship Clause required domicile. As early as 1875, Yale Law School professor William Robinson wrote that a native-born citizen was one who was born within the jurisdiction and allegiance of the United States. And to be born within the jurisdiction and allegiance of the United States, a person born within the territory of the United States of alien parents had to show that those parents were permanently domiciled within the United States. A long list of eminent 19th century legal scholars, including Thomas Cooley, Francis Wharton, Henry Campbell Black, and Justice Samuel Miller, agreed. Cooley wrote that a citizen by birth must not only be born within the United States, but he must also be subject to the jurisdiction thereof, and by this is meant that full and complete jurisdiction to which citizens are generally subject, and not any qualified and partial jurisdiction, such as may consist with allegiance to some other government. Francis Wharton explained that children born in the United States of parents not being here domiciled are not citizens. Henry Campbell Black of Black's Law Dictionary wrote, "If a stranger or traveler passing through the country or temporarily residing here has a child born here who goes out of the country with his father, such child is not a citizen of the United States because he was not subject to its jurisdiction." By contrast, the children born within the United States of permanently resident aliens are citizens. And Justice Samuel Miller confirmed in his lectures on constitutional law that if a traveler temporarily residing in this country has a child born here which goes out of the country with its father, such child is not a citizen of the United States because it was not subject to its jurisdiction. Scholar after scholar confirmed that domicile was required for citizenship. The words "subject to the jurisdiction thereof" excluded the children of foreigners transiently within the United States. A. Morse, Treatise on Citizenship. The Citizenship Clause excluded the children of foreign subjects born while the latter transiently sojourn here. M. Lesser, Citizenship and Franchise. The children of foreigners in transient residence are not citizens, their fathers being subject to the jurisdiction less completely than Indians. Hall, The Foreign Power and Jurisdiction of the British Crown. The requirement of personal subjection to the jurisdiction thereof excludes children of persons passing through or temporarily residing in this country. B. Winchester, Citizenship in its International Relation. As immigration laws became more restrictive, some adopted the view that children must be born to citizens to obtain citizenship by birth. In contesting that view, its detractors spoke in terms of domicile. Prominent jurist Henry C. Ide, for example, published an article arguing that whether the very fact of birth in our country renders one subject to the jurisdiction thereof depends on the question of domicile. The jurisdiction referred to in the amendment means political national jurisdiction and not merely the jurisdiction of our laws. One born of parents temporarily in the country is not constitutionally guaranteed citizenship because he is not born with the stamp of domicile, so the elements of national jurisdiction are wanting. By contrast, Ide contended, persons domiciled but not naturalized are de facto, though not de jure, citizens of the country of their domicile, so their children should be deemed de jure as well as de facto citizens. Footnote 7. Throughout this time, Indians in tribes born on American soil continued to be viewed as non-citizens. Their citizenship evolved not through any changes to the interpretation of the Citizenship Clause, but through changes in statutory law. Congress in 1887 effectively adopting Justice Harlan's dissent in Elk v. Wilkins as a matter of policy granted citizenship to every Indian born within the territorial limits of the United States who has voluntarily taken up, within said limits, his residence separate and apart from any tribe of Indians therein, and has adopted the habits of civilized life. And Congress declared Indians in tribes citizens in the 1924 Indian Citizenship Act. Carrying on. Subsection 3. In United States v. Wong Kim Ark, this court interpreted the citizenship clause to apply to a person born and domiciled here. The case and the arguments made in it arose out of the unique circumstances of Chinese immigration in the late 19th century. Hundreds of thousands of Chinese immigrated to the United States during this time. They were met with considerable hostility. By statute, Chinese settlers could not be naturalized. Congress then banned Chinese immigration in the Chinese Exclusion Act of 1882. Meanwhile, if a Chinese person renounced his allegiance to China, the Chinese government could behead him upon his return, sell his family as slaves, and banish his relatives. Given the era's concern with dual citizenship, this policy made it even more difficult for Chinese immigrants to fully settle in the United States. Unlike other settlers then, the Chinese, even those who lived here and wished to remain, had no path to citizenship and no means of freeing themselves from the grasp of China. The executive branch took the view that because domicile no longer ensured full integration into the American body politic, the citizenship clause's phrase subject to the jurisdiction must require more than domicile. That view would entail that a child born to Chinese parents domiciled in this country was not a citizen. Instead, the executive branch sought to replace the requirement of domicile, which would make any child of domiciled Chinese immigrants a citizen, with the requirement that a person's parents already be citizens. Acting on this view, the government in 1895 denied citizenship to a man domiciled in the United States from birth. The stipulated facts were these. Wong Kim Ark was born in San Francisco in 1873 and his legal home was California. His parents were not temporary visitors. They were not illegal aliens. Instead, Wong's parents had done everything within their power to express their desire and intent to become Americans. They came to settle in America. After Wong traveled to China in 1890, he returned and was admitted to the United States as a citizen. But after his second trip to China in 1894, the American customs collector denied him permission to re-enter. The government claimed for the first time that Wong was not a citizen. This court's decision in Wong Kim Ark concerned only persons already domiciled in the United States. As stated in the government's brief, the question presented by this appeal was, is a person born within the United States of alien parents domiciled therein a citizen thereof by the fact of his birth? The government agreed that Wong was born and domiciled in the United States. In fact, the thrust of the government's opening brief was that birth and domicile were insufficient. The government lamented the mistakes made and the misunderstanding arising from failing to distinguish between nationality and domicile. It disapproved of the decisions of some of our attorneys general and secretaries of state for their error of failing to distinguish between nationality and domicile. It acknowledged that state citizenship was based on domicile, but argued that a different rule should govern national citizenship to preserve the distinction between state and national sovereignty. The Constitution does not countenance, the government argued, making domicile an element of nationality. The court was not persuaded and ruled that Wong, born in the United States to parents domiciled here, was a citizen. The court found it so important that Wong and his parents were domiciled in the United States at the time of his birth that it gratuitously insisted upon that fact throughout its opinion. The court's introductory paragraph stated 7 different ways that Wong was domiciled in the United States. He was born to parents who were at the time of his birth domiciled residents of the United States. His parents were enjoying a permanent domicile and residence therein at San Francisco. His parents continued to reside and remain in the United States. He, ever since his birth, has had but one residence, to wit, in California, within the United States. He had there resided. He never lost or changed that residence, and he never gained or acquired another residence. 2 paragraphs later, the court confirmed that its decision was limited to persons born and domiciled in the United States. The question presented by the record is whether a child born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China but have a permanent domicile and residence in the United States becomes, at the time of his birth, a citizen of the United States. Then, if that were not enough, the court reiterated the same limits to its opinion in its final paragraph. This case presented for determination the single question stated at the beginning of this opinion, namely, whether a child born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China but have a permanent domicile and residence in the United States becomes, at the time of his birth, a citizen of the United States. The opinion itself was filled with meandering dicta. The court's interpretation of the citizenship clause evolved over the course of the opinion before landing on an interpretation that limited citizenship at birth to persons domiciled here. At first, the opinion stated that the rule of American citizenship was the feudal principle of birth on the soil with only 2 exceptions. 1, the child of an ambassador or other diplomatic agent of a foreign state, and 2, the child of an alien enemy in hostile occupation. Then, after considering more evidence and arguments, the opinion reformulated the rule to include a 3rd exception. 1, children of members of the Indian tribes, 2, children born of alien enemies in hostile occupation, and 3, children of diplomatic representatives of a foreign state. Then, after discussing more considerations and authorities, the opinion formulated the rule with at least 5 exceptions and a residence requirement. All children born of resident aliens, with the exceptions or qualifications of 1, children of foreign sovereigns, 2, children of foreign ministers, 3, children born on foreign public ships, 4, children of enemies within and during a hostile occupation of part of our territory, and 5, children of members of the Indian tribes owing direct allegiance to their several tribes. Then the court concluded by reiterating an explicit domicile requirement. Outside of these 5 categories, the citizenship clause covers all other persons of whatever race or color domiciled within the United States. So although these various statements are both dicta and irreconcilable, as is much of the opinion's reasoning, the court's most complete rule statement was limited to persons like Wang born and domiciled in the United States. Chief Justice Fuller's dissent, joined by Justice Harlan, did not accept the government's primary theory that, to qualify for birthright citizenship, a child born in this country must also be born to citizen parents. Such a position, after all, was in tension with Justice Harlan's twice-stated view that the citizenship clause turned on complete jurisdiction, or residence, 2 terms that corresponded to domicile. Chief Justice Fuller's dissent instead took the position that the citizenship clause recognized an essential difference between birth during temporary and birth during permanent residence. On his account, the citizenship clause excluded children born of aliens whose residence was merely temporary. Chief Justice Fuller nonetheless dissented because he rejected the premise that Wang's parents were domiciled here at the time of his birth. He explained that because Chinese law purported to bind Wang's family even after they had settled here, the family cannot acquire a permanent home here no matter what the length of their stay might be. Thus, Chief Justice Fuller and Justice Harlan dissented because, in their view, Wang and his parents were not actually domiciled in the United States at the time of his birth. Subsection 4. Wang Kim Ark left in place the same rule that existed before. A child of a domiciliary was a citizen, but a child of a temporary visitor was not. The effect of Wang Kim Ark, a legal scholar explained shortly after it was published, is to make citizens of the United States by virtue of the 14th Amendment all persons born in the United States of parents permanently domiciled and residing here. As a 14th Amendment treatise published in 1901 explained, it remained the case that mere birth within American territory does not always make a child an American citizen. The citizenship clause excluded children of aliens born here while their parents are traveling or only temporarily resident. Wang Kim Ark was limited to alien parents not temporarily resident here but permanently domiciled. On this understanding of Wang Kim Ark, temporary visitors' children were still excluded from citizenship. In the United States, William Edward Hall wrote 6 years after Wong Kim Ark, "It would seem that the children of foreigners in transient residence here are not citizens." A 1901 international law treatise explained that children born in the United States to foreigners here on transient residence are not citizens because by the law of nations they were not at the time of their birth subject to the jurisdiction of the United States. When a father has domiciled himself in the Union, John Westlake wrote in 1904, his children are citizens. But when he is in the Union for a transient purpose, his children born within it have his nationality. This understanding was widespread after Wong Kim Ark. A person born in this country of alien parents was a citizen only if those parents were domiciled. A child born in the United States is a citizen when domiciled, but not when his parents left after being temporarily resident. A child born on American soil to a stranger or traveler passing through the country was not a citizen, but a child born within the United States of permanently resident aliens was a citizen. The rule remained, in other words, that children of foreigners in transient residence were excluded from citizenship even though born in the United States. Government officials generally agreed. In 1910, a Department of Justice report explained that it has never been held, and it is very doubtful whether it ever will be held, that the mere act of birth of a child on American soil to parents who are accidentally or temporarily in the United States operates to invest such child with all the rights of American citizenship. The Citizenship Clause did not mean that jurisdiction to which the bodily form of the child is subject from the moment of its birth, but that larger jurisdiction which, though difficult to define, is well known and understood, the difference between the jurisdiction which is exercised over a visitor and that over one domiciled, which difference may be seen at a glance. Even this court described Wong Kim Ark in limited terms. It read Wong Kim Ark to apply to aliens with a permanent domicile and residence in the United States. Wong Kim Ark, in its telling, covered children born to parents permanently domiciled in the United States. Subsection 5. Throughout this period, Congress left in place the same statutory language that it originally enacted in 1866 and then reenacted in 1870, so American citizenship was limited to persons not subject to any foreign power. The Nationality Act of 1940 replaced that language with the same language in relevant part as the Citizenship Clause itself. A person born in the United States and subject to the jurisdiction thereof is a citizen. Congress reenacted that provision verbatim in the 1952 Immigration and Nationality Act, INA. It remains the governing statute today. Section F, subsection 1. In the 20th century, executive practice repurposed the Citizenship Clause to treat the children of temporary visitors and illegal aliens as citizens. An assistant solicitor named Richard Flournoy prominently argued that the Citizenship Clause does include the children of temporary visitors. He disagreed with a number of writers who held that in order that a person born in the United States of alien parents may have American citizenship, his parents must have been domiciled in this country at the time of his birth. Although he acknowledged that Wong Kim Ark did not directly decide the precise point, he said that the Citizenship Clause should be read to incorporate a rule that originated with the feudal system under which all persons, with certain limited exceptions, born within the fief of an overlord, were held to owe fealty to him and allegiance to the sovereign. Flournoy acknowledged that some consequences of his theory were absurd. President Franklin D. Roosevelt's administration adopted the view that the Citizenship Clause applied to the children of temporary visitors. In 1995, some 127 years after the Citizenship Clause was enacted, President Clinton's Office of Legal Counsel endorsed the same view. It explained that the right to American citizenship for the children of illegal aliens and temporary visitors is fundamental to our liberty as we understand it. Many in Congress disagreed with the executive branch's view. As late as the 1990s, Senator Harry Reid sponsored bipartisan legislation to clarify that the child of an illegal alien or temporary visitor would not be a citizen of the United States or of any state solely by reason of physical presence within the United States at the moment of birth. No sane country, Senator Reid argued, would offer a reward for being an illegal immigrant. Others supported similar legislation. The question was not prominent in judicial opinions in the 20th century. One of the first substantial discussions arose 105 years after Wong Kim Ark, when Judge Posner treated the matter as unsettled. A constitutional amendment may be required to change the rule whereby birth in this country automatically confers U.S. citizenship, he wrote, but I doubt it. The purpose of the rule was to grant citizenship to the recently freed slaves, and it would not be flouting the Constitution to put an end to the nonsense. Subsection 2. Some took advantage of the executive branch's recent policy of granting citizenship to anyone born on American soil. The policy encouraged birth tourism, the practice of traveling here with temporary authorization solely to give birth and obtain citizenship for one's children, then returning to raise them in another country. Today, birth tourism companies reportedly collect large fees from wealthy foreigners to facilitate their trips to give birth in the United States. Large numbers of children are born in the United States each year to parents who are temporarily present here in order to obtain citizenship for their children. Section G, subsection 1. Upon taking office, President Trump issued an executive order that expressed the executive branch's interpretation of the Citizenship Clause. The Citizenship Order adopts the view that the 14th Amendment does not guarantee citizenship at birth to the children of temporary visitors and illegal aliens. Section 1 of the order interprets the scope of the Citizenship Clause. It states that someone born in the United States is not guaranteed citizenship if that person is born here to lawful, temporary foreign visitors or to illegal aliens. By contrast, a person is guaranteed citizenship if he is born here to lawful permanent residents or citizens. Section 2 of the order then directs the executive branch to implement this interpretation by not issuing documents recognizing the citizenship of persons in the two excluded categories and by not accepting documents issued by state, local, or other governments purporting to recognize the citizenship of such persons. Those directives are prospective. They apply only to persons who are born within the United States after 30 days from the date of this order. Section 3 of the order directs executive officials to implement the order with appropriate regulations, policies, and guidance. The President's initiative generated a groundswell of new scholarship into the original meaning of the Citizenship Clause. A wide range of originalist scholars have concluded that the 20th century executive practice was mistaken and that the order has substantial lawful applications. Subsection 2. Before the order went into effect or executive agencies implemented it, several district courts universally enjoined its implementation. Footnote 8. This is just a citation to a number of district court cases to that effect, so I'm not going to read them all out. Carrying on. This court partially stayed those injunctions in Trump v. Casa Inc. because they exceeded the district court's remedial authority. Several plaintiffs immediately filed new actions, and several district courts again enjoined the executive branch from implementing the order. Footnote 9. This is once again just citation to a number of cases to that effect, so I'm not going to read them all out. Carrying on. This case arises from one of those actions. 3 plaintiffs sued on behalf of a putative class. The plaintiffs, who proceed under pseudonyms, are each illegal aliens or lawful temporary visitors. The first plaintiff, a Honduran citizen, was expecting a baby due in October 2025. The other 2 plaintiffs, one Taiwanese citizen and one Brazilian citizen, did not allege that they were expecting a baby. None alleged that any of their children will be domiciled in the United States. As a right of action, plaintiffs invoked the Citizenship Clause itself, the INA, and the Administrative Procedure Act. They sued on behalf of a putative class of all children who would be ineligible for citizenship under the President's order, as well as those children's parents, and they sought to have the order declared unconstitutional and unlawful in its entirety. The district court ruled for the plaintiffs. It interpreted the Citizenship Clause to guarantee citizenship to the children of all lawful temporary visitors and illegal aliens. As to relief, the district court certified a provisional universal class under Federal Rule of Civil Procedure 23b2, which states that class actions may be maintained if the defendant has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief is appropriate respecting the class as a whole. The certified class consisted of all current and future persons born on or after February 20th, 2025, who fall within the 2 categories covered by the President's order. the district court entered a class-wide preliminary injunction prohibiting enforcement of the citizenship order against anyone in the class, meaning anyone at all. Subsection 3. The court today affirms the district court's universal class injunction. It holds that the 14th Amendment guarantees citizenship to all children born here to lawful temporary visitors or illegal aliens. On the court's telling, the law of citizenship in the United States was fixed to an English rule that everyone born on the soil was permanently bound to serve the sovereign. This principle of permanent feudal allegiance, according to the court, was repurposed into a rule of citizenship and adopted by all of the states. The rule's universal acceptance was embodied by an 1844 state equity decision called Lynch v. Clark. The rule extended citizenship to all persons born within the United States territory except three categories: children of foreign representatives, children over whom the government lacked actual power, and children of Indians in tribes. Those three exceptions were then adopted in the Civil Rights Act and the Enforcement Act by the phrase "not subject to any foreign power," and in the Citizenship Clause by the phrase "subject to the jurisdiction thereof." This court's Wong Kim Ark opinion 3 decades later, the court says, confirmed the same rule. Part 2. Before proceeding to the merits, I briefly note 3 threshold impediments to the court's decision today that the court leaves unaddressed. First, the court has an independent obligation to ensure that every single recipient of class action relief has standing. But today it affirms an injunction on behalf of a class that includes all current or future persons subject to the order indefinitely into the future. Second, the court cannot grant relief to any party without a right of action. But it grants relief here on the basis of a suit brought under the Citizenship Clause, the INA, and the APA. The Citizenship Clause and the INA's equivalent, by their terms, create no right of action. The APA authorizes suits challenging final agency action, but the plaintiffs did not allege any final agency action. Third, because respondents sought to invalidate the citizenship order in its entirety and the district court granted facial relief, the plaintiffs bear the burden to show that all applications of the order are unlawful. Under this court's precedent, facial challenges require plaintiffs to establish that no set of circumstances exist under which the order would be valid. To prevent federal courts from invading the political branch's interest in effectuating policies enacted by representatives of the people, facial invalidation must remain rare and hard to win. The court's decision to hold the citizenship order facially unconstitutional, in other words, makes it unlawful for the president to enforce the order against a single person. He cannot enforce the order against a child of an alien enemy or a child of a foreign spy. He cannot even enforce the order against children who are raised in foreign countries, join foreign armies, and fight wars against the United States. The court, without considering any of these individual circumstances, holds unconstitutional the application of the citizenship order in all of them. Part 3. In my view, the citizenship order is not facially unconstitutional. The order is consistent with the original meaning of the Citizenship Clause, at least insofar as it applies to children born to parents here lawfully or unlawfully who are not domiciled in the United States. The Citizenship Clause was enacted for people who were born in this country and called it home. It was enacted for freed slaves such as Dred Scott, who had a domicile here and therefore were entitled to sue as citizens. It was enacted for men such as Frederick Douglass, who demanded citizenship not as aliens nor as exiles, but as Americans. Its authors and supporters promised over and over again that it would exclude the children of persons temporarily resident here, whom we would have no right to make citizens. In Senator Trumbull's words, what do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. And for decades after ratification, it was interpreted by all 3 branches of government and by a wide range of legal authorities to be limited to people who were already Americans. The ordinary principles of constitutional interpretation, the ones on which this court typically relies when presented with a constitutional question such as this one, support the conclusion that the Citizenship Clause requires domicile. That conclusion is supported by the constitutional text, contemporaneous evidence, early executive practice, early legislative practice, judicial precedent, and all of the other indicators of original public meaning. The court's alternative account does not have a similar degree of support. The citizenship order is therefore, insofar as it applies to persons not domiciled here, consistent with the Citizenship Clause. It is consistent with the Citizenship Clause in its exclusion of the children of lawful temporary visitors such as birth tourists. The exclusion of the children of lawful temporary visitors, who are by definition not domiciled here, was originally a matter of widespread agreement. As to them, the citizenship order does exactly what the executive branch did for most of the rest of the 19th century, what this court said it could do, and what scholars for decades confirmed that it could do. And the order is at least facially consistent with the Citizenship Clause in its exclusion of the children of illegal aliens because at least some such persons are not domiciled here and therefore also are not citizens. Footnote 10. Because this case presents a facial challenge and no one disputes that lawful temporary visitors and some illegal aliens are not domiciled here, I would reserve for another day the question whether the children of illegal aliens can be domiciled here. The government and several scholars have suggested some reasons why they believe illegal aliens can never be domiciled here, and illegal aliens' entry and presence violate federal law. He is subject to potential removal at any time. And some authorities have suggested that domicile requires permission to remain. Therefore, when presented with variations on this question in other contexts, some courts have concluded that an alien who wishes to remain in the United States in violation of federal law cannot be domiciled here because he lacks the legal capacity to establish domicile. That said, many others understandably have suggested that long-term resident illegal aliens satisfy the elements of domicile because they reside here with the intent to permanently remain. As Justice Gorsuch explains, the children of such aliens may be domiciled here because they are born here to parents who have long chosen to make this nation their permanent home. Such questions are best resolved in the context of as-applied challenges. Carrying on. Section A. The constitutional text supports the conclusion that the Citizenship Clause requires domicile. Subsection 1. The Citizenship Clause guarantees citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. At the time that the Citizenship Clause was adopted, the phrase subject to the jurisdiction referred to the legal relationship that a person had to the government of his domicile. That legal relationship included the government's power over the domiciliary's personal affairs, power to regulate his conduct everywhere, and power to impose personal taxes on him. It also included the reciprocal relationship of protection abroad and primary allegiance. A government lacked the powers associated with this relationship and thus lacked complete jurisdiction over temporary visitors. Temporary visitors remained subject to the jurisdiction of their home country. Hence, a person was subject to the jurisdiction of the government where he was domiciled. This interpretation accords with contemporaneous evidence that would have informed the public meaning of the text. It is consistent with the Civil Rights Act's requirement that citizens be not subject to any foreign power. A person born in the United States to temporary visitors was subject to a foreign power, namely the power of his home country in which he retained his domicile. It is consistent with the early American law of state and national citizenship, which turned on domicile. It overrules Dred Scott because it restores the rule of decision under which Scott would have won, namely that he was entitled to sue as a citizen of Missouri because he had a permanent domicile in the state. It excludes tribal Indians because they remained first and foremost subject to their separate nations, which alone had complete jurisdiction over them. And it ensures that the freedmen, who were clearly American, would not be denied citizenship based on a racial caste system. Footnote 11. Some have asked whether freed slaves were domiciled here given that their ancestors were brought here against their wills. It was firmly established that freed slaves were domiciled here. Those who argue that blacks were not domiciled in the United States would have concurred in the judgment in Chief Justice Taney's opinion in Dred Scott, the outcome of which turned on whether Dred Scott was domiciled in Missouri. Carrying on. In other words, the phrase subject to the jurisdiction meant what the drafters and ratifiers said it meant: complete jurisdiction. Fully and completely subject to the jurisdiction of the United States. The jurisdiction of the United States in every sense. and a full and complete jurisdiction coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department. That is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States now. The phrase thus also had the implication that the drafters and ratifiers said it had. The children of temporary visitors were not citizens. The citizenship clause, they said, would not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers. After all, we would have no right to make citizens of persons temporarily resident in the United States. Subsection 2. The court's alternative theory is more difficult to square with the text. Subsection A. The court defines the phrase subject to the jurisdiction of the United States to refer to the power of the United States to govern those within its territory. It then says that at least 3 categories of persons born within United States territory are not subject to its jurisdiction. First, a person is not subject to the jurisdiction of the United States when the government impliedly waives its regulatory power over him. The court understands this category to exempt all children of representatives of foreign sovereigns, endeavoring to capture a long-standing principle that such children were not entitled to citizenship. Although the court gestures towards diplomatic immunity as a basis for this exception, diplomatic immunity extends to only a narrow set of diplomatic officials, not to all foreign representatives. Most foreign officials receive a partial immunity, such as immunity for their official acts. But partial immunity cannot render a person not subject to the jurisdiction of the United States for 14th Amendment purposes. After all, a variety of clearly American government officials, such as judges, prosecutors, and police officers, have similar partial official immunity. Footnote 12. This is just a number of citations to that effect, so I'm not going to read them all out. Carrying on. Furthermore, if the political branches can deny someone citizenship by waiving their regulatory power over him, then they can deny citizenship to any child in America, even if his family has lived here for generations and has no other home. The better explanation for excluding the children of foreign representatives is that they were not domiciled in the United States. Footnote 13. Diplomats and other foreign officials were likely mentioned specifically in accounts of the scope of citizenship for another reason. They shared much in common with domiciliaries. They were often not transient visitors, but instead stayed in the country for long, indefinite periods and were likely to have and raise children here, but the law treated them uniquely and presumed that they were not domiciled, regardless of the duration of their residence. Carrying on. Second, the court says a person is not subject to the jurisdiction of the United States when the government lacks actual power over him. This category presumably is an attempt to accommodate the consensus that citizenship would not have been granted to the children of foreign invaders. But while the child of a foreign invader is of course not constitutionally entitled to citizenship, it is not because America lacks actual power over him. If it were, then citizenship could be denied to any American over whom the government happened to lack actual power at birth. The more likely reason why foreign invaders are not citizens is that they too are foreign and not domiciled here. Third, the court says, a person is not subject to the jurisdiction of the United States when he is a member of an alien and sovereign nation. This category reflects the court's attempt to accommodate the historical record that the citizenship clause excluded the children of Indians in tribes, but the court cannot explain why tribal Indians were not subject to the jurisdiction of the United States if they happened to be born outside Indian lands while foreign temporary visitors were. It is true that tribal Indians belonged to alien and sovereign nations and that the United States' relations with them implicated inter-sovereign concerns. But temporarily visiting foreigners also belong to alien and sovereign nations, and the United States' relations with them also implicate inter-sovereign concerns. It is difficult to understand why China, for example, would be less alien or less sovereign than the Cherokee nations. It is also difficult to understand why tribal Indians would be less entitled to American citizenship if born on non-Indian land within the United States than children of birth tourists who immediately returned to China. Subsection B. The court's definition also cannot be reconciled with the contextual evidence that would have informed the meaning of the citizenship clause. The court does not attempt to explain how its reading of the Citizenship Clause comports with the Civil Rights Act's citizenship provision. The court does not present evidence that the children of temporary visitors were not subject to any foreign power as the Civil Rights Act required. Temporary visitors were subject to the foreign power of the government of their domicile. The court also does not present any evidence that the Citizenship Clause had a different meaning from the Civil Rights Act, as no party here disputes the two provisions were agreed to have been synonymous with respect to foreigners. As the plaintiff's counsel put it, the framers were trying to do the same thing with the language in both. The court likewise cannot explain the evidence that citizenship in this country was instead based on domicile. It does not meaningfully engage with the congressional debates during which this provision was extensively discussed, and it has no account of why so many legislators made so many statements irreconcilable with its view. In fact, the court does not even identify anyone who expressed the feudal principle in the relevant language, not subject to any foreign power or subject to the jurisdiction of the United States. The closest it comes is Lynch versus Clark's use of the phrase within the jurisdiction, language that denotes territorial jurisdiction. But Congress conspicuously chose not to use that broader territorial phrase in the Citizenship Clause. Notably, the 14th Amendment elsewhere says that no state may deny to any person within its jurisdiction the equal protection of the laws. The Citizenship Clause does not use that territorial phrase. Thus, while jurisdiction can refer to mere territorial jurisdiction, which a government of course exercises over temporary visitors, the Citizenship Clause did not adopt that sense of jurisdiction. I would not interpret subject to the jurisdiction to refer to the exclusion of three bespoke categories of persons whose relationship to the sovereign was not described in those terms. There is a simpler interpretation of the text that was expressly endorsed by those closer in time to ratification. Children born to diplomats, hostile alien occupiers, and Indians in tribes were not citizens because they were not subject to the complete jurisdiction of the United States. For the same reason, the children of foreign temporary visitors who were also not subject to the complete jurisdiction of the United States were also not citizens. Section B. Practice and precedent immediately and long following ratification support the same conclusion. In constitutional law, this court often pays close attention to how government officials interpreted and applied a constitutional provision shortly after its enactment. Here, the executive branch, Congress, and the judiciary all largely interpreted the Citizenship Clause to require domicile in the decades following ratification. Subsection 1. The executive branch regularly denied citizenship to the children of temporary visitors under the Citizenship Clause. The executive branch's position from the outset was that the Citizenship Clause excluded the children of aliens who were not subject to the complete jurisdiction of the United States. Therefore, a child born in the United States but domiciled abroad was on his birth subject to a foreign power and not subject to the jurisdiction of the United States. Many executive decisions under the Citizenship Clause denied citizenship to children born but not domiciled here. In recorded, reasoned decisions, the Hayes, Cleveland, and Harrison administrations, in accordance with the opinion of President Grant's Attorney General, all denied citizenship to children born in the United States but not domiciled here, who also did not satisfy any of the exceptions to the court's rule. On the court's account, each of these administrations, Republican and Democratic, over the course of multiple decades and close in time to ratification, acted in defiance of the Constitution seemingly without objection. Against this settled course of practice, the court can find only a single executive decision from the entire 19th century that it believes supports its interpretation. But in that case, the executive branch ultimately ruled that the claimant, Francois Heinrich, was not a citizen. Heinrich was born on American soil and did not fall into any of the court's three exceptions, but Secretary of State Hamilton Fish still concluded that he was not an American citizen because he resided in Austria. The court understands the executive branch to have concluded that Heinrich was originally clothed with American nationality but then lost that citizenship upon returning to his domicile abroad. Even the court is thus forced to embrace an interpretation of the Citizenship Clause that allows the political branches to deny citizenship to persons born here to temporary visitors. On that interpretation, the political branches can deny citizenship to such persons once they return home. Beyond that single case, the court does not dispute that the many other 19th century executive decisions were incompatible with its view, and it has found no examples of the executive branch actually affording the privileges of citizenship under the Citizenship Clause to a person born here while domiciled abroad. The executive branch instead repeatedly took the position that the Citizenship Clause required domicile. Footnote 14. One amicus brief tried to identify a decision recognizing the citizenship of a person born but not domiciled here, but it hurt more than it helped. That person was named Joseph Mogridge. Mogridge made a claim against the United States in 1872 that required him to be a British subject. The United States prevailed on the argument that Mogridge was an American citizen because he was born within the United States and he was, at the time of the alleged injuries, domiciled within the United States. Before Elk, some believed that the domicile required by the Citizenship Clause could be acquired after birth. The government apparently took that view. What was not an open question was whether the Citizenship Clause required that a person, as the Mogridge case shows, be domiciled within the United States. For good reason, the plaintiffs and the court chose not to invoke Mogridge's case. Carrying on. Subsection 2. Congressional practice supports the same conclusion. Early congressional enactments provide contemporaneous and weighty evidence of the Constitution's meaning. Congress could have enacted a statute that referred to the court's three categories of exceptions. Instead, in 1870, the Reconstruction Congress reenacted the Civil Rights Act, which expressly excluded all persons subject to any foreign power. Once again, a foreigner who was not domiciled here remained subject to a foreign power, namely his home country. Nobody in Congress, as far as I'm aware, argued that this exclusionary language violated the Citizenship Clause. Congress left the language excluding persons subject to any foreign power in place until 1940. It was the governing rule for the first 72 years after ratification. Such contemporaneous legislative exposition of the Constitution, acquiesced in for a long term of years, fixes the construction to be given its provisions. The court has no explanation for the Reconstruction Congress's 1870 decision to exclude from citizenship all persons subject to any foreign power. It appears to concede that it cannot reconcile its interpretation of the Citizenship Clause with that statute, and the court recognizes that every child born to temporary visitors was subject to a foreign power. According to the court, then, Congress defied the Citizenship Clause immediately after enacting it. Subsection 3. Early judicial precedent supports the same conclusion. In 1873, 5 years after ratification, this court described the Citizenship Clause in a manner that is, on the court's view, indefensible. It stated that the clause excluded from its operation children of citizens or subjects of foreign states born within the United States. The court rejects that position today, but declines to address its previous interpretation. Likewise, in 1884, this court interpreted the Citizenship Clause to require that a person be not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to its political jurisdiction, owing it direct and immediate allegiance, and owing no allegiance to any alien power. The court also rejects that position today. Section C. Decades of post-ratification scholarship interpreting the Citizenship Clause confirmed this view. Most interpreters of the Citizenship Clause concluded that it required domicile. The Citizenship Clause, scholars said, required that a child born here of alien parents show that those parents were permanently domiciled within the United States. Robinson, Notes on Elementary Law. It excluded those with allegiance to some other government. Cooley, General Principles of Constitutional Law. Children born in the United States, their parents not being here domiciled, are not citizens. Wharton Treatise, 1880. The words subject to the jurisdiction thereof excluded the children of foreigners transiently within the United States. Morse Treatise on Citizenship. Children born in the United States to foreigners here on transient residence were not subject to the jurisdiction of the United States. Wharton Digest. A child born here to parents temporarily residing was not a citizen of the United States because it was not subject to its jurisdiction. S. Miller, Lectures on the Constitution of the United States. Many more agreed. The Citizenship Clause excluded the children of foreign subjects born while the latter transiently sojourn here. Lesser, Citizenship and Franchise. The children of foreigners in transient residence are not citizens. Hall, Foreign Powers and Jurisdiction of the British Crown. If a stranger or traveler passing through the country has a child born here who goes out of the country with his father, such child is not a citizen. Black, Handbook of American Constitutional Law. Children of foreigners in transient residence are not citizens. Hall, International Law. One born of parents temporarily in our country is not constitutionally guaranteed citizenship because he is not born with the stamp of domicile, so the elements of national jurisdiction are wanting. Ide, Citizenship by Birth, Another View. The Citizenship Clause excludes children of persons passing through or temporarily residing in this country. Winchester, Citizenship in its International Relation. The court does not attempt to match this post-ratification evidence. To the contrary, the court acknowledges that, at least by the 1880s, the Citizenship Clause was understood to require domicile by the government, the executive branch, the State Department, scholars, and treatises. The court, though, proposes that this widespread understanding was not evidence of the original public meaning of the Citizenship Clause, but a rebellion against it. The scholars, courts, and government officials who held that domicile was required, the court says, were engaged in a law reform effort. Their motive, the court seems to say, was to deny citizenship to Chinese immigrants, especially around the election of President Cleveland, the first Democrat to hold the office since the Civil War. On this basis, the court suggests ignoring the considerable post-ratification practice and scholarship that is incompatible with its view. The court's account does not make sense. To begin, the post-ratification evidence against the court's view begins not nearly 2 decades after the 14th Amendment's ratification, but immediately. Well before the court has any explanation for a departure from its view, all 3 branches of the federal government had already rejected it. In 1870, Congress interpreted the Citizenship Clause to require that a child born here be not subject to any foreign power. In 1873, the Supreme Court interpreted the Citizenship Clause to exclude from its operation children of citizens or subjects of foreign states born within the United States. And the same year, President Grant's Attorney General interpreted the Citizenship Clause to exclude the children of aliens over whom the United States had limited jurisdiction even though they were born here. If all 3 branches of the federal government were not enough, many others concurred during these first 2 decades. The court cannot explain why, in the 1870s, William Robinson wrote that children born within the territory of the United States of alien parents were not citizens unless permanently domiciled within the United States. Why California excluded from citizenship children of transient aliens. Why Representative Ebenezer Orr, President Grant's first Attorney General and one of the nation's most eminent jurists, interpreted the Citizenship Clause to require domicile. And why the executive branch denied citizenship to a child born here but domiciled abroad. The court likewise cannot explain why, in 1880, Thomas Cooley wrote that the Citizenship Clause excluded children who had any allegiance to some other government. The court's theory does not even explain the later evidence that it characterizes as a revisionist project. If, as the court suggests, various government officials and scholars were trying to prevent the children of Chinese immigrants from being citizens, then they would not have proposed a domicile requirement alone. They would have needed to propose a citizenship requirement. As Wong Kim Ark exemplifies, many Chinese immigrants were already domiciled here. They simply weren't eligible for formal naturalization. Accordingly, when the executive branch did attempt to exclude the Chinese in the 1890s, it argued against the domicile rule. Meanwhile, as far as I can tell, the people excluded by the domicile requirement were not Chinese, but mostly European. Children such as Joseph Speck of Switzerland, Ludwig Hausdig of Saxony, Richard Greiser of Germany, Frederick de Bury of Austria, and the child of Mary Devereux of Ireland are unlikely targets of a campaign of anti-Chinese discrimination. The more likely explanation for why so many Americans stated that the Citizenship Clause required domicile is that the Citizenship Clause required domicile. Section D. Many other indicators of original public meaning support the domicile requirement. I briefly addressed 3. First, if the court were right that the Citizenship Clause did not require domicile, then it would have increased dual nationality, which would have provoked concern among 19th century Americans. The United States has long recognized the general undesirability of dual allegiances. At the time of ratification, exclusive loyalty to the United States had long been a fundamental element of American citizenship. The view at the time was that a nation should as soon tolerate a man with 2 wives as a man with 2 countries. Opposition to dual nationality was especially strong after the Civil War. The country had just emerged from a civil war that cost the lives of over 600,000 men due to a treasonous denial of allegiance to the Union, the United States. Going forward, there would be no national citizenship absent a reasonable expectation of national allegiance. An 1868 congressional report explained that if a person was a national of both his home country and the country of his birthplace, it could expose him to competing claims for compulsory military service, or could cause him to be summoned to fight for governments with which he has no connections and against those with which his fortunes are indissolubly united. The intimate association of those who are claimed as subjects of foreign governments is such as to put in peril the rights or peace of all. Accordingly, this court has long resisted reading the Citizenship Clause to inhibit the political branch's ability to address problems attendant to dual nationality. A rule that recognized the citizenship of children born to temporary visitors would have increased dual nationality. At the adoption of the Citizenship Clause, as today, most nations treated the children of their citizens born while temporarily abroad as citizens. As a result, a child born in the United States of a temporary visitor would have immediately been a citizen of his home nation. If the court's interpretation were correct, the child would immediately also become a dual citizen. It is unlikely that the Reconstruction Congress constitutionalized such a rule. By contrast, the domicile requirement mitigated the problem of dual nationality. Each person had one and only one domicile, so tying citizenship to domicile avoided dual citizenship. Second, the domicile rule aligns national citizenship with the long-standing rule for state citizenship. Even after the court's decision today, Americans are citizens only of the state of their domicile, even if it is not the state of their birth. No one doubts that a child born to New Yorkers on vacation in Florida would be treated as domiciled in and a citizen of New York. For the same reason, one would think that a child born to Canadians on vacation in Florida should not be a citizen of the United States. The court, in other words, rejects and is bewildered by an approach to citizenship that is in fact the one we still know best. Third, the domicile rule would make the Citizenship Clause accord with America's treatment of its own domiciliaries abroad. America itself has long taken the position that children of American citizens born on temporary visits abroad are American citizens. Such children were long considered American citizens because their parents were domiciled in America. It is unclear why the same reasoning should not apply in the other direction. Part 4. The court's alternative history is mistaken. Section A. The court's theory of the Citizenship Clause stands on 3 main pillars: Calvin's case, Lynch v. Clark, and Wong Kim Ark. None can justify the court's decision today. Subsection 1. The first pillar of the court's theory is Calvin's case, a 418-year-old English common law decision. Calvin's case held that a child born in Scotland could hold land in England. According to the court, Sir Edward Coke's separate opinion in Calvin's case established the common law principle called jus soli, pursuant to which people owed perpetual feudal allegiance to the King of England if they were born within the dominions that he owned. This principle applied to all persons born on the land, not just those domiciled there. As the court tells it, the 1608 feudal principle as described by Coke was adopted as the law of citizenship in America and then incorporated by reference in the Citizenship Clause. The English principle was a rule of feudal servitude, not a rule of citizenship. In England, there was no such thing as a citizen. The English principle instead determined a person's perpetual feudal bondage to the king, which he could not unilaterally abandon. It was based on the notion that a man owed personal service to the lord of the soil, the same as his master owed it to the king, and it was born with the child and only ended in the grave, a relation of master and servant. Under the feudal system, every owner of lands held them in subjugation to some superior or lord. The lord would protect the vassal in the enjoyment of the territory granted him, while the vassal would be faithful to the lord and defend him against all his enemies. Footnote 15. The English feudal principle was also a product of the isolated position of the island nation of England, which meant that temporary visits from childbearing foreigners were rare. Carrying on. The English feudal principle was not accepted by the American governments. As Justice Alito explains, the principle that birth on the soil made a person perpetually bound to the king was premised on the theory that the king was anointed by God to rule the people like children. John Adams famously wrote that the feudal theory meant that the common people were held together in herds and clans in a state of servile dependence on their lords, in a state of total ignorance of everything divine and human. Americans emphatically rejected this theory. They began their settlements and formed their plan both of ecclesiastical and civil government in direct opposition to the feudal system. They then dissolved all allegiance to the British crown, and they set up a new system of government in which the people were not regarded as servile dependents. Instead, the people were sovereign and the government derived its legitimacy from them. In this new system of government, feudalism had no place. The soil did not belong to the government but to the people, and those who were born on it did not owe the government a lifetime of obedience or servitude. The Reconstruction Congress expressly opposed the feudal principle that the court claims that it adopted. As its Committee on Foreign Affairs saw the matter, there is nothing American in the oath of the land barons of England. It described the English rule's claim of indefeasible allegiance and perpetual service as the symbol of feudalism and force. Instead of the feudal principle, the congressional report explained that American law viewed people as taking on a new citizenship as relevant here when they changed their domicile. The same year that the Citizenship Clause was ratified, Congress passed a statute rejecting the feudal principle and explaining that it supported the right of all persons to expatriate and change their citizenship. In fact, by the 1840s, even English law had evolved. England had moved on from the darkness of the Middle Ages, and as the subjects of one kingdom began to migrate into and reside in other countries, had begun to attach a newfound importance to the law of domicile. Well before the Citizenship Clause, this court explained that the courts of England had decided that a person who removes to a foreign country, settles himself there, and engages in the trade of the country, furnishes by these acts such evidence of an intention permanently to reside there as to stamp him with the national character of the state where he resides. A year after the Citizenship Clause, a renowned English case declared that a person's civil status, by virtue of which he has ascribed to him the character of a citizen of some particular country, is governed universally by one single principle, namely that of domicile. Subsection 2. The second pillar of the court's theory is Lynch v. Clark, a single state court case about citizenship. Thomas Lynch was a successful businessman in New York. When he died, he had no will and no children. Shortly after he died, his brother Bernard and his niece, through another brother, Julia, moved to New York from Ireland. The New York legislature then passed a special statute giving Lynch's property to Julia Lynch, subject only to the rights of the heirs at law of Thomas Lynch. The legislature then passed another special statute giving Lynch's property to Bernard Lynch, save for the claims of heirs of Thomas and the existing rights of Julia Lynch. Lynch's business partner, John Clark, also claimed a right to property in his estate. Bernard then brought a bill in equity against both Julia and Clark. Julia cited the special statute giving her inheritance rights, but also argued that because she was born in the United States, she inherited all of Thomas's property and had other equitable entitlements. That argument turned on a state law bar on aliens inheriting real property, so Julia argued that she was not an alien. She argued, among other things, that she was not an alien because she was in fact domiciled in the United States at the time of her birth. Her father came here with an intention to remain and thereby changed his domicile. The assistant vice chancellor who was assigned the case held 6 days of argument, during which Julia Lynch's citizenship was not then made a very prominent point. After argument, the assistant vice chancellor became so impressed with the importance of the question upon the citizenship of Julia Lynch that he asked for supplemental briefing on the issue. He then wrote a long opinion explaining his theory of American citizenship, which concluded that Julia Lynch was not an alien, but a citizen and therefore entitled to inherit the property. Within a year, New York replaced the law that the assistant vice chancellor interpreted with a new law that simply made aliens eligible to inherit property. The state shut down his court 2 years later. The court's reverence for Lynch versus Clark is not commensurate with its importance. Lynch was not a precedent of this court, or any federal court, or any state appellate court, or even a court of law. Instead, it was decided by a New York assistant vice chancellor in a court of equities equivalent to a trial court. The assistant vice chancellor, much like a magistrate judge, had the power to hear preliminary motions for the suppression of testimony and cases referred to him by the chancellor. The assistant vice chancellor's opinion on Julia's citizenship was apparently not reviewed by any appellate court. Lynch also did not interpret the Citizenship Clause, a statute using the same language as the Citizenship Clause, or even a statute that remained in effect at the time of the Citizenship Clause. Instead, it interpreted a New York state law. The law was replaced immediately after Lynch. If a single expressly limited opinion from a specialized intermediate federal court does not establish a well-settled meaning that the court can assume Congress incorporated into a federal statute that uses the same language, then a single state trial equity court decision interpreting a different law certainly does not do so. Footnote 16. New York also stood apart from the rest of the United States in its affinity for the feudal system on which the assistant vice chancellor's theory was based. Carrying on. Lynch also lacked staying power. By the time of the Citizenship Clause, New York's higher courts had all but abrogated it. In Ludlam v. Ludlam, a New York appellate court held that the children of those traveling or sojourning abroad, though born in a foreign country, are not born under the allegiance and are an exception to the rule which makes the place of birth the test of citizenship. That decision was affirmed by the New York Court of Appeals, which stated, "By the law of nature alone, children follow the condition of their fathers, and enter into all their rights. The place of birth produces no change in this particular." When the New York legislature authorized a committee to codify its laws in 1860, the codification defined birthright citizens as all persons born in this state and domiciled within it, except the children of transient aliens and of alien public ministers and councils. Then, during the 14th Amendment debates of the 39th Congress, Lynch went unmentioned. It was only during the Civil Rights Act debates that Lynch appeared, a single mention by a member who played no role in drafting the 14th Amendment. So, while this court's opinion invokes Lynch 13 times in 26 pages, the entire Reconstruction Congress, in the combined course of deliberations over the Civil Rights Act and the Citizenship Clause, mentioned it only once. Subsection 3. The third pillar of the court's theory is Wong-Kim Ark. The question before the court today, whether the Citizenship Clause requires the President to recognize citizenship for the children of all lawful temporary visitors and illegal aliens, was not before the court in Wong-Kim Ark. Instead, the Wong-Kim Ark court held that someone born in America to parents domiciled in the United States was a citizen. It rejected the government's argument that Wong's parents had to be citizens for him to be a citizen at birth. The citizenship order is fully consistent with this decision. Under the order, people like Wong remain citizens, and the government today nowhere urges the position that it took in Wong-Kim Ark. To the contrary, it invokes authorities that the government in Wong-Kim Ark opposed. The court nonetheless leans heavily on dicta from the majority opinion in Wong-Kim Ark, which it takes to have established that Wong's domicile was irrelevant and that he, a lifelong American, was indistinguishable from a person who had no meaningful ties to America. The court does not ordinarily put so much weight on past decisions' discussion of matters not before the court. It is a maxim not to be disregarded. This court has always admonished that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. Thus, if they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for decision. Instead, we emphasize, our opinions dispose of discrete cases and controversies, and they must be read with a careful eye to context. After all, the question actually before the court is investigated with care and considered in its full extent, but other principles which may serve to illustrate it are considered in their relation to the case decided, but their possible bearing on all other cases is seldom completely investigated. Nor is Wong Kim Ark's dicta so clearly on the court's side. After a long discussion with many internally inconsistent statements, Wong Kim Ark's final statement of the rule comported more closely with the citizenship order's application to temporary visitors than with the court's view. The Wong Kim Ark Court concluded that the Citizenship Clause grants citizenship to all children born of resident aliens with the exceptions or qualifications of 1. Children of foreign sovereigns, 2. Children of foreign ministers, 3. Children born on foreign public ships, 4. Children of enemies within and during a hostile occupation of part of our territory, and 5. Children of members of the Indian tribes owing direct allegiance to their several tribes. It then reaffirmed that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. Wong Kim Ark also repeatedly emphasized that its holding was limited to domiciliaries. It did so 7 times in the first paragraph and repeatedly after that, and presciently, Wong Kim Ark itself invoked this court's oft-repeated reminder that general expressions that go beyond the case should not control the judgment in a subsequent suit when the very point is preserved for decision. This is not quite no, no, 1,000 times no, but should have sufficed to dissuade the court from invoking the case with respect to the distinct legal and factual issues presented here. It is not surprising that Wong Kim Ark limited its holding to domiciliaries. The government in Wong Kim Ark stipulated that Wong was domiciled in the United States and argued that domicile was irrelevant. The court thus had little reason to consider what rule would apply to a temporary visitor. The court was hardly likely to upset the consensus that the Citizenship Clause required domicile in a case where the issue was irrelevant given Wong's domicile in this country. If Wong Kim Ark were so simple in establishing the court's rule as to temporary visitors, that meaning was seemingly lost on many. As the Department of Justice report confirmed in 1910, a dozen years after Wong Kim Ark, it has never been held, and it is very doubtful whether it will ever be held, that the mere act of birth of a child on American soil to parents who are temporarily in the United States operates to invest such child with all the rights of American citizenship. The Citizenship Clause's reference to jurisdiction does not mean that jurisdiction to which the bodily form of the child is subject from the moment of its birth, but instead that larger jurisdiction which, though difficult to define, is well known and understood, the difference between the jurisdiction which is exercised over a visitor and that over one domiciled. In the years following Wong Kim Ark, the Citizenship Clause was generally understood as limited to children born of alien parents, not temporarily resident here, but permanently domiciled. Nothing in Wong Kim Ark changed the consensus that children born in the United States to foreigners here on transient residence are not citizens because by the law of nations they are not at the time of their birth subject to the jurisdiction of the United States. Subsection 4. As for the remainder of the court's reasoning, much of it is self-defeating. To begin with, the court invokes Frederick Douglass's statement that the Constitution knows all the human inhabitants of this country as the people. But temporary visitors are not inhabitants. To be an inhabitant, a person must be domiciled. And Frederick Douglass himself argued that blacks were citizens because they were not comparable to temporary visitors. They were not aliens, they were not exiles, and they were not strangers. Instead, they were Americans, he said, who, unlike temporary visitors, owe equal allegiance to the same government. Likewise, the court invokes Attorney General Bates's statement that persons born here were prima facie citizens, but the court does not seem to be aware that this phrase corresponds to the rule of domicile that the court rejects. If a person's parents were domiciled abroad, then the prima facie case was overcome. Beyond these statements, the court mainly emphasizes that the children of temporary visitors owed a partial allegiance to and were owed partial protection from the sovereign. That undisputed fact does not demonstrate that the children of these visitors were citizens. To the contrary, Senator Trumbull explained that the Civil Rights Act was written to avoid this very misunderstanding. The act said not subject to any foreign power instead of owing allegiance to the United States precisely because temporary visitors owed a partial allegiance to the United States, and he did not want anyone to mistakenly conclude that the act included the children of temporary visitors. The language chosen thus excluded temporary sojourners who continued to owe allegiance to their native country. Finally, the court relies on general statements without recognizing that those statements are also compatible with my view of the Citizenship Clause. The Citizenship Clause indeed followed the pre-existing law, but the pre-existing law was based on domicile. Children born here to foreign parents indeed were generally citizens, but that is because they were generally domiciled here. And citizenship did indeed almost always follow birthplace, but that is because birthplace almost always followed domicile. Section B. The court's responses to my view also undermine its own. The court criticizes my view for depending on the parent's status, not the child's. But the court's view depends on the parent's status too. The court, for example, excludes from citizenship the children of representatives of foreign sovereigns or enemy invaders. Unless newborn babies are serving as international diplomats, the court's account thus turns on parents' status. Along the same lines, the court asks why words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. But again, if that is a problem, then it is one for the court's theory as well. After all, the court's exceptions for foreign representatives, Indians, and invading enemies do not appear in the clause either. Finally, the court suggests that domicile is a difficult concept to apply. But domicile is, of course, a concept widely used in both federal and state courts for jurisdiction and conflict of law purposes, and its meaning is generally uncontroverted. The court's concept poses its own administrability questions. The court never explains, for example, what happens when a child is born to a citizen and a diplomat, or to a citizen and a member of an invading army. The court also suggests that my interpretation of the Citizenship Clause is not consistent with the Civil Rights Act's not subject to any foreign power requirement because a foreign nation can purport to exercise power over its original citizens even after they establish a domicile here. But the court's interpretation of the Citizenship Clause does not even attempt to be consistent with the Civil Rights Act's requirement, since the children of temporary visitors are clearly subject to the foreign power of their homeland. Regardless, the court is wrong about domiciliaries remaining subject to the foreign power of their country of birth. Although their nation of origin might purport to exercise jurisdiction over them, the United States would not have had to recognize that authority as lawful once those persons were domiciled here. The court ultimately denigrates the evidence in support of my position as scant. I see it differently. The court cites little evidence from the Reconstruction Congress that gave us the Citizenship Clause, and its other 19th century evidence is slim in comparison. As for the evidence in support of my position, it is substantial. Representative Bingham, the architect of the 14th Amendment, believed that the Citizenship Clause would not apply to the children of temporary visitors. Senator Trumbull, a principal champion of the amendment, agreed. Jacob Howard, who introduced the Citizenship Clause, agreed. Congressman after congressman during the legislative debates agreed. Congress in 1870 agreed. President Grant's Attorney General agreed. President Grant's Attorney General before that agreed. The Supreme Court in 1873 agreed. State legislatures agreed. Executive branch decision makers over the course of multiple decades agreed. Justice Miller agreed. Thomas Cooley agreed. A battery of other eminent scholars agreed. And the great Justice John Marshall Harlan on 3 separate occasions agreed. Once again, I am quite comfortable in the company I keep. Part 5. Before concluding, I briefly address plaintiff's argument that even if the citizenship order has at least some lawful applications consistent with the Citizenship Clause, it is not consistent with the statutory citizenship provision in force today. The court gives no independent import to the statutory citizenship provision, and I would not either. From 1866 until 1940, the statutory citizenship provision required that a person claiming citizenship based on birth in the United States be not subject to any foreign power. That language from the Civil Rights Act, like the language of the Citizenship Clause, required that a person claiming citizenship have a domicile in the United States. so both the statute and the Constitution required domicile until at least 1940. The Nationality Act of 1940 codified the existing law by enacting the Citizenship Clause's text. By the early 1930s, the American law on nationality was expressed in a large number of provisions scattered throughout the statute books. President Roosevelt designated a committee to review existing nationality laws and, as relevant here, to codify those laws into one comprehensive nationality law. As a result of that process, Congress enacted the Nationality Act in 1940. The Nationality Act was the first attempt ever made since the founding of our republic to codify and unify all the laws of the United States relating to the important subjects of nationality and naturalization. A codification of existing laws does not change the law unless it does so clearly. When legislatures consolidate their statutes at large into a code, they often revise the wording of the prior statute to provide for consistency of expression. But that revision does not result from legislative reconsideration of the substance of codified statutes. The same is true for legislative restyling exercises short of codification. Such new language does not amend prior enactments unless it does so clearly. The Nationality Act's citizenship provision codified the Civil Rights Act's not subject to any foreign power requirement, and the Citizenship Clause's subject to the jurisdiction requirement. It did so by borrowing language from the Citizenship Clause, which granted citizenship to all persons born in the United States and subject to the jurisdiction thereof. By using language that tracked the Citizenship Clause, Congress did not clearly change the law. It would be surprising to discover that Congress departed from the constitutional standard by enacting the exact constitutional language. Part 6. The 14th Amendment was enacted in the wake of the Civil War with the one pervading purpose of securing equal citizenship for freed slaves. It was enacted, as Justice Harlan wrote, to secure a race recently emancipated the civil rights that other citizens enjoyed. This court time and again denied Americans that promise. Shortly after the amendment was ratified, this court deprived black citizens of the right to peaceably assemble and to keep and bear arms. A little later, in Plessy, the court upheld the subjugation of black citizens in the form of state-coerced racial segregation. When it had an opportunity to correct that profound error, it did so narrowly. It then used that very decision to justify busing American children to different schools based on their race. And until recently, this court continued to selectively enforce our colorblind Constitution, including by allowing state-coerced racial discrimination in public education, and compelling states to draw political districts on the basis of race. Meanwhile, the court has repurposed the 14th Amendment to protect its own set of preferred rights that the Reconstruction Congress never contemplated and that cannot find support in its text. Today, the court does so again by recognizing a constitutional right to citizenship for the children of all foreign birth tourists and illegal aliens. Part 7. I am not sure that today's opinion will stand the test of time. The Citizenship Clause added greatly to the dignity and glory of American citizenship. Today's opinion devalues that citizenship. I respectfully dissent. Justice Alito dissenting. This is one of the most important decisions in the history of this court, and in my judgment, the court has made a serious mistake. As interpreted by the court today, the 14th Amendment confers citizenship on virtually everyone who happens to be born in this country, including the children of birth tourists, women who come here solely for the purpose of giving birth to a child and then promptly returning home. Careful analysis of the text of the 14th Amendment and the process that led to its adoption shows that it does not degrade the concept of United States citizenship in this way. Indeed, the 14th Amendment confers citizenship only on those children who, at birth, owe allegiance solely to this country. Respecting this interpretation would not require uprooting the millions of children who were born here to mothers who entered or remained in this country illegally. Those children are not responsible for their parents' violation of our immigration laws, and their plight is the result of a long period during which a coterie of actors, executive branch officials, states and cities, and a variety of private groups sent the message to would-be immigrants that our immigration laws should not be taken too seriously. This message, coupled with ineffective or unenthusiastic enforcement, spurred massive illegal immigration and the growth of a large contingent of people who were born here to mothers unlawfully present in this country. Some members of this group have lived here for years, and they have a strong moral claim to be able to remain in the land where they grew up. Congress can and should address their situation. The 14th Amendment dictates who must be a citizen, but it does not address who may be a citizen by act of Congress. Congress has conferred citizenship on many people who are not made citizens by the 14th Amendment, including children born abroad to American citizen parents. These people and the millions of immigrants who have been naturalized are no less American than those who are fortunate enough to be born here. For these reasons, the original meaning of the 14th Amendment does not require inhumane results, and we should not adopt an erroneous interpretation of the 14th Amendment simply out of fear of the consequences of rocking the boat or as a reaction to current immigration policy. Nor should we take the position that our hands are tied by dicta in a sprawling 19th century opinion that is, to put the point gently, very far from a model of careful judicial craftsmanship. Too much is at stake. United States citizenship is precious. Anyone who has attended a ceremony where citizens are naturalized can see that message on the faces of those who take the citizenship oath. Before saddling the nation with a medieval rule, we had better be certain the Constitution requires it. The court's account of the birthright citizenship rule in American law is roughly as follows. After American independence, the British rule of birthright subjecthood was modified in just one way, to take account of Indians who lived under tribal governance, but otherwise the rule was transplanted intact to American soil. As modified, the rule was that a child born in this country is automatically an American citizen unless the child is born to tribal Indians or to a diplomat with immunity from legal process. During the period before the Civil War, the rule's status was firm. After the war, Congress codified the rule in Section 1 of the 14th Amendment, and in United States v. Wong Kim Ark, this court issued a binding precedent confirming what Congress had done. Every step of this story is incorrect. The Declaration of Independence repudiated the foundation on which the British rule was based. From 1776 until the eve of the Civil War, the status of the rule in this country was unsettled. There is no evidence establishing the Constitution's references to citizens incorporated the British rule, and until the eve of the Civil War, there was little litigation about the meaning of American citizenship. After the war, Congress finally adopted a constitutional provision, Section 1 of the 14th Amendment, making certain persons citizens at birth, but that provision differed substantially from the British rule. It specified that a person born here is not a citizen unless his allegiance to the United States is unimpaired by any obligations to a foreign power. And while Wong Kim Ark included dicta suggesting that the 14th Amendment incorporates the British rule, its actual holding was much narrower. And under that interpretation, respondents' challenge to Executive Order No. 14,160, protecting the meaning and value of American citizenship, fails. Part 1, Section A. According to the court, the 14th Amendment's Citizenship Clause codified the British rule of birthright subjecthood with only one new exception, which was needed to accommodate the unique status of American Indians. That is a curious claim, and it is ironic that the court should embrace it only days before we celebrate the 250th anniversary of our Declaration of Independence, which emphatically renounced the foundation on which the British rule rested. That rule did not concern citizenship. There was no such thing as a citizen of England, Scotland, or Ireland. The inhabitants of the British Isles were the king's subjects. As Sir Edward Coke explained in Calvin's case, they acquired that status automatically at birth, and they retained it, like it or not, until they died. This status arose from a feudal understanding of the origin of governmental authority and the relationship between those who govern and those who are governed. The king's authority was understood to come from God. As Coke put it, a king ruled by the law of nature, and birth established the bond between king and subject, just as birth establishes the bond between parent and child. In Calvin's case, the question was whether a man born in Scotland was a subject of King James I of England, who was seated to the thrones of both Scotland and England before the man's birth. In a famous speech to Parliament, James I forcefully explained his views about the source of his authority and his relationship with his subjects. The king, he proclaimed, sits upon God's throne and is the father of his people. This theory of monarchical power and the status of the people provided the foundation on which the rule of birthright citizenship stood. Just as a person automatically acquires at birth all that is entailed by the relationship between parent and child, a person born within the king's dominion automatically became the king's subject. This meant that the subject acquired a duty of obedience to the king, and the king owed a duty of protection to the subject. This relationship was not based on consent, and a subject could not shed it. In this system of soil and servitude, the court sees emancipation. But our founders disagreed. The Declaration of Independence emphatically rejected the British theory of government. It proclaimed that governments derive their just powers from the consent of the governed, not divine right, and it absolved the people of the United States from all allegiance to the British Crown. With its foundation blown away, the British rule of birthright subjecthood was not suited for easy incorporation into American law. In addition to the incompatibility of its theoretical foundation, two distinctively American practical problems stood in the way. The first was the problem of slavery and, more broadly, of race. In England itself, the number of slaves had never approached American dimensions. Just 4 years before the American colonies declared independence, Lord Mansfield's decision in Somerset v. Stewart denied that slavery had any common law foundation. And it would soon disappear. Footnote 1. This is just a citation to that effect, so I'm not going to read it out. Carrying on. In the United States, on the other hand, nearly 700,000 lived in slavery, roughly 1/5 of the country's population, according to the first census in 1790. And since the contemporary definition of a citizen was a free man of a city, not a slave, it was obvious that neither the Articles of Confederation nor the Constitution, both of which allowed slavery to continue, recognized the members of this sizable population as citizens. Even for the free black population in the United States, there was substantial opposition to application of the British rule. Many states, both in the South and Midwest, restricted the rights traditionally associated with citizenship, such as the ability to settle, vote, and serve as a witness in court, to white residents. Footnote 2. This is just a citation to that effect, so I'm not going to read it out. Carrying on. And there was some federal support for this understanding of citizenship. Footnote 3. Under the Naturalization Act of 1790, only a free white person could become a citizen. Carrying on. In Britain, on the other hand, as the court notes, the common law did not take account of race. The second problem was the unique legal status of Indian tribes in the United States. Under the clause of the Constitution allocating seats in the House of Representatives and presidential electors, Indians not taxed were excluded from the body politic and thereby denied citizenship. This provision did not require census takers to determine whether individual Indians owed or paid taxes. Instead, the phrase referred to those Indians who retained their traditional way of life. They lived in their own communities under tribal law and enjoyed the privilege of total immunity from state taxation. It is hard to find estimates of the size of this segment of the population at the end of the 18th century, but it was certainly significant. The existence of these two big carve-outs refutes any argument that the British rule was transplanted without modification to American soil, and any attempt to plant some version of that rule here also faced the problem of applying it to a nation that, unlike Britain, had a written constitution and a federal system. In Britain, the rule of birthright subjecthood was part of the common law and thus could be changed by Parliament whenever it chose. If the rule was transplanted across the Atlantic, would it have a similar status here? Would it be part of the common law that state legislatures or courts could alter or abandon? Alternatively, did the rule have some status under federal law? Numerous provisions of the Constitution use the term citizen. Did all these provisions incorporate the British rule of birthright subjecthood? In this case, because we are concerned with the meaning of citizenship under the Constitution, it is the second alternative that is important for present purposes. In Lynch v. Clark, a decision on which the court, respondents, and many amici heavily rely, the Assistant Vice Chancellor of New York suggested that the Constitution's references to citizen incorporated the British rule, but that is far from obvious. Nothing in the records of the Constitutional Convention supports that conclusion, and the British rule would be a poor fit as an interpretation of the term citizen in the provisions governing the qualifications of members of Congress and the President. An early draft of the Constitution provided that a representative must have been a citizen of the United States for at least 3 years, but there was opposition to this provision. One delegate argued that 3 years was not enough, in part because a rich foreign nation, for example Great Britain, might send over her tools who might bribe their way into the legislature for insidious purposes. In response, the delegates voted to require 7 years citizenship for representatives and 9 years citizenship for senators. The presidential eligibility clause had a similar aim, but it went even further. Not only does it require 14 years residence, but it also requires that a president be a citizen from birth. Its purpose was to prevent a person with possible foreign loyalties from becoming president, and the British rule hardly seems consistent with that aim. Footnote 4. On July 25, 1787, John Jay sent George Washington a letter suggesting that it would be wise and seasonable to provide a strong check to the admission of foreigners into the administration of our national government, and to declare expressly that the command-in-chief of the American army shall not be given to, nor devolve on, any but a natural-born citizen. Shortly thereafter, the phrase was added. In his commentaries on the Constitution, Joseph Story explained that the purpose of the natural-born citizenship provision was to cut off all chances for ambitious foreigners who might otherwise be intriguing for the office, and interpose a barrier against those corrupt interferences of foreign governments in executive elections. Carrying on. Section B. No case concerning the meaning of the term citizen in any constitutional provision reached the Supreme Court until Dred Scott v. Sandford. Before then, the British rule did figure in a handful of antebellum Supreme Court decisions, but none of these addressed any constitutional question, and most appear to have regarded the British rule as part of state law on eligibility to inherit property. Not only were there no Supreme Court decisions on the constitutional question, there was not much litigation of any kind on the question of United States citizenship. Both Lynch in 1844 and an 1862 opinion by Attorney General Bates expressed surprise at this dearth. And in our time, when the difference between citizenship and alienage is a hot issue, this dearth may seem very strange, but some obvious explanations come readily to mind. The question of citizenship came up regularly in cases in which the jurisdiction of a federal court was invoked based on diversity of citizenship, but the issue in those cases was whether one or more of the parties were citizens of a particular state, not whether they were citizens at all. A party wishing to challenge federal jurisdiction had no incentive to argue that an adverse party was an alien, because both Article 3 of the Constitution and Section 11 of the Judiciary Act of 1789 conferred jurisdiction over cases between citizens and aliens. Therefore, an adverse party who showed that a supposedly diverse citizen was actually not a citizen at all would have confirmed the jurisdiction he sought to oust. As for the other constitutional provisions that use the term citizen, it appears that the question simply did not come up. A reason why this issue did not arise regarding the qualifications for members of Congress may be that foreign-born individuals who were interested in holding office could easily become citizens. Under the Naturalization Act of 1790, a foreigner became an American citizen simply by proving 2 years of residence and good moral character. In the years before the Civil War, and indeed until many years thereafter, the distinction between citizens and aliens meant less than it does today. During that period, immigration was unrestricted, so aliens could come and stay as long as they wanted. And in an era when transatlantic travel was slow, unpleasant, expensive, and sometimes perilous, it is likely that the vast majority of those who sailed across the Atlantic intended to remain. If that was their choice, naturalization, as noted, was easy, and if for whatever reason a person who intended to make a permanent home here did not do what was needed to apply for naturalization, the lack of citizenship did not matter as much as it would in later years. In some places, aliens could even vote and hold elective office. Whatever the reasons, the issue of citizenship came up in only a few cases, and except for those involving the question of citizenship for free black people, the cases did not involve questions of much public importance. Legal treatises, to be sure, included comments on birthright citizenship, but those comments were not informed by judicial opinions. The important point for present purposes is that during the antebellum period, there was no settled understanding about the meaning of citizenship under the Constitution, and there certainly was no settled understanding about the citizenship of a child born on the United States soil to parents whose presence in the country was unlawful. That was a situation that could not have occurred. Part 2, Section A. After the Civil War, Congress faced enormous challenges, and one of these was ensuring that all black Americans, both the newly freed slaves and those who were free before the war, would be treated as citizens of the United States and of the states in which they lived. Congress addressed that issue in the landmark Civil Rights Act of 1866 and then again in the 14th Amendment. For the first time in the nation's history, these enactments provided a national rule on citizenship, and the meaning of that rule is the question the court now addresses. In tackling that question, an avowedly textualist court should start by carefully examining the text of the Citizenship Clause of the 14th Amendment. That clause states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside." Thus, birthright citizenship has two separate elements. First, a person must be born in the United States, and second, he or she must be subject to the jurisdiction thereof. It is therefore critical to ascertain the meaning of subject to the jurisdiction thereof, and that is no easy task because, as we have often remarked, jurisdiction is a term of many meanings. We must therefore determine which one applies here. If subject to the jurisdiction of the United States had been a term of art during Reconstruction, we would presumably hold that the phrase has that meaning in the 14th Amendment, but that phrase was not a term of art, and the court does not claim it was. If the Citizenship Clause set out specifically named exceptions to the general rule of citizenship by birth, our job would be easy. We would follow those exceptions. But the Citizenship Clause is framed differently. It sets out a general rule: citizenship is not conferred upon a person born in the United States unless that person is also subject to the jurisdiction of the United States. By its terms, that rule applies across the board. And when a legislative body chooses to adopt a generally worded rule, we apply it in all circumstances that fall within the rule, not just those that were on the minds of the legislators at the time of adoption. So, what does the phrase "subject to the jurisdiction thereof" mean? Unfortunately, the text of the 14th Amendment does not provide a definitive answer, but it supplies two valuable clues. First, Section 1 of the 14th Amendment uses the word jurisdiction twice, once in the Citizenship Clause and once in the Equal Protection Clause, and the wording of the two clauses differs. The Citizenship Clause applies to those subject to the jurisdiction of the United States, whereas the Equal Protection Clause applies to any person within a state's jurisdiction. When Congress uses disparate language, especially in the same provision, we assume that the difference matters. Therefore, we must presume that the scope of the two provisions is different. Second, the phrase "subject to the jurisdiction of the United States" applies not only to those who are born in this country, but also to those who are naturalized. After all, Congress would not include both qualifiers unless they were both doing some work. Accordingly, there must be some people who are naturalized but are not subject to the jurisdiction of the United States. In other words, whatever subject to the jurisdiction of the United States means, it must mean something that is not inherent in naturalization. Section B, subsection 1. Although the text of the 14th Amendment provides these clues, we must look beyond that text to find a full explanation of the phrase "subject to the jurisdiction of the United States." The terms of the 1866 Civil Rights Act, CRA, provide that explanation. The CRA includes its own Citizenship Clause, and the circumstances surrounding Congress's adoption of the CRA and the 14th Amendment make clear that the two provisions were understood to be substantively the same. The 39th Congress debated the CRA from January to March 1866, when it was passed and sent to President Johnson for his signature. Footnote 5. President Johnson vetoed the bill, but Congress overrode the veto in April 1866. Carrying on. Congress debated the 14th Amendment from April to June 1866, when it was adopted and sent to the states. Thus, during a 6-month period, the same Congress debated two provisions that addressed the very same question and adopted them both. Those circumstances in themselves make it highly unlikely that the two provisions differed in substance. In addition, one of the chief reasons for adoption of the 14th Amendment was to prevent the CRA from being held unconstitutional. President Johnson had cited the unconstitutionality of the CRA as one of the reasons why he vetoed it. If the CRA had granted birthright citizenship to persons who were not entitled to citizenship by birth under the 14th Amendment, there would still have been doubts about the CRA's constitutionality. So at a minimum, the 14th Amendment's text had to be at least as generous as its CRA counterpart. Moreover, following the ratification of the 14th Amendment, Congress reenacted the CRA in 1870. That reenactment would have been pointless if the CRA's test for birthright citizenship were less generous than the 14th Amendment's. For all these reasons, it is abundantly clear that the test for birthright citizenship in the 14th Amendment and the CRA were substantively identical. I therefore turn to the text of the CRA's citizenship provision. It provided that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. That language preserved two exceptions that were well known and well accepted at the time. The first was for the children of diplomats. The second was for Indians who had not left their traditional way of life and continued to live with other members of their tribes under the governance of tribal leaders. The exclusion of these Indian tribes from citizenship followed from Article 1's Apportionment Clause, which says that congressional representatives and direct taxes shall be apportioned among the several states according to their respective numbers, excluding Indians not taxed. In the Constitution, just as during the Revolution, taxation and representation went hand in hand. Indians who lived apart under tribal rule were not considered part of the political community. As Chief Justice Marshall explained, Indian tribes were domestic dependent nations. Chancellor Kent provided a similar description of Indian status in the early republic. Though born within our territorial limits, the Indians are considered as born under the dominion of their tribes. They are not our subjects born within the purview of the law because they are not born in obedience to us. They belong by birth to their own tribes. Because Indians who lived apart under tribal rule were not considered part of the political community, they did not receive representation and they were not taxed. Due to this status, it appears to have been accepted that tribal Indians and their children, although born on U.S. soil, were not citizens. The other exception, for the children of diplomats, was one that had been recognized under the British rule and was endorsed by leading authorities on the law of nations. This was a minuscule category at best, and Congress could have preserved the exception with narrow language applicable only to the members of that group. For example, it could have said something like this: all persons born in the United States, excluding Indians not taxed and the children of foreign diplomats, are hereby declared to be citizens of the United States. Congress did not take that approach. It chose instead to identify what it understood to be the characteristic that called for the exception and to deny birthright citizenship to anyone who shares that characteristic. That characteristic, as Congress saw it, was being subject to any foreign power. With this understanding of the CRA's citizenship test in mind, we may return to the text of the 14th Amendment. When Congress framed the citizenship test in the 14th Amendment, it consolidated the CRA's two exceptions to citizenship by birth for Indians not taxed and those subject to any foreign power. The 14th Amendment used the phrase subject to the jurisdiction of the United States to cover both of those exceptions. Therefore, a person who is subject to any foreign power is not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. This unique formulation uses the term jurisdiction in a very specific sense. It refers to a form of jurisdiction that is exclusive, that is not in any way limited by any power possessed by any foreign country. The children of diplomats were not subject to this complete jurisdiction because they were citizens or subjects of the countries represented by their fathers and thus bore duties to those countries. Likewise, tribal Indians were not subject to the United States' exclusive jurisdiction because they were bound to obey tribal law. But they were certainly subject to the jurisdiction of the United States in a different sense of the concept. That is, they were subject to regulation by the federal government. After all, their tribes were domestic dependent nations. And even though the government allowed tribes a large measure of self-government, it consistently asserted its jurisdiction to intervene. In 1817, for example, federal criminal jurisdiction was extended to many crimes committed within the Indian country, and the Indian Trade and Intercourse Act of 1834 extended that jurisdiction. In addition, treaties repeatedly described tribes as within the jurisdiction of the United States. Likewise, this court held that Indians were within our jurisdiction and subject to our laws. Thus, tribal Indians were subject to the jurisdiction of the United States in the sense that they could be and were governed by federal law, but they were not subject exclusively to federal law because they were also governed by tribal law. For that reason, their children did not become citizens at birth. This understanding of the phrase subject to the jurisdiction thereof also explains why naturalized citizens must forswear all other allegiances when they become United States citizens. From the earliest days of our republic until now, Congress has required naturalized citizens to renounce and abjure absolutely and entirely all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty of whom or which the applicant was before a subject or citizen. Such an oath would not be necessary if the Constitution permitted anything less than exclusive jurisdiction. In sum, the 14th Amendment confers citizenship on a person who is born in this country or naturalized only if that person is not subject to any foreign power. Subsection 2. The court interprets subject to the jurisdiction thereof differently. In its view, the phrase simply means subject to the laws that apply to everyone who is present within the country's borders. That interpretation, however, presents fatal problems. First, it gives the 14th Amendment's citizenship test a meaning that plainly differs from that in the Civil Rights Act, even though it is beyond any reasonable dispute that Congress did no such thing. To justify its departure from the Civil Rights Act, the court argues that the act raises more questions than answers, and that the 14th Amendment better expresses the views of the Reconstruction Congress. But as I see it, deciding whether someone is subject to any foreign power raises far fewer questions than deciding whether that person is subject to the jurisdiction of the United States. The court's commitment to avoiding the straightforward text of the Civil Rights Act strongly suggests that something is amiss. Second, the court cannot explain why the 14th Amendment did not confer citizenship on children born in the United States to tribal Indians. As explained, federal law governed those children and their parents to the extent the federal government wished. If the court were right that the citizenship clause applies to anyone who is born here and subject to our laws, then the 14th Amendment would have conferred citizenship to all tribal Indians. But the exception for tribal Indians was well established at the time and remained until Congress eliminated it by statute. Third, the court cannot explain why the phrase subject to the jurisdiction of the United States applies to naturalized citizens. All naturalized citizens, like everyone else who is present in this country, must obey the law, so if that phrase meant what the court thinks, it is superfluous. By contrast, if it means not being subject to any foreign power, it serves an identifiable purpose and explains why the naturalization statutes, both before and after the adoption of the 14th Amendment, required those seeking naturalization to renounce allegiance to any other country. For these reasons, the court's interpretation of the 14th Amendment's citizenship clause fails on textualist grounds. Subsection 3. The court does not confront these problems because it pays little attention to the constitutional text. Instead of performing its own textual analysis, the court leans on precedent that glosses the text. But none of the cases it cites analyze the text of the 14th Amendment's citizenship clause. The court first cites Lynch, but as Justice Thomas comprehensively explains, any reliance on Lynch is misplaced. Next, the court turns to Schooner Exchange versus McFadden, which held that a ship of war of a friendly power could enter a United States port without the risk of seizure. Neither that holding nor the reasoning in Chief Justice Marshall's opinion for the court has any bearing on the meaning of the terms of the 14th Amendment's citizenship clause. The question in Schooner Exchange concerned the circumstances under which a sovereign is deemed under the law of nations to have implicitly waived part of its otherwise complete sovereignty over its territory. The 14th Amendment, however, does not waive any part of the United States' sovereignty. It is true that the government has waived its sovereign right to subject covered diplomats and their dependents to legal process, but that is done by a statute that implements treaty obligations and respects long-established norms of international law. Neither that statute nor any treaty into which the United States has entered, nor any international law norm requires the United States to confer birthright citizenship on any child born here to alien parents. Subsection 4. The interpretation of the 14th Amendment's citizenship clause set out above is based entirely on the text and legal context of that amendment and the Civil Rights Act of 1866. It does not depend in any way on the record of the debates on those two enactments, but to the extent that congressional debates on the 14th Amendment and the Civil Rights Act are probative, they strongly support my textual interpretation. The clearest evidence was provided when the 14th Amendment's citizenship clause was presented in the Senate. As originally drafted, the 14th Amendment did not define citizenship. Senator Jacob Howard introduced an amendment that remedied that problem. Senator Lyman Trumbull, the author of the Citizenship Clause in the Civil Rights Act, explained just what the new amendment meant. The provision is that all persons born in the United States and subject to the jurisdiction thereof are citizens. That means subject to the complete jurisdiction thereof. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anyone else. That is what it means. This language, he said, was better than the language of the Civil Rights Bill, but the object to be arrived at is the same. Senator Howard concurred entirely in Senator Trumbull's interpretation. Thus, the authors of the two major provisions defining United States citizenship agreed that birthright citizenship required complete allegiance. Other senators quickly agreed. Senator Doolittle called the Civil Rights Act the forerunner of this constitutional amendment and said the Civil Rights Bill undertook to do the same thing as the 14th Amendment. Senator Reverdy Johnson, a member of the Joint Committee on Reconstruction and former Attorney General, pointed out that all that this amendment provides is that all persons born in the United States and not subject to some foreign power, for that no doubt is the meaning of the committee who have brought the matter before us, shall be considered as citizens of the United States. So too, Senator Williams remarked that he understood the words here subject to the jurisdiction of the United States to mean fully and completely subject to the jurisdiction of the United States. Footnote 6. There was no substantive debate on the Citizenship Clause in the House of Representatives. Carrying on. Public commentary on the Citizenship Clause exhibited a similar understanding. Those who disagree with this interpretation have not found any statement in which another senator expressly disputed Senator Howard's and Senator Trumbull's interpretation of the amendment. They muster a collection of statements that provide some support for their position, but it is a mistake to attribute too much weight to extemporaneous oral statements which are often phrased in ways that are not precise, and a single member's interpretation of a provision may not be shared by a majority. I do not suggest that we should base our decision in this case on statements made during the legislative debates on the 14th Amendment and the Civil Rights Act. Reliance on any form of legislative history is always problematic for reasons that are familiar. Floor statements by individual legislators rank among the least illuminating forms of legislative history. Here, the only form of legislative history we have consists of floor statements. We should base our decision on the firm ground provided by the constitutional text, but if we looked beyond that text, the congressional debates and public commentary confirm that the Citizenship Clause requires complete allegiance. Part 3. After the ratification of the 14th Amendment, Supreme Court cases quickly acknowledged the interpretation set out above. In the slaughterhouse cases, the court wrote that the amendment's Citizenship Clause was intended to exclude from its operation children of citizens or subjects of foreign states born within the United States. And in Elk v. Wilkins, Justice Gray's opinion for the court held that the Citizenship Clause requires not merely that a person born in the United States be subject in some respect or degree to the jurisdiction of the United States, but that he be completely subject to the United States' political jurisdiction and owe the country his direct and immediate allegiance. For that reason, John Elk, despite being born within the territorial limits of the United States, did not have a valid claim to citizenship by birth because he had been born on a reservation to tribal Indians. Indian tribes, the opinion explained, were alien nations, and their members owed immediate allegiance to the several tribes. Although Elk had voluntarily separated himself from his tribe and taken up his residence among the general public, he was born owing immediate allegiance to the tribe, and as a result was not entitled to birthright citizenship under the 14th Amendment. That was the state of the court's case law until Wong Kim Ark turned it in a different direction. That case provides the strongest support for today's decision, but its holding is not controlling, and I would not allow the meaning of American citizenship to be forever dictated by the opinion's dubious dicta. Wong Kim Ark cautioned against assigning too much weight to dicta, and it is appropriate to apply that same advice to the opinion in Wong Kim Ark itself. The court leans heavily on Wong Kim Ark, which certainly displayed the fruit of considerable research on a range of subjects, but it showed little respect for precedent. Justice Gray, the author of Elk, also wrote Wong Kim Ark, but he brushed Elk aside on the flimsy ground that it concerned only members of the Indian tribes and thus had no bearing on other children. Wong Kim Ark's treatment of the text of the 14th Amendment and its relationship with the Civil Rights Act's citizenship test was no better. Indeed, in reading the opinion, it is hard to escape the conclusion that it aimed to divert as much attention as possible from what those provisions actually say. The discussion of those provisions is broken up and interspersed with disquisitions on other matters. When the opinion finally turns to the text of the 14th Amendment, it summarily concludes that subject to the jurisdiction thereof in the Citizenship Clause has the same meaning as the phrase within its jurisdiction in the Equal Protection Clause. But the opinion makes no effort to explain why Congress might have chosen to use different language in two places within the same provision to express the same concept. As we have often noted, we usually presume that differences in language convey differences in meaning. Nor does the opinion explain why Elk had interpreted subject to the jurisdiction thereof very differently. As for the phrase not subject to any foreign power in the Civil Rights Act, Wong Kim Ark tries two different tacks. First, it suggests that the phrase means the same thing as subject to the jurisdiction thereof in the 14th Amendment. But if, as the opinion maintains, subject to the jurisdiction thereof essentially means subject to civil and criminal liability for breaking the law, then subject to the jurisdiction thereof does not mean the same thing as not subject to any foreign power. Everyone within the country's borders, except those with diplomatic immunity, may be held civilly or criminally liable for violations of the law. But many aliens within our territorial limits are also subject to a foreign power, i.e., their home country, because they must follow that country's laws when they are abroad. Some countries, Mexico for example, even mandate military service for those living abroad. Footnote 7. This is just a citation to that effect, so I'm not going to read it out. Carrying on. So in ordinary usage, being within the United States and having an obligation to obey U.S. law while here is definitely not the same as not being subject to any foreign power. Wong Kim Ark's fallback argument is no better than the first. The opinion speculates that Congress might have thought that not subject to any foreign power trimmed the birthright citizenship rule too much, and that this accounts for Congress's use of different language in the 14th Amendment. That suggestion flies in the face of all the reasons previously mentioned why the citizenship tests in the Civil Rights Act and the 14th Amendment must be understood to be substantively identical. That is the extent of Wong Kim Ark's analysis of the terms of the 14th Amendment's citizenship test, and I would not carve an interpretation of the citizenship clause in stone based on such dubious dicta. And dicta it is. Sometimes it is not easy to determine the exact contours of a decision's holding, but the opinion in Wong Kim Ark obviates that problem. At the end of the opinion, the court clearly spells out exactly what it held. Quote, a person born in the United States of parents of Chinese descent, who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States. End quote. Thus, the holding of the case was limited to a child born in the United States to parents who were not citizens but had established a permanent domicile and residence here. Many other key passages in the opinion confirm this fact. Quote, when the parents are domiciled here, birth establishes the right to citizenship, end quote. The Citizenship Clause, quote, includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States, end quote. Quote, every citizen or subject of another country, while domiciled here, is within the allegiance and the protection and consequently subject to the jurisdiction of the United States, end quote. Quote, subjects of the Emperor of China but domiciled in the United States must be held to be subject to the jurisdiction of the United States, end quote. The court dismisses these pointed and repeated references to domicile, arguing that domicile was merely an incidental fact and not an element of the holding. But Justice Gray had a good reason for pointing out that Wong Kim Ark's parents had established their domicile here. A person's domicile is the place where he or she intends to live indefinitely. Therefore, the fact that they had established domicile here meant that they wanted to make the United States their home. It is telling that Justice Gray's statement of the holding also mentioned that Wong Kim Ark and his parents were Chinese. The British birthright subjecthood rule did not take account of the race or nationality of the alien to whom a child was born within the king's domain. So if the opinion aimed to adopt the British rule, with the one new exception for tribal Indians, there was no need whatsoever for the holding to say anything about the race of Wong Kim Ark or his parents, yet it did so. And not only that, the opinion spent many paragraphs describing statutes, court decisions, and debates in Congress about the plight of Chinese immigrants. The opinion also properly stressed that the fundamental objective of the 14th Amendment was to protect the rights of people of all races. When we understand the situation Wong Kim Ark and his parents faced, their domicile in the United States takes on a special meaning. If they had been white or black, they could have applied for naturalization. Footnote 8. This is just a citation to that effect, so I'm not going to read it out. Carrying on. But because they were Chinese, the law forbade their naturalization. By establishing domicile, they had done everything within their power to express their desire and intent to become Americans. If the court had not interpreted the citizenship clause in the way set out in the holding, the result would have been a population permanently caught in limbo. The Chinese immigrants who were lawfully present before the enactment of the Chinese Exclusion Act in 1882, as well as all their descendants, could never become citizens no matter how much they wanted to be Americans, no matter how deep their roots in this country, and no matter how substantial their contributions to our society. Wong Kim Ark is therefore best understood as holding that people who are lawfully present here, establish the United States as their intended permanent home, and do everything within their power to become United States citizens can be seen as no longer subject to any foreign power. Footnote 9. The majority accuses me of creating an ad hoc exception to the rule of complete allegiance for those who have done everything in their power to become United States citizens. But that is a surprising line of attack for the majority. After all, the exception comes from Wong Kim Ark, a decision the majority fully embraces. Wong Kim Ark, in turn, had to recognize this exception to effectuate the 14th Amendment's protections in the face of the discriminatory Chinese Exclusion Act. Regardless, as far as exceptions are concerned, the court has more to explain than I do. The court has not offered any satisfactory explanation for how the federal rule it champions coheres with the new, distinctly American situations regarding Indians, slaves, and free blacks. Carrying on. Thus, their children are born citizens under the 14th Amendment. That interpretation of Wong Kim Ark is consistent with the decision's statement of its holding. It can be reconciled with the language of the 14th Amendment and the Civil Rights Act, and for the Chinese Americans of Wong Kim Ark's time, it was the interpretation that best implemented the 14th Amendment's promise of racial equality. Part 4. Wong Kim Ark benefited Chinese Americans, but its impact on other immigrants was limited. For decades after that decision, immigration remained largely unregulated. During World War I, however, the federal government began to limit the flow of immigrants. In 1917, Congress passed a law that excluded all Asians, implemented a literacy test, and included a long list of criteria for admission. Later laws, most notably the Discriminatory Immigration Act of 1924, continued this trend by imposing quotas based on immigrants' country of origin. From that time until the enactment of the Immigration and Nationality Act of 1965, immigration, both legal and illegal, was light, and the number of Americans born abroad shrank from 13.9 million in 1920, when the population was just over 100 million, to less than 10 million in the 1960s, when the population grew to over 200 million. Footnote 10. It is just a citation to that effect, so I'm not going to read it out. Carrying on. After 1965, however, immigration increased dramatically and the problem of illegal immigration grew. The story of illegal immigration unfolds in 4 parts. First, illegal immigration emerged as a notable problem in the 1970s. Second, the federal government tried to deal with this problem in 1986 by implementing employer sanctions and amnesty for millions of immigrants, but that attempt failed. Third, the federal government, with help from this court, blocked border states from implementing their own solutions to a problem that hit them particularly hard. Meanwhile, other states, counties, and cities designated themselves sanctuary jurisdictions, thus encouraging illegal immigration. Finally, as a result of those developments, the number of illegal immigrants in this country exploded. Section A. Illegal immigration emerged as a national problem in the 1970s, after Congress passed the Immigration and Nationality Act of 1965. That act eliminated immigration quotas based on national origin and replaced them with a preference based immigration system that included an overall cap of 290,000 immigrant visas per year. But demand for visas vastly outstripped supply, thus encouraging migrants to subvert the legal process. Many immigrants entered or remained illegally for economic reasons. In the United States, opportunities abounded to pick crops and do other 3D, dirty, dangerous, or demeaning jobs. American employers were all too willing to hire employees who would work for less than the minimum wage and without the benefit of laws protecting employee rights. Yet even these poor working conditions surpassed those in the home countries of many immigrants. This situation created a strong incentive for immigration, both legal and illegal. As a result, immigration, both legal and illegal, soared. Demographers generally assumed that the size of the illegal immigrant population in 1960 was negligible. By the end of the 1970s, however, a conservative estimate of the number of illegal immigrants was 3 million. Section B. Early efforts to solve the illegal immigration problem failed. In 1977, President Carter imposed an immigration overhaul that floundered due to opposition from his own party's core constituencies, including labor unions, Hispanic groups, and environmentalists. In 1986, more than 20 years after the passage of its last major immigration bill, Congress agreed to do something about illegal immigration. It passed the Immigration Reform and Control Act of 1986, IRCA. This court, in an opinion by Justice Stevens, described IRCA as a major statutory response to the vast tide of illegal immigration that had produced a shadow population of literally millions of undocumented aliens in the United States. IRCA made it unlawful to hire or to recruit or refer for a fee an alien knowing the alien is an unauthorized alien. To implement this program, IRCA required employers to review documents establishing identity, such as a driver's license, employment authorization, such as a social security card, or both, such as a U.S. passport. IRCA also increased funding for border security and immigration enforcement. IRCA balanced harsher enforcement with a plan to legalize the status of millions who were living in the United States illegally. Immigrants could obtain legal status in two ways. First, they could file an application showing that they had resided in this country continuously since before 1982, had been physically present here since the date IRCA became law, November 6, 1986, and would be admissible if they were coming legally. Second, they could certify that they had resided in the United States for at least a year, had worked in agriculture for at least 90 days, and were admissible. Given the less stringent criteria for the latter legalization pathway, it proved much more popular. The number of applications under the agricultural pathway far exceeded estimates, at least in part because of fraud. Ultimately, almost 2.7 million illegal immigrants obtained legal status under the two pathways. Despite IRCA's ambitious aims, it failed to curb illegal immigration. The work verification and employer sanction system did not eliminate the strong economic incentive for illegal immigration. Immigrants easily forged, stole, or shared documents like photoless driver's licenses and social security cards to provide verification of identity and employment authorization to their employers. And the law supplied little reason for employers to smoke out these fraudulent documents. On the contrary, if an employer requested additional documentation, he or she faced penalties imposed to ensure that employers did not discriminate against foreign-looking or sounding workers. Under-enforcement of IRCA rendered its employer sanctions nearly toothless. IRCA's increased border enforcement did not help either. Although IRCA may have caused a short-term decrease in migration, the law failed to discourage undocumented immigration in the long run. Congress has not passed comprehensive immigration legislation since 1986, in part because voices across the political spectrum have criticized any attempts at serious reform. For example, President George W. Bush's immigration reform proposal met with skepticism from conservatives who argued that it amounted to amnesty for illegal immigrants. Meanwhile, liberals and labor unions criticized the plan for not going far enough to address illegal immigrants' plight. Section C. When Congress failed to solve the illegal immigration problem, states stepped in. California led the way in 1994 with Proposition 187. That law stated every law enforcement agency in California shall fully cooperate with the United States regarding any person who is arrested if he or she is suspected of being present in the United States in violation of federal immigration laws. Proposition 184 also excluded illegal immigrants from public social services, publicly funded healthcare services, and, most controversially, public education from elementary school through university. Although California voters overwhelmingly approved Proposition 187, the measure never went into effect. A federal district court enjoined the law, and then a new governor settled the lawsuit. As illegal immigration continued to climb, states tried to lessen its effects. For example, Arizona passed a law in 2007 that allowed courts to suspend or revoke business licenses for those who employed illegal immigrants. The Chamber of Commerce sued, arguing the law was preempted, but this court disagreed. Following that victory in this court, states worked to ameliorate the illegal immigration problem. In 2008 alone, 13 states passed laws punishing employers for hiring unauthorized workers. Arizona went further in 2010 with a law that punished illegal immigrants for working or failing to register. The law also gave law enforcement the ability to arrest, based on probable cause, those suspected of violating the immigration laws and required verification of individuals' immigration status during stops, detentions, and arrests. At the United States' urging, the court held that federal law largely preempted Arizona's efforts. The litigation between Arizona and the United States inaugurated an era in which the federal government and states resisted each other's efforts to address illegal immigration. Texas, in particular, repeatedly challenged federal immigration policies that the state alleged increased illegal immigration. But the state met with little success in this court. The trouble began when Texas unsuccessfully challenged the 2021 termination of an earlier administration's border enforcement policies. The state also lost in this court when it tried to stop the government's deprioritization of immigration enforcement against some criminal aliens. This court thus greenlighted a policy that prohibited immigration officials from making enforcement decisions based solely on criminal convictions, no matter how serious. For its part, the federal government sued to stop Texas from implementing its own solutions to illegal immigration. When illegal entrants overran Texas border towns, the state erected barbed wire fencing, but Border Patrol officers cut or displaced the fencing. As the lower courts found and a video confirms, the federal officers installed a climbing rope on the Texas side of the river and made no effort to turn back a stream of migrants who were wading across the Rio Grande. Instead of processing the entrants, border officers simply told them to walk a mile or more without supervision to the nearest immigration processing center. Footnote 11. This is just a citation to that effect, so I'm not going to read it out. Carrying on. Then, from the comfort of chambers more than 1,000 miles from the southern border, this court sided with the federal government, allowing immigrants to pour into the state. Likewise, the government sought to stop Texas from criminalizing illegal entry or re-entry into the state. Although the court denied that application, the federal government's message was clear. Even in the midst of a crisis, self-help is not an option. In short, the federal branch and this court left border states, the ones that bear the brunt of the country's illegal immigration problem, practically defenseless against illegal immigration. Meanwhile, other states, counties, and cities encouraged illegal immigration by becoming sanctuary jurisdictions. These jurisdictions prohibit their law enforcement officers from cooperating with federal immigration officials. They often refuse to share information with federal immigration officers or to honor the federal government's request to briefly extend the detention of those suspected of being in the country illegally. Many also prohibit police officers from asking about immigration status. San Francisco passed some of the first such ordinances in the 1980s. After 2008, the number of jurisdictions with sanctuary policies increased significantly. According to a list published by the Department of Justice, 11 states and the District of Columbia, 3 counties, and 18 cities are sanctuary jurisdictions. Footnote 12. This is just a citation to that effect, so I'm not going to read it out. Carrying on. But the number is likely significantly higher. Section D. Congress's failure to act, the executive branch's enforcement policies and frequent opposition to state solutions, and some jurisdictions' policies have resulted in a massive increase in the number of illegal immigrants living in this country. According to leading demographers at Pew Research Center, the illegal immigrant population grew by more than 2 million between 2022 and 2023, bringing the total number of illegal immigrants in this country to 14 million. Demographers estimate that 9% of all births in the United States in 2023 were to mothers who were in the country illegally or on a temporary basis. Footnote 13. This is just a citation to that effect, so I'm not going to read it out. Carrying on. These numbers are striking, and after 2023, the trend appears to have intensified. Between July 2023 and March 2024, the overall foreign-born population of the United States increased from 48.5 million to 51.6 million, an unprecedented increase of 3 million immigrants in 9 months. Much of this growth was driven by the admission of unauthorized immigrants with temporary deportation protections. As a result of the events of the past 50 years, the United States now has a large contingent of people who entered or remained in this country illegally, as well as a large group of people who were born here to such parents. The court's interpretation of the 14th Amendment makes all the members of this latter group citizens. Many of those who have grown up here now have a strong moral claim to be allowed to remain, but that is a matter that the 14th Amendment, when properly interpreted, leaves to Congress. Part 5. As shown in Part 2 Supra, a person who is born in the United States is made a citizen by the 14th Amendment only if that person was also subject to the jurisdiction of the United States, and that phrase means subject to the jurisdiction of the United States alone and not subject to any foreign power. A great many persons who are born here to illegal immigrant parents fail this test because at birth they are automatically made nationals of their parents' native country and, as a result, incur duties to that country. This means that they are subject to a foreign power and are thus not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. This is illustrated by the laws of countries on the list of those from which the greatest number of illegal immigrants come. Footnote 14. This is just a citation to that effect, so I'm not going to read it out. Carrying on. Mexico is at the top of that list, and under Mexico's constitution, the child of a Mexican parent can become a Mexican national at birth and acquires certain duties to the government. Among these are the obligation to receive military training and join the National Guard. Guatemala is second on the list, and its constitution also confers Guatemalan nationality on a person born abroad to a Guatemalan parent. All Guatemalan nationals owe certain duties to the government. At the age of 18, a Guatemalan national automatically becomes a Guatemalan citizen, and thereby acquires additional obligations. El Salvador is also among the top 5, and its constitution provides that children of a Salvadoran father or mother born in a foreign country are Salvadorans by birth. Upon reaching the age of 18, these children incur an obligation to serve in the military, as well as other duties, including the duty to serve the state in conformity with the law. Many other countries among the top 10 has similar laws. Respondents' claim in this case is that Executive Order No. 14,160 is unconstitutional on its face. To prevail on this facial claim, they must show that no set of circumstances exists under which the executive order would be valid. And because the order is valid as applied to nationals from the countries discussed above, the claim should fail. In all likelihood, the executive order is also constitutional as applied to nationals from a great many other countries, but no such showing is needed here. Indeed, showing merely that the executive order is valid as applied to a child born to a birth tourist would be enough to defeat respondents' facial claim. That is why the court goes out of its way to hold that even a child born to a mother who is here only for a brief time is a citizen under the 14th Amendment. The court's interpretation is not only contrary to the original meaning of the 14th Amendment, it produces grotesque results. While foreigners who wish to immigrate lawfully must sometimes wait for many years, a child born here to a birth tourist is automatically a citizen. The court's interpretation also has national security implications. Suppose that a person's only connection to this country is that he was born here to a mother who was present just long enough to give birth and then quickly returned to her native country. Suppose that country is a strategic adversary or enemy of the United States. Suppose the child never visits the United States while growing up and was inculcated with hatred of this country. According to the court, that person is a citizen of the United States. He can enter and leave the country as he pleases. He can travel the world on a United States passport. Even if he plots to harm this country, he cannot be deprived of his status as a citizen, at least under current precedent. The court's interpretation saddles this country with an ancient British rule that even the United Kingdom has abandoned, as have other countries whose legal systems share the same pedigree. Footnotes 15 and 16 are just citations to that effect, so I'm not going to read them out. Carrying on. The court's interpretation preserves a powerful incentive to enter or remain in this country illegally. Immigrants naturally prefer affluent countries where economic opportunities are available. Other than Canada, the United States will be the only affluent nation where birth alone is enough to establish citizenship. Footnote 17 is just a citation to that effect, so I'm not going to read it out. Carrying on. If the 14th Amendment required these results, the country would have to live with them or amend the Constitution. But the 14th Amendment does not include the rule the court now imposes on the country. In my judgment, the court has made a mistake that will seriously affect the country's future. For that reason, I respectfully dissent. Justice Gorsuch dissenting. At the heart of today's dispute lie two competing views of the 14th Amendment Citizenship Clause. On one account, the clause incorporated the English common law rule of jus soli, literally the right of the soil. That rule, developed in feudal times, had more to do with being a subject than a citizen. It was based on the notion that a man owed personal service to the lord of the soil, the same as his master owed it to the king, and it was born with the child and only ended in the grave. On the other account, the clause adopted a distinctly American settler's view of citizenship, one that promises full dignity and glory of American citizenship to any child born in this country to parents who have made this nation their permanent home, regardless of their race, religion, or national origin. To my eye, the latter understanding better accords with the clause's original public meaning, and that leads me to join Justice Thomas's dissent. I write only to emphasize a few points. First, the understanding Justice Thomas and I share of the Citizenship Clause is consistent with the court's holding in United States v. Wong Kim Ark. That case involved parents born in China who had made their home in this country lawfully even though they never became naturalized citizens, and statutes then in effect made that impossible. The question the court faced was whether the parent's child, born in this country, was himself a citizen. The government argued that the child was not a citizen because his parents were not. This court rightly rejected the government's position. Throughout history, many other nations have restricted citizenship by birth to the children of citizens. But the American settlers' view of citizenship reflected in the Citizenship Clause is not so parsimonious. What matters isn't whether a child's parents are citizens. What matters is whether they, and by law their child at birth, have made this place their home and are thus domiciled within the United States. Second, respondents chose to pursue a facial challenge to the executive order at issue in this case and secured below a preliminary injunction barring every one of the order's potential applications. Under this court's precedents, we can sustain that injunction only if no set of circumstances exists in which the order may be applied lawfully. That is a demanding standard, and it is not met here. Among other things, the executive order holds that children born to temporary visitors in this country, whether here lawfully or unlawfully, are not citizens, and at least to that extent, the order is consistent with the Citizenship Clause as Justice Thomas and I read it. By definition, temporary visitors to this country do not choose to make a permanent home here, and their children thus cannot claim the privilege of citizenship. Because the executive order is lawful at least to this extent, respondents' facial challenge must fail. Finally, just because the executive order has some lawful applications and can survive a facial challenge does not mean it is lawful across the board and immune from narrower legal challenges. Besides addressing temporary visitors, the order also denies the benefits of citizenship to children born in this country to parents who make their permanent home here, but do so in defiance of federal immigration laws. The government insists that aspect of the order can survive any possible legal challenge too, because individuals can secure domicile in this country only if they do so in compliance with federal law. About that, however, I harbor doubts. Perhaps Wong Kim Ark does not squarely foreclose the government's position. After all, that case addressed a child born to parents who lawfully resided in this country. Still, I wonder, is a child born here to parents who have long chosen to make this nation their permanent home not a citizen under the 14th Amendment solely because his parents' presence violates statutory law? If those parents are not domiciled here, then where are they domiciled? And if the answer is nowhere, how can we reconcile that conclusion with this court's long-standing recognition that every person is domiciled somewhere? Because the executive order is not facially invalid, these questions may not be properly before us, but their answers are undeniably important to a nation committed to a view of citizenship open to all children born here to parents who can call this country their home. And that does it for the opinions of the justices. So now we'll get into the opinions of the hosts. And for today's episode, Will is once again joining us.
Great to be back.
Great to have you back. So yeah, we can, without further ado, I guess we can just get into it. I figure since there's kind of a lot to talk about in this one, I mean, it's like 194 pages of opinions.
Yeah,
Uh,
and 90 of those pages are just
Thomas.
Thomas's dissent, yeah.
Yeah. Um, yeah, I figure at least just like to keep my thoughts straight, just kind of going through the opinions in the order they were written is probably the easiest way, but if you have any way you would prefer, that's totally cool too.
No, that's fine. I think that the order of the opinions lends itself to to being
Mm,
read, majority through, 'cause, I think that at the very least, in terms of the concurrences or partial concurrence in the case of Kavanaugh, um, it all sort of relies on the majority's reasoning, so we can
yeah.
start. We can begin at the beginning, as they say.
Editing Bailey here. Spoiler, we didn't exactly do that. Yeah, like at the outset, like uh we talked about this briefly. We don't really discuss these cases much before we uh actually record for these episodes, but when the case came down, one of the first things I did was like, okay, let me look at the composition of the votes and like who joined the majority, who dissented, and I was really expecting it to be like 7-2, or potentially even more against the administration. So I was really surprised to see it was 6-3 as to the judgment and
And
5-4 as to the
5-4 as to the
reasoning.
reason. Yeah, I was genuinely surprised by that. I really thought there would be more consensus, but I guess this was, more divisive than first blush would indicate. And, the as both the majority and the dissent tried to rely on sort of historical context in order to justify their positions.
Mhm.
Um, I'll say at the outset, probably to no surprise to you, that I was much more convinced by the Roberts majority. um, I think that especially their references to and reliance on the common law tradition that we inherited from the UK really helps bolster this idea of birthright citizenship being not contingent on some other kind of allegiance test or domicile test or whatever. Um, and I think it's worth noting this is pretty much tangential to the opinion itself, but I think it is worth noting for posterity that uh, the United States is not the only country that has unqualified citizenship from birth.
Mm.
Most of the Americas do have in some form or another. It's like something like 30 countries globally, most of which, as I said, are in the Americas, North and South America. Um, but we're not an outlier in that regard per se. But in the grand scheme of nations, 200 whatever, we are in a comfortable minority.
Yeah, I never, I never really believed the people that well, I shouldn't say never, I'm sure there was a time where I did, but, um, at least as far as this case was concerned, the timeline of this case, yeah, I didn't really believe the people that were like, "We're the only ones." It's like, I don't think we're the only ones, there's a lot of countries. Um, and of course, it doesn't matter for the legal, the legal analysis. So it's like, I don't care if we're the only ones. If that's what the Constitution demands, that's what it demands. Yeah, I didn't have any really strong opinions coming into this case. Again, we talked about my thoughts briefly, but it kind of was like, for me, all right, we're going to see who convinces me. And yeah, after I finished reading the chief's opinion, I thought it was fairly strong. I thought it was pretty compelling, and I was going into the later opinions, Thomas's and whatnot, honestly, kind of like, okay, are they really going to be able to convince me away from the Chiefs? Like, I wasn't really thinking so, but yeah, I won't go too much further than that. But yeah, the majority opinion, struck me as fairly well reasoned. Yeah, you've got this tradition from the British common law. You've got nothing at least clearly abrogating it. I mean, yeah, I guess there's really not too much
Yeah, I mean,
more to the majority's opinion. I guess it is fairly
yeah,
short in the grand
not to
scheme of
mention
things.
not to mention though, well, yeah, exactly, but also not to mention that, the textual case in this case was very strong. You know, the plain reading of the 14th Amendment, which was, I think, the very little that we had discussed prior to actually reading the opinion.
Mhm.
The plain reading of the citizenship clause, really lent itself to this understanding of, with the exception of people who are subject to foreign jurisdictions, diplomats and the like. Um, this citizenship by birth is very plainly intended. There's no there's no internal text uh, to the Constitution whatsoever that suggests that there's a domicile requirement, for instance, which was a heavy fixation for the petitioners in oral arguments, uh,
Mhm.
to try and distinguish this from the uh, Wong Kim Ark case that had been decided a century prior.
Yeah, I guess that is, sort of one other thing that I had to say about the majority is that the so yeah, the majority adopts a, I guess you'd say, more conventional or more ordinary understanding of the phrase "subject to the jurisdiction thereof," but not quite the sort of, like, most conventional or, most straightforward and literal understanding because, the straightforward, literal understanding of that phrase, that, like, a lot of proponents of birthright citizenship were like, "Obviously, it's this because jurisdiction means this." Like, the the most literal sense of that phrase is just, are you subject to liability if you violate the laws of the United States?
Yeah.
And everybody on US soil is subject
Oh,
to
yes,
prosecution.
exactly.
So, there obviously it can't really mean that because there are these long-standing exceptions to birthright citizenship that have been, recognized were recognized in Wong Kim Ark, have been recognized, seemingly by the framers and commentators and whatnot around the time of ratification. So can't mean that, but the the majority, still adopts a more conventional view that it's like I think they sort of framed it as like the full governing authority of the United States or the full governing authority of the sovereign.
Yeah. And I think that maps on pretty well with, at the very least, conventional understanding of, well, of, like, the concern of illegal or overextended immigrants, coming here, and who get pregnant or are pregnant and then give birth here, which is to say that, like, these can't be stateless individuals. And let's take Mexico, for example. The state of Mexico might not, I'm not familiar enough, but the state of Mexico might not offer automatic citizenship to the child of Mexicans. There might be another process there. So if you come to the United States and give birth, the narrower interpretation of the 14th Amendment may end up with a situation where you are allowing children to be born stateless. And at least under the modern paradigm of international law, that is a big no-no. um, the most logical solution to that being, it's like, okay, well, maybe you can say that children of a Mexican citizen is a Mexican citizen no matter where they're born. Americans do more or less get that treatment. We don't have
Mhm.
to be born on American soil to be naturalized, to be natural born citizens. We just that's just the primary way. Um, but another way to solve that issue is to say, hey, well, I mean, look at where they're born. You know, like what is the country of their birth? What is the country that they are living in, that they are domiciled in, that they are, and that's where the domicile argument kind of comes back in, where it was confusing to me, and I realize we're drifting more into the dissent take on this because you're probably right that there's not as much to talk about in the majority because it's again it's very consistent and straightforward with I believe the tradition as it has existed at least in the popular consciousness for birthright citizenship. But if you're talking about domicile, it was confusing to me. It was confusing to me the idea that a child of immigrants born in the United States isn't domiciled in the United States or has allegiances to some country that isn't the United States.
Right.
If they're
Um
not like traveling back and forth, if they're not like, you know, undergoing a secret internal like Mexican education within the territorial confines of the United States, it's like, what kind of allegiance do you think this child would have? They're growing up
Yeah.
here, they're living here, they're learning our culture, our language, they're in our education systems theoretically, right? Like,
Mhm.
it's hard to make a more compelling case that somebody is uh, American by birth under those circumstances.
Yeah, well, and I think the problem is there might be a bit of imprecision throughout all of the opinions potentially about, like, exactly what we're talking about, like, exactly what the relationship between, like, domicile and allegiance and jurisdiction and all of this are. The way I read, uh, Thomas's dissent was or at least his discussion of domicile is essentially synonymous with just permanent residence. And so, like, domicile doesn't require uh, any additional allegiance or connection. It's just here is where you permanently reside or intend to permanently reside or whatever. And then the domicile of the child, them being incapable of really choosing where they live until they come of age, that just follows the domicile of the parents is what I understood Thomas to be arguing.
Yeah, that is ultimately where they go. Which I think kind of has its own issues. Not so much when it comes to temporary travelers, because there was this distinction drawn between
Mhm.
illegal immigrants seeking permanent residency and legal immigrants. It seemed engaging in temporary residency, right? Um, if an illegal immigrant, uh, in whatever context that word is being applied, uh, intends to leave their homeland and come to the United States, again, it seems weird to suggest that that isn't a domicile, that they aren't changing their domicile to the United States.
Right,
Admittedly, it isn't. They haven't re-domiciled within the context of our laws,
right. Well, and this
but they
is
are literally not domiciled in their home country anymore. So again, it faces it runs back into that issue.
right, well, yeah, and this is something that Thomas and Gorsuch point out, and this is something I should have pointed out from the start, because seemingly no, like, lay commentators on either side noticed this, because people on the right were like, "Oh, look at these 5 justices dissenting," or 4 justices dissenting, rather, like, yeah, it was a really narrow split. No justice on the court would have voted to exempt the children of illegal aliens permanently residing here from birthright citizenship. Kavanaugh's view on the Constitution, I think, permits that result, But other than him, because he took kind of a statutory off ramp, Alito's
Yeah.
view is kind of the closest to that, where presumably a great majority of children of illegal aliens would fail his test. But Thomas and Gorsuch, and they explicitly say this, that they like left the question of illegal aliens domiciled here for another day. But their theory would seem to suggest, no, yeah, the children of illegal aliens who are permanently residing here, or at least intending to permanently reside here, would be entitled to birthright citizenship. Both Gorsuch and Thomas kind of raise the specter of this question of like, okay, can somebody be domiciled here if they're not legally entitled to remain? Maybe, maybe not. I think Gorsuch, from what I know of Gorsuch and what I read of his very short additional concurrence, on top of Thomas's that he joined, I think he's pretty sympathetic to the idea that no, the children of illegal aliens domiciled here are birthright citizens. I'm not quite sure about
Yeah, he
Thomas, but
Gorsuch was very explicit about the fact that he thought
yeah,
that the executive order was constitutional with respect to temporary visitors only.
right.
And by implication, definitely at the very least, if not explicitly, I can't recall exactly, but certainly by implication, he seemed to suggest that the children of illegal immigrants would be entitled to birthright citizenship, at least under most circumstances. Again, I think the dissent, for what it's worth in terms of the nuance that was attempted to be offered, and I'm including Kavanaugh's partial dissent in this
Mhm.
dissent question. Um, uh, they they were definitely operating in a way where they wanted to narrow the scope of the 14th Amendment, but not do so in a way that is totally consistent with, I think, the nativist
Mhm.
goals or impulses of the executive order as it was written. Right. I think that the justices themselves recognize that not only legally, but probably for several different policy reasons, um, uh, there is a serious difficulty in trying to restrict birthright citizenship in the way that was desired or implied under the executive order.
Yeah. Yeah, and yeah, yeah, I was definitely certain the executive order was, went too far. I mean, even ignoring the fact that you're trying to set the meaning of a constitutional provision by executive fiat, like, that's a problem in and of itself. But also, the executive order didn't really give a plausible reading of the 14th Amendment, I don't think. Like, yeah, uh, I guess I haven't said yet in our discussions of the dissent. Upon reading the dissents, um, I did, or at least Thomas's, I did find it more compelling than I expected that I would. And I don't know. I think he's convinced me away from the the majority's opinion somewhat because the I guess how do I put it, the domicile sort of understanding of subject to the jurisdiction thereof. I think Thomas makes a stronger case than I expected that no, that is just the original public meaning of that phrase and similar phrases from the Civil Rights Act of 1866, which is the predecessor statute. And then he does also a better job than I expected, kind of poking holes in the majority's common law argument, saying, like, this isn't actually all that well grounded. Like, the majority relies very heavily on some not very authoritative sources here.
Yeah. I think that I don't disagree with that assessment, but to sort of add on to it, and I would say remeasure um, Thomas's dissent, I think that there is this hyperfixation on the exact time and manner in which is very common amongst originalists, right? It's kind of their whole mo. But there's this hyperfixation on the time and place in which this provision in the 14th Amendment and the 1866 Act were written, and trying to rely on that in order to understand the meaning as it has come to be understood. Not only was the 1866 Act, amended and replaced with a statute of with different language. But also, more importantly, um, I think that in order to understand the 14th Amendment, textually speaking, we can't just wedge it in the time and context in which it was written, which was for African Americans and freed black slaves, because it wasn't written in a way that relies on that context, right? The writing, the exact language used in the 14th Amendment does not rely upon the fact that it is referring to freed slaves. It does not rely on the
Mhm.
fact that it is referring to people with primary allegiances to the United States and no other country. I think that the fact that such generic language was used in the 14th Amendment evidences an intent by its drafters, though the primary or overwhelming intent of the drafters in creating it might have been specifically to address the slave question or the post-slavery question. Um, it seems incontrovertible to me that a subsidiary intent or a tacit intent of the drafting of the 14th Amendment as written was to include people who would not be considered who would be considered natural born American citizens, but who wouldn't fit within that narrow box of the post slavery uh,
Mhm.
people. You know,
Right. Yeah, and I mean, I know there is, like, language in the dissent talking about, yeah, that being the context and that the sort of predominant purpose or intent or whatever, had to do with settling the question of citizenship for freed slaves, overruling Dred Scott, but I don't think the dissent relies too heavily on that, and those weren't really the arguments that I found, uh, the most compelling because, yeah, I mean, I agree. The 14th Amendment is obviously speaking in broader terms, and, just because there's this primary legislative intent, well, the primary legislative intent's not the law. The text that they actually wrote down to achieve that intent is the law. Uh,
right?
and so the other thing is that, like, you mentioned how the 1866 Act is, it's the predecessor statute was, then amended, or rather the Constitution was amended to sort of displace it. And this was one of the more compelling arguments that I heard from Thomas. There was then a subsequent act in 1870, the Enforcement Act, that, you know, was it was written to enforce the provisions of the 14th Amendment as Congress has the power to do under Section 5. And it basically reenacts the same relevant language the from the Civil Rights Act. And so then, Thomas's arguments about the language from the Civil Rights Act is not subject to any foreign power kind of really come into force there, because it's like this is the ratifying Congress 2 years after ratification writing a law to enforce this provision. So, like, this not subject to any foreign power language has to be relevant because, presumably the people in the best position to understand what this language actually meant and who just ratified it aren't then immediately violating it. And yeah, I don't think the majority was right to kind of brush off the Civil Rights Act language um, as kind of flippantly as it did.
Well, the I guess the amendment that I'm speaking of is not because you're right. Yes, there was after the ratification of the 14th Amendment, there was this 1970 or 1970 1870 law. Um, but come around to I'm thinking more the Nationality Act of 1940,
Mhm.
some 50 years later, where I think our understanding of the material implications of the 14th Amendment uh, were not better, but they were definitely different. More coincided more with this modern interpretation, with this modern understanding of birthright citizenship. And so we get to, Title 8, Section 1401 that tries to codify this modern understanding. And I think with that codification, it is no longer, not that it's completely irrelevant, but is no longer as relevant as I think Thomas implies it to be, that there was this statutory history in the late 1800s, because that statutory history has been abrogated by Congress.
Right. Well, and this kind of gets into Kavanaugh's partial concurrence actually, because he kind of makes a similar argument on statutory grounds. He says like, well,
Right.
there's this modern understanding of birthright citizenship that was seemingly codified by Congress um in the 90s. And so at least for statutory purposes, that understanding is what controls here. But I don't think that really matters for the constitutional analysis. And that's kind of what I'm getting at when I'm saying like the Enforcement Act of 1870 matters, because it's literally the Congress that wrote and ratified, or at least much the same Congress. There might have been like a House election in the interim or something, I don't know. Um, but it's much the same Congress that wrote and ratified the 14th Amendment, then writing a statute to enforce the provisions of the 14th Amendment. And they're re-ratifying, in order to do that, they're re-ratifying the language from the Civil Rights Act that's not subject to any foreign power. So, like,
Right.
I think there's an even stronger argument than, since you've got not subject to any foreign power sort of bracketing the 14th Amendment, or the ratification of the 14th Amendment in time. I think there's a very strong argument that like that language has to mean something or inform our understanding of what's subject to the jurisdiction thereof. And
Oh,
absent,
I mean, sorry, yeah.
yeah, absent that post enactment thing, like okay, then there's an argument about how relevant really is the Civil Rights Act of 1866 and its language. But
Yeah, I certainly agree from a historical perspective that like Congress's understanding of the 14th Amendment uh, as having this additional caveat, um, as not being subject to foreign power, uh, certainly framed the way that they understood the 14th Amendment. And again, insofar as you want to use legislative intent and relate that to constitutional analysis, that is compelling. My concern, though, is that at that point we are no longer doing actual constitutional analysis, uh, because my interpretation would be that the Constitution allows for Congress to more narrowly define what the 14th Amendment means because of its vagueness. And so at that time, Congress did define it narrowly. But since then, Congress expanded its definition to no longer have that foreign powers caveat. Um, Before Trump v. Barbara came out, I believe that Congress probably did have the authority to control that. But unfortunately for I think Kavanaugh's position, um, the illegality of this executive order, um, under the uh, Title 8, Section 1401, um, brought this case to the court. And now the highest court has decided in no uncertain terms that birthright citizenship is X under the 14th Amendment, not X plus or minus whatever Congress says. Uh,
yeah, and
it's sort of it has settled a legal issue at the constitutional level that I think before now was reasonably and legitimately construable within Congress's purview, if
I
that makes sense.
yeah, yeah, it makes sense. I don't know that I agree. um, I don't. Yeah, I mean, I don't know. I've got the immediate sort of knee jerk issue of like, Congress effectively changing the meaning, Congress being like permitted to effectively change the meaning of the Constitution. Like, I understand the Constitution giving Congress, legislative leeway, I guess. Um,
Mhm.
Saying like setting the bounds of what Congress can do and say, okay, in these bounds, have at it, go for it, do whatever you want. I don't understand the 14th Amendment to be doing that. Like, it's setting out particular criteria for birthright citizenship, and it just doesn't, it doesn't make a lot of sense to me that Congress would get to modify, in effect modify those criteria by mere legislation. Editing Bailey again, I just wanted to clarify, and come to think of it, I may have been misunderstanding Will slightly on this, but Congress can, of course, grant birthright citizenship to broader categories of people than the 14th Amendment does. The 14th Amendment just sets who must be granted birthright citizenship, not who may be granted birthright citizenship. So, this is why, for example, as was noted in at least Alito's opinion and maybe others, that American citizens born abroad to other American citizens are granted birthright citizenship, even though the 14th Amendment doesn't do that because a child born abroad isn't born or naturalized in the United States. So this is not Congress, in effect, modifying the meaning of a constitutional guarantee by mere statute, but just going above and beyond the Constitution's guarantee, which, at least in this context, it's allowed to do. But yeah, it does sort of, it does sort of bring me to something that I saw some people talking about as a bit of an aside. This was very much a blunder by the administration at best, because yeah, like you said, this has led the Supreme Court of the United States, the highest court in the land, to set the constitutional standard forever and for all time until and unless the Constitution is amended or the Supreme Court overrules itself on birthright citizenship. Whereas before, yeah, maybe you could have squeaked through a little bit of chipping away at things on the edges through legislation. But now, like, no, you tried to ram something through by executive fiat, and the court predictably intervened, and now you're stuck with this standard. Like,
Yeah.
what were you people thinking?
Well,
But,
not to be cynical about it, but I think the administration was thinking that they would get a win here, and
you know,
that was just optimistic at best,
it was not even optimistic.
because
It was,
it's not even it stems back to an issue that I'm sure will come up every single time we meet, which is that and it's because it's not necessarily a partisan issue either. It's that people make predictions about how the court is going to rule based on ideological preference, like political preference, not necessarily based on the kind of jurisprudential or quasi bipartisan values that the court attempts or actually maintains.
Mhm.
I think that if you did a purely jurisprudential analysis of of the of the court's makeup, you would probably reasonably predict a 6-3 or a 7-2 outcome in this case. It was a
Yep.
little bit closer than that, to like as we expressed to our surprise, but this was a foreseeable outcome. Uh,
Right. And like it
Unless you thought that everyone on your side of the aisle was going to vote in your favor, which,
yeah.
like I said, not probable.
And I mean, if this was an 8-1, sorry, if this was an as applied challenge brought by like the child of an illegal immigrant who permanently resides here, intends to permanently reside here, I bet this is an 8-1 with maybe Alito in dissent and Kavanaugh's opinion basically unchanged, him taking like the statutory off ramp. But like, I think the only one that could go either way is maybe Thomas, depending on what he thinks about the illegal immigrant domicile here question. But
Mhm.
it's like 8-1 or 7-2. It's like
Yeah.
there's, and again, like, predictably so. The court's not just gonna engage in some hackery to try and support this crazy effort to set a constitutional standard by executive fiat.
I I really like that, uh, there isn't much to say about Kavanaugh that we haven't already, but I do
Mhm.
really like the I wouldn't call it boldness, but I got some entertainment out of the fact that he explicitly was like, Congress could amend this section, this statute, and then who knows what'll happen.
Yeah. Yeah, I remember reading that, being
It's
like, "I know,
it's
I know what'll happen."
It's very much Kavanaugh's very much like, well, he's staked his ground, so we know where he falls. But
Yeah.
it's an advisement, I think, to Congress and to the administration that, like, listen, if you want to try something like this again, don't do it by executive fiat. Do it by through legislation, and then we'll see where it goes from there.
But Congress
So
can't
this is
do things.
yeah, full stop.
Yeah.
Uh, yeah, so this is not a. I mean, no issue is really ever dead, right? Just the
Mhm.
right circumstances have to come along. But I could see this coming back in another presidential cycle, another 8 years maybe. Um, if the Republican Party takes or takes back, because I assume based on how the pendulum historically swings, I assume they're going to lose Congress. Um, but if they get it back and they have another Republican president who is interested in something like this, then I imagine that the legislative angle is exactly where they're going to go.
Yeah. Uh, one other one other thing I wanted to mention, something you said reminded me of this, uh, about the Thomas's dissent. Yeah, I don't know if this was necessarily the criticism you were making, but it's a criticism I think I should uh address, seeing as, I don't know, I have come to kind of endorse Thomas's dissent, is that there's a lot of reliance on, maybe not reliant, there's some reliance on statements of legislators during like the enactment history or legislative history, whatever you want to call it, of the 14th Amendment, and of the Civil Rights Act of 1866. And, I've been a consistent critic of relying on legislative history. And so I want to address it so, so I don't, I don't know, I guess get accusations of hypocrisy here. I do think like Thomas's reliance, insofar as he relies on these statements by legislators, does run into the regular pitfalls of relying on legislative history. It's not necessarily a reliable indicator of much of anything because Congress is an homogenous body. It's a whole bunch of,
Right.
you can't look at the statements of a few legislators and be like, well, that's what Congress was thinking.
Yeah.
But I don't think that's exactly what Thomas is doing in the way that a lot, or what most proponents of legislative history are doing. Because, like with Jackson, for example, what she's looking to legislative history to do, and she says this explicitly in some of her opinions, is to discern the intent of Congress, the legislative intent of Congress. What were they trying to do with this law? And then from there, that intent is supposed to inform your construction of the law. Like, okay, we're trying to adhere to that intent. So adopt the
Yeah.
construction that's most consistent to that. I think what Thomas is looking to these statements for is is evidence of original public meaning, the same way that you would look to statements in like the Federalist Papers or,
Yeah.
stories, commentaries, or something to discern the original public meaning of, one of the older constitutional provisions. So there is still the regular pitfall of legislative history that's not necessarily reliable, and you need more evidence than that. And I think he gives more evidence than that, but
Yeah.
I don't think
I
he's
think
doing what I've criticized Jackson for doing pretty
no,
extensively.
the purposeful the distinction, I think, is Thomas's purpose for bringing up those discussions was, I think, precisely that, to merely inform how the authors of the amendment were talking about these ideas, the kinds
Mhm.
of context in which they were developing it, not necessarily to establish a definitive understanding uh, uh, of the text qua the text, merely to suggest that there was some kind of shared public meaning to the terms that were being used, that meaning might have been lost with time, and so it's important to look at how these terms were being discussed. Um, it is a meaningful distinction. I think that it's a bit of a spectrum, um, and Thomas rides that a little bit, but he's definitely nowhere near the sort of like legislative intent constitutionalism that Jackson often advocates for. It's more of a casual tool, casual utility, I think, in Thomas's analysis.
Yeah. And yeah, it like I sort of mentioned, he looks to statements of, from a whole bunch of other sources as well, scholars and courts and uh treatises and
Yeah,
etc.
I think this was the longest dissent that he's ever written.
That wouldn't surprise me because it was a long one.
It
Although
was
some
it,
of
it
the
was I gotta say I do not like Thomas's opinions most of the time. This was probably the one that I was easiest able to stomach. I still disagree with it for the most part, but it wasn't. I don't know how to say this except for it wasn't crazy. It wasn't
honestly,
just like
yeah.
weird as fuck. It was just
Yeah, and
it was
what's funny is like my 7-2 prediction from earlier was like, okay, I predict Alito doesn't like birthright citizenship for illegal aliens and temporary visitors, and that was my only basis for thinking Alito would be in dissent. Um, not to imply that he's like a partisan hack. I don't really want to apply that or imply that of any of the justices, but he does seem a little more results oriented than some of the other conservative justices, I guess.
yeah.
Um, and Thomas, I was expecting in dissent, not for the same reasons at all. I was expecting him in dissent because he's got really weird theories of original meaning sometimes, and this struck me as a Thomas is going to do something weird case. And so that's why I was really surprised to see Gorsuch joining his dissent. And when I saw that, I was like, okay, this might have something to it other than or that more than just the weird originalists can latch onto, I guess.
Hmm.
And yeah, like I said, read it and thought it was pretty compelling. There was a lot of repetitiveness though. There were there were two kind of main parts of the opinion. One where he's going through the history and evidence of original meaning and whatnot, and then the other part where he seems to be kind of applying that to the case at hand and addressing the majority's arguments. And so in that second section, there's a lot of repetition of kind of what he said before, which I I don't know. Reading it, I was like, okay, yeah, I know. You said this over the course of like 20 pages already. Can we?
Yeah.
But no, it was very interesting. I guess with that we've covered what the majority, the principal dissent, Kavanaugh's position, and well, I guess not really extensively Alito's position. Uh, Alito was even more restrictive than like Thomas and Gorsuch wanted to be. On his theory, most children of illegal aliens would not meet his test, and his seemed a lot more contrived. Although I did really like his kind of very textualist analysis, very almost mathematical analysis of the text at the start. Like, oh, well, you've got born or naturalized and subject to the jurisdiction thereof. These all have to be doing separate work, so subject to the jurisdiction thereof must mean something that's not inherent in naturalization, and et cetera, et cetera. And it's like, okay, I kind of like that. I like the very bare bones textualist analysis at the start. But
No, yeah, that was probably the only thing that I liked about Alito's opinion. His desire to distinguish Wong Kim arc from this case, I think, was well structured, but ultimately he just wasn't able to get there. This
mhm.
preoccupation with the idea of lawful presence just I think that it was imported into the analysis in order to reach a particular result, and I just don't think there was enough historical or textual basis to get anywhere close to what Alito was advocating for.
Yeah, and it doesn't make any sense to me to tie the meaning of the citizenship clause to lawful presence because that's entirely a statutory question, and as I suggested before, I don't think Congress, I don't think we should read constitutional provisions
Right.
to imply Congress can effectively amend them by statute.
Not to mention, you know, historically, that's a very weird
Yeah.
construct. Like, if you imagine applying that retroactively to the context of American slavery, right? It's like, what does lawfully present mean if you are the descendants of a vast international enterprise of stealing people from their homes and putting them to work f- at no labor cost on land that they have no attachment to. It's like lawful presence. We're really playing with that word, I think.
Yeah. Well, and not to mention, like, the modern scheme of immigration laws is just completely foreign to the time of the ratification of the 14th
Oh
Amendment.
yeah,
Like, yeah, there wasn't this like, "Oh, are you admissible to the United States?" And, just these convoluted, immigration policies, and, you could as I understand it, you could kind of just show up here and make your home here, and whether you were naturalized or not didn't really matter,
pretty
so
much.
much.
Yeah.
Well, and I mean, Wong Kim Ark, right? His parents were lawfully present here, even though, as multiple justices point out, his parents could not be naturalized because Chinese people were just excluded from naturalization categorically.
Yeah. Yeah.
And then I guess, oh yeah, the only other thing I wanted to say about Alito's thing is like he gets really preachy about the illegal immigration issue, and yeah, I don't like justices getting all preachy about policy considerations, especially not in significant chunks of their opinions like Alito did. So that was a little annoying, and yeah, not relevant to the legal analysis. Not that I think he explicitly said it was, but it's just like, why is this here?
Yeah. Kavanaugh avoided that in this case, which I appreciate because his preachiness in the last case that
Mhm.
we read it was
Yeah, Kavanaugh's opinion was one of his more tolerable separate writings. I think a lot of times when he writes separately, it seems he wants to kind of reach out and answer questions that aren't presented, and um yeah, I don't like that tendency of his.
mm-mm.
But yeah, here I didn't agree with the constitutional analysis at all, but it was like, okay, the statutory analysis is really good. The constitutional analysis is, I guess, interesting, whatever. And yeah, he didn't do anything annoying like preach about policy or answer questions not presented. So good on you, Kavanaugh. But
Well done. I will say that, even though at the top of the episode we said that we were gonna just go down the list,
yeah.
we did more or less completely skip over Jackson and Sotomayor's concurrence. So for the purposes of spot treatment, um, we should at least mention, uh, they didn't add anything really substantive, I think, to the
hmm
majority opinion. There was a lot of, I would say, posturing, but I agree with them, so it's like posturing with a positive tone. Um, they the writing was dedicated very much to reinforcing this Douglas-esque narrative of the purpose of the 14th Amendment and the bringing about the justice that was promised to all free and equal Americans, blah blah blah. That vision was finally realized in this way, and that anything less than what the conclusion came to by the majority today, anything less than that would be a betrayal of this tradition, especially within the context of the Black Americans, struggle for for equal rights.
Yeah, I strongly disliked Jackson's opinion. I
I
really
figured you
hated
would.
it. Uh,
It's not a what. Here's the thing: if it was purely literary, I think I'd like it because of its literary value. If it was purely literary, if it was purely just like a an opinion piece written in like a journal or a newspaper or something, I think it would be really good. It doesn't really have a place in the context of a formal opinion, a legal opinion of the Supreme Court of the United States. It is too flowery. It is way too like idea idealistic, ideological. It is not a legal analysis. It
Mhm.
is a social analysis. It is a you know it's something else entirely, and to that end, insofar as that is incompatible with what judges should be doing on the bench, I completely sympathize with it with your distaste of it.
Yeah, and well, and that's one of the things yeah, that was one of the things that I, like, really hated about it. I'm like, "This reads like" I mean, I also just don't think she writes as well as the other justices is another issue, but I'm like, "This reads like" yeah, a journalist or like a, like a student or maybe professor in a, like, critical theory class or something like that. I'm like, "Why is any of this here?" And it's worth noting as well, Sotomayor didn't join most of it. She joined us to the introduction in part 1, um, and then jumped ship for the rest of it. I don't remember I don't remember what the distinction between, like, part 1 and the rest of it really was, but yeah, I don't know. The other issue that I had is, like, she seems to be kind of heavily implying that the position of or Thomas's position at least, would almost return the country to, like, the injustices of, like, the Dred Scott era, and I'm like, "Come on."
Yeah, she more says yeah, the it's she calls it an ultimate irony.
Yeah, and
That
that
that the dissent rejected Dred Scott and yet endorsed Dred Scott's core claim that, quote, "For certain people, being born on American soil will not suffice to confer citizenship." An odious claim that the citizenship clause plainly rejects.
yeah, it just
It's a reductionistic analysis of Dred Scott.
yeah,
Uh,
like,
a-
conflates this it seems to want to sort of import, like, the overtly racist, overtly, like, or overt, like, racial superiority motives, I guess, of, like,
yeah,
Dred Scott and that whole era into the dissent's understanding of the citizenship clause, and, yeah, that is just not actually there.
no, and I agree. Yeah, the Jackson's framing as this pertaining really in any way to Dred Scott is very bad faith. Because as you've expressed, yeah, the cudgel that is the Dred Scott decision, the legal and moral problems with that decision have everything to do with the fact that it was trying to legally reinforce and constitutionalize white supremacy, not that it was trying to distinguish between natural born citizens and not natural born citizens.
Right.
It's like it really doesn't matter in the context of this case, in the context of modern statutory and constitutional analysis. The Dred Scott case is dead letter, and for many reasons other than just new interpretations of the citizenship clause.
Yeah, uh, it is kind of funny, though, as a bit of an aside, Thomas has I don't wanna say approvingly because it's not really approvingly, but Thomas has cited to the Dred Scott decision before. I think it was in Bruin, where basically he cited to the Dred Scott court's, like, dicta saying that, "Oh, well, if black people were citizens, then they would be able to keep and carry arms wherever they went," and he's like, "Oh, see, this is a right of the American people to keep and carry arms wherever you go." And they understood this even in Dred Scott, and they were like, "No, we can't give that to black people." But
That is honestly a very good case. That's a very compelling argument. Yeah, even in the horribly evil racist times of Dred Scott, they were like, "Oh yeah, citizens, black citizens would get guns."
Yeah.
Anyway, all that aside, um, this was a very good case to read. I'm glad that you recommended because we are reading this out of order. Normally,
Mhm.
you do all of your cases sort of as they come, but we're recording this very shortly after the opinion came out.
Yeah. Basically as shortly as possible as we could.
Yeah, and I appreciate that because I would not have bothered to read 190 pages. If not for the fact that I had this social pressure to finish it on this
Exactly, I'm
timetable, but,
forcing
uh
you.
but it was good. Oh, yes, I consented to this. Uh, it was very good, though.
Yeah, no, that's, I guess well, not exactly the same for me because I was planning on reading it no matter what, but, it was very good to read it, while the sort of buzz was still going on about it because, yeah, actually having read the opinions in full, or at least most of them while people were kind of talking about it is like it was really helpful to distinguish like okay who's actually engaging these in good faith and who either hasn't read them or is just ignoring significant chunks of them for motivated reasons because yeah there's a lot of bad faith in the discourse around the court as we've talked about before. I think we pretty comprehensively covered most of what there is to say, unless there's anything else you can think of.
Not to my mind.
With all that said, if I'm asking my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, despite that sometimes it takes a really, really long time to make. Uh, But Patreon members have access to bonus and exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will, I guess, be going back to cover the rest of the Supreme Court's 2025 term. Until then.